kick off day 5 here in another 9 or 10 minutes inside the Hennepin County Courtroom, but we want to bring in our colleague here, Paul Bloom. Paul's been covering this trial since day 1, and Paul, you had the unique perspective yesterday of being one of the media pool reporters inside the courtroom. Give us your perspective of what you saw there yesterday and what happened.
Yeah, Tim, good morning to you. So important for us to get a chance to be inside that courtroom. The camera is obviously only capturing so much. I have to say, sort of the most compelling witness testimony yesterday afternoon, of course, Agent Sam McGinnis with the Bureau of Criminal Apprehension, he getting up to demonstrate the use of the taser, the LED lights, the laser, flashing it on, showing the jury what it looks like to sort of fire up a taser. Of course, the taser at the heart of this alleged mistake. The handgun on Kim Potter's dominant right side, the taser on her off left. How could she make this mistake? As you say, the state says it's manslaughter, first degree, second degree. The defense countering, and we've talked about this now for several days, even now a couple of weeks. Their defense is really a two-pronged defense. One, tragic accident, tragic mistake in the heat of the moment. But two, under the circumstances, given Daunte Wright's behavior and actions trying to flee the arrest, getting back in his vehicle, that she was authorized to use force and deadly force in that moment. And Sergeant Johnson, the third officer at the scene last week, testified to that effect. And now the state is trying to basically put this case back together. They want this jury to get back to this idea that this was manslaughter and something Kim Potter had better control of. And with that, I do want to bring in our legal expert for today, Marsh Hallberg, of course, Hallberg Criminal Defense. Marsh, a familiar face in some of these high-profile cases. He's been an expert legal analyst for me and for the Fox 9 for quite some time. And Marsh, the state kind of getting towards the end of its case. My understanding is just a handful more witnesses. I wouldn't be shocked if the defense has this by, Wednesday, Thursday even. These final couple days for the state, how important is it for the prosecution to really get back to pinning down this man 1, man 2 count so the jury understands why Kim Potter should be held criminally responsible for Daunte Wright's death?
I think any attorney always wants to bring their case home strong, like any situation like this. I think the state came off the strongest with its emotional testimony in the very beginning with the family members. That was kind of heart-wrenching and grabbed everybody's attention. Some of this, it's not real glamorous, but it's extremely important, all the little details. Like yesterday, we talked a lot about just the common sense things. They put up the photo of the taser and the gun, and they have the witness walk through all the obvious differences, the color difference, the weight difference, the serrations on the handle, the length of the handle, all of those types of things. So are kind of obvious to everybody. So yeah, I can look at a picture, I can see those differences, but you want to get that all into the record and be able to argue that at closing. So I don't think there's going to be a big finish to this, a big hurrah, like a lot of times you do, but it's still very important that they fill in all the boxes here.
Here, a question for you regarding the cross-examination by the defense yesterday. Paul Eng, one of the defense team members, specifically asked the BCA agent about some of the similarities between those two weapons, and he pointed out the color because the top of the two weapons are black. And that is what you see when you're actually drawing it and using it at a crime scene like that. How important was that cross-examination, do you think, to their case?
I think it helped. I think the defense is doing a really nice job. Paul Eng is more of a quiet spoken kind of gentleman. Mr. Gray is more energetic, more animated. So I think they make an interesting trial team here, and they complement each other well. They will bring that back. Again, the whole argument is going to be in the heat of the moment. We've known the defense in this case from the beginning. And that is to simply say that I expect a two-pronged defense, as Paul mentioned. But the one main theory is that, look, we're going to have an expert come in and talk to you about this action error, that people in the moment do what they're automatically trained to do, and that's the predominance of always drawing a gun. And then, but that expert is not being allowed to testify as to whether Officer Potter experienced that in her situation. So she has to take the stand to fill in the box and say, yes, that is exactly what happened for me. It was automatic reflex. and I did that. What happened here is that sometimes we attorneys joke about what the gifts that the trial gods give us. And kind of what kind of came out in this case was that the testimony by the one officer, Sergeant Johnson, saying, I would have shot in this situation as well because the use of deadly force is authorized by statute. And by opening that whole issue up, and as I recall, the state, did not object to that question. That came out. That is now before the jury. And it's a whole separate theory that they can now bring forward to say, even if it was a mistake, even if she didn't plan to use her gun, she could have used it anyway. So they now have two different issues to bring home in closing argument.
And Marsh, Paul Bloom again here, and it's interesting, the state basically trying to rehabilitate that point where I think they got beaten up, where their own witness testified that yes, under the situation, Kim Potter was legally authorized to use deadly force. They've since filed a motion to stricken that testimony. I don't know how a judge would ever go back and now take away that testimony. The jury has certainly already heard it. My understanding is we may begin today's session with a couple of motions the state filed yesterday, one of which is to stop any more quote-unquote legal analysis of the deadly force statute like Sergeant Johnson testified to. Now, the state contends that Sergeant Johnson can testify to what he sees, what he perceives. Is he in the driver's compartment? Is he out? Did he feel like his life was in danger? But they just don't want any sort of pronouncements that that was a legal use of force by Kim Potter in that moment. So they're seeking to now stricken that testimony and then also keep anybody else that may come to the witness stand in these final days to allude to the legal statute there. They also have filed a motion to be able to talk about Kim Potter and the fact that she had been union president with the police department at the time of this deadly encounter. They feel it's germane to the situation. I would ask you, I don't know if you've read that full motion, Marsh, but this idea that she's union president at the time, that gives her extra weight with fellow officers who may still testify. Do you think it's germane? Is that a topic the state should be able to probe in the coming days?
I have read the pleadings on that, and I think it is something the state should be able to bring up. They have the right to choose their theory of the defense, and if they want to try to somehow challenge the credibility of law enforcement witnesses in this case to say that somehow there's some blue line code of silence kind of thing support, they have the right to go down that road. And it's already in evidence that Officer Potter was the union rep, so that's already in the record. I think they have the right to say if they think that's a bias, they can do that, because it's going to come out through these other witnesses. How do you know Officer Potter? What was your interaction? And part of that is through the union work. I don't think that's a well-placed position by the state, quite frankly. I think this is a case where we've got everything on the video. We know exactly what happened. This few seconds of the scuffle that went on in the car. We've got the taser getting mistaken and the gun switch happening. And that's the case. And to try to say there's some big cover-up or investigation of other things just doesn't fly here. So I think the judge should let them talk about the union rep issue if they want to. It's already out there. In regards to the other issue about whether the gun taser issue is going to come out, I think we got to wait to see how the judge rules today.
Tim here, we're expecting perhaps some department employees today to talk about use of force policy, maybe a taser policy as well. Give us your thoughts as to how that lays in to the prosecution's case here today and why it's important.
Well, I think what happened yesterday was that the defense to say that the people that testified yesterday really couldn't fill in really what are the policies at this specific police department. There was discussion about how Officer Potter had failed to check her taser at the beginning of each shift many times in the last several weeks. Maybe that's trying to show a sloppiness by her and her cavalierness with her handling of a taser, but they were blocked under some technical kind of foundational issues of not saying, well, how does that apply to this department? So they need to bring it in to tie that testimony from yesterday into today. And we've got the video here showing that demonstration that happened yesterday. I think that was powerful. People really were attentive during that. You see the little green and red dots that come out also to show another indication that taser. So I think that was testimony yesterday that was compelling.
Bring you back into the conversation here because, again, you were in court yesterday and you had the unique perspective of being able to watch Kim Potter as this testimony was going on, particularly as they're talking about the taser here in comparison to the handgun and the demonstration of the taser. What was her reaction during all of this? Was she looking at the jury? Was she looking down? Did you get any kind of read from her at the time?
It's tough reading the defendant from our spot in the courtroom, frankly. We're kind of shielded by several people in front of us. And then at any one time, it is tough. She's wearing a mask. I did not necessarily note where her face or attention was focused as that taser was going on. Because to be honest, Tim, at that moment, I was really focused on the jury, and Marsh nailed it on the head. It's engaging, when a BCA agent gets up. I have to stop there because Judge Chu is entering the courtroom. We don't want to miss any courtroom activity. So we'll get back to this taser discussion, but certainly one I do want to elaborate on what happened in that courtroom. But for now, we'll head into the courtroom as Judge Chu kind of gets herself situated and gets ready to take this bench, her bench, today at Kim Potter's manslaughter trial.
There's something folder for your position. It's a word now.
All right, counsel, I wanted to deal with the two motions that were filed by the state. And one was to admit evidence of bias, the testimony related to union membership, and Officer Potter being a former union president. Mr. Frank, would you like to be heard on that issue?
Yes, Your Honor. Thank you, and good morning. Our motion is, well, let me back up. As you know, the court will instruct the jury that when considering how much weight to assign the testimony of witnesses, one fact that the jurors may consider is the relationship of the parties. And our motion, therefore, or in that vein, is addressed not at union membership, period, or as a whole, or in general. Our motion really has two purposes, but both based within the specific context of this case. So we're not seeking just in general to say people in unions, you should consider their testimony differently. It's the context of this case, Your Honor. And if our motion was not specific in that regard, I apologize, and I'll try to add that precision now. The specific context here is a union that provides services and defense for its members when they are questioned about their job performance. And those are very serious matters. They're often very serious matters, as we know. And so that sort of defense, that assistance, is a little bit different than a lot of unions. This case is about an officer's conduct, and so in the sense that when people worked with Ms. Potter, they felt that as their union rep or president, she had their back. The question is whether witnesses that are still a part of that union or were a part of that union when they knew her might feel like they should have her back. I'm not saying that's true. I'm saying that's a question that the jury should decide based on that evidence. So that's one purpose for that. Not to cast aspersions, of course, on unions or anybody in particular, but it is part of the relationship of those two parties that is tied to the allegations in this case. The second basis upon which this motion is brought relates to a specific witness who we expect to testify, who is currently, as we understand it, working for that union that provides defense. And so we certainly, if that's true, intend to ask him about that, because it would be no different than the defense hiring an investigator to come in and testify to facts. We would put in that they are paid to do that. And so if that witness is going to testify about the conduct, we think we have a right to inquire about that relationship as well. So those are the limited bases upon which we sought to admit that evidence and submit that it is relevant to the issues at hand for the jury's consideration. If they assign it no weight, that's their prerogative.
Okay, here's the problem that I see, and I'll let the defense respond as well, but Officer Potter, former Officer Potter, is no longer connected to the police union in any way. So witnesses that are testifying couldn't possibly be biased to testify in her favor because of her position.
I think the point is that over the years, there was a relationship between Officer Potter and other witnesses who were in the same union that had the same interests. And as I said, it's not just that they worked with her, it's that she had this additional role in defending them and providing services to them. In that sense, they were more than just co-workers. It's a stronger potential bond, and that should be something the jury gets to know about when they're considering the relationship of the witness and the party.
Okay, Mr. Ng.
Well, the evidence is that former Officer Potter was the union rep for 2 years. What is critical here is that they're attempting to show a relationship that doesn't exist. Tim Gannon, the chief, was not in the union whatsoever. Sergeant Johnson wasn't in the union. Acting Chief Grinning wasn't in the union. So there's really no connection. And her role was essentially to negotiate a labor contract, pay and leave and that sort of thing. And it was quite limited. It's not like the Minneapolis police where there's a very powerful union rep that we've read about, for example. So there's no showing of bias, and the individuals they're concerned about weren't in the same union anyway.
Okay. Did you want to respond, Mr.?
Just 2 quick points, Your Honor. Officer Johnson would have been a member of the union until, I think, 2015 when he became a sergeant. And Tim Gannon is currently employed by that union. And he will, as has been represented to us, will come in and offer opinions, thoughts, and so we think it absolutely relevant that he is now employed by the union that also employs legal defense for officers.
All right, I'm going to find that the questions about union membership and Officer Potter's former activities in connection with the union are not relevant to show bias. So I am denying the motion of the state. The second motion the state has is to preclude quote, improper lay opinion testimony. And would you like to briefly be heard on that, counsel?
Yes, Your Honor. Thank you.
Thank you.
Your Honor, the defense had disclosed 2 expert witnesses in this matter, Dr. Miller, the psychologist, with respect to their theory on slip and capture, and Mr. Iams with respect to use of force. What they have done since those disclosures is essentially try to turn other cops into expert witnesses. The court heard from Sergeant Johnson on Friday. Sergeant Johnson testified to issues with respect to use of deadly force, application of a statute, things that are particular legal conclusions that are outside the scope and improper lay opinion. The parties had discussed this with the court sort of beforehand in chambers. It was an issue that we raised. The way that this went down on Friday was extremely prejudicial, but also extremely improper when it comes to the way that lay opinions might be used under 701. Under Rule 701, a lay witness may offer lay opinion testimony on issues that are sort of common everyday occurrences. That does not include things like legal conclusions, things that require particularized or specialized knowledge. They don't, of course, encompass things that are ultimate issues for the jury to decide, including whether or not deadly force is reasonable, whether or not any particular force that was used was reasonable in this case. Those are issues for the jury. Those are issues that are central to this case, not proper for lay witness testimony. Because of the testimony that was heard on Friday, of course, the state has now asked that the court prohibit any further inquiry along those lines and ask the jury to disregard those specific opinions that were outside the scope of any lay witness. The concern as well is that the defense has also provided some disclosures with respect to their anticipated witnesses. That includes former Chief Tim Gannon. It appears that he may also offer similar opinions with respect to whether or not the use of a taser was reasonable, whether or not the use of force was reasonable, his review of video having not been a part of that interaction whatsoever. And it also appears from their disclosures that he may ultimately try to offer opinion with respect to their slip and capture theory, which again would be improper, whether or not she experienced any phenomenon that would be what they're trying to describe as a slip and capture. Your Honor, obviously if we had known that this was where they were going and these questions were coming out to that extent on Friday, it's something we would have raised again in the moment, but of course we are now in a position where they have blown open this door. This was not a question just about what happened on that day and what did you see and what did you do. There were questions about, does this statute apply? When does this statute apply? All of those call for legal conclusions. All of that is improper lay testimony, Your Honor. So we have concerns about what has been done. We'd ask for an instruction that the jury be told to disregard those types of opinions, but we also want to make sure that those are properly limited going forward with respect to the witnesses they intend to call. Thank you, Your Honor.
Your Honor, we object to that motion. We ask that it be denied. It was their witness. I cross-examined the witness. I did not ask about any statute. He's the one that brought up the statute. If they didn't prepare the witness correctly, that's their problem. In addition to that, they never objected at the time. So now they want to redo the testimony that the jury's already heard. It's actually proper lay testimony as far as a witness goes, because his perception is there. He was in the vehicle. He said he was, and he has that's the rationally based perception under Rule 701.
helpful to clear the understanding of the witness's testimony or the determination of the fact and issue? Well, he sure was helpful. He was there, and he gave his opinion as to what Kim Potter did was reasonable. And that's a lay opinion. And it's not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. I'm reading from Rule 701, Your Honor. It's proper evidence. We did not have to give them notice, oh, by the way, we're going to cross-examine your witness with these issues. They should have known that since he's given statements. I didn't pull this out of the clouds. They had taken statements from him that say these things. So we adamantly object. They didn't object last week, and now they want to redo the trial. Thank you.
Okay, Ms. Aldridge.
Thank you, Your Honor. If I may respond briefly to that. When it comes to Rule 701, 701 is a rule that allows for lay witness opinion on matters for which they have personal knowledge. So things like, what did you see? Was the car speeding by as it went by? Things like that. In this case, what the defense has done is asked Sergeant Johnson on Friday, and presumably will ask additional witnesses, to assume and speculate what was in the mind and known to Officer Potter, former Officer Potter, at the time these decisions were made. That is not a personal opinion. That is definitely not a lay opinion, and it's outside the scope of that rule, Your Honor.
All right. Anything further?
Well, Your Honor, they didn't object. I cross-examined the witness. There was no objection at all. There wasn't anything last week.
Okay, first of all, Officer Johnson's opinion, I am not going to tell the jury to disregard. When that issue came up, I ruled that police officers can testify about what they have been trained to do under certain circumstances. There appear the defense, I think the state's motion goes beyond Officer Johnson. They're also trying to preclude any of the police officers that will be testifying in this case from issuing or eliciting opinions concerning whether or not the use of the taser was appropriate under the circumstances. And I believe that the police officers, due to their training, are entitled to render an opinion on that. And it's totally appropriate for them to do that. So I don't know if there were other areas that the state had a problem with respect to expected police officer testimony or not.
Your Honor, we did. It was not just whether or not the taser was appropriate, but there were opinions about whether deadly force would have been appropriate, and also with respect to the psychological components of whether someone would experience things similar to slip and catch.
Okay. There is no question that no witness, including the defense expert witness, can testify that Officer Potter experienced action error or slip and capture. Nobody can say that. But I'm not going to preclude any of the officers from testifying that based upon their training and experience, deadly force or use of taser was appropriate under the circumstances. Okay. Is our counsel ready for the jury?
Judge, may I be excused from that? I forgot my water.
Yes, you may.
Thank you.
All right, thank you, Deputy. Good morning, members of the jury. Please be seated. All right, the state may call its next witness.
The state would call Commander Garrett Flesland to the stand.
All right, officer. Please stand behind the witness chair and raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this matter?
I do.
Have a seat. You may remove your mask. State your full name and spell it.
Garrett Flesland, Garrett
Okay, officer, a couple things to keep in mind. The court reporter is taking down everything that is being said. You have to answer with a yes or a no. Don't shake your head. Don't say uh-huh or uh-uh. Don't talk at the same time as the lawyer asking the question. If an objection is made, stop talking immediately. Don't answer unless I tell you to. And if you need clarification on the question, let the lawyer know. All right? Counsel?
Thank you, Your Honor. Good morning. Can you tell the jurors what your current occupation is?
I'm a police officer for the City of Brooklyn Center.
And what is your current position there?
I'm one of the commanders within the department.
So are you a licensed peace officer in the state of Minnesota?
Yes, sir, I am.
How long have you been licensed?
21 years.
When you, well, just tell the jurors what year it was so we don't have to do the math.
I was licensed in August of 2000.
And when you're licensed, do you have to meet certain requirements in order to get that license?
Yes, sir.
And after getting it, do you have to do certain things to keep it?
Yes, sir.
Does that include training, education, etc.?
A variety of training requirements and continuing education requirements.
And since you got your license, have you done all that was required to maintain your license?
Yes, sir, I have.
Just go into your background a little bit more, if that's all right. Tell the jurors where you went to high school.
Park Center High School in Brooklyn Park.
And after high school, what did you do?
I enlisted in the Navy.
And which, well, let me ask this. How long were you in the Navy?
Total, just about 10 years between active duty as well as I was picked up for an ROTC scholarship. So I went to college in the middle of that.
Okay. And so how many years of active duty?
Just under 6 years.
So when in the 10 did you start the educational or the ROTC component?
I enlisted right after high school in the nuclear power program. After a little over a year, I was selected for ROTC, and that's when I went to college. And then after college and commissioning, then I went back for about 5.5 years of active duty.
So when you went to the college there, did you get a degree?
I did.
What was the degree in?
A Bachelor of Science in Physics.
Was that relevant to your work in the Navy?
Yes.
And so at some point then, when you got out of the Navy, did you have to make a kind of a career choice then?
I did.
What choice did you make?
I decided to pursue law enforcement.
Why?
Grew up with a value and service to others. Felt like it would be a good way to continue to serve the community. Family members are in law enforcement. It seemed like a noble profession to continue.
And not any names or anything like that, but like, how are your family members in law enforcement related to you?
My father was a police officer. My wife is a police officer.
And so how did you then go about pursuing a career in law enforcement?
The state of Minnesota has requirements before you can get licensed as a peace officer. One of the requirements that a lot of people pursue is a 2-year degree in law enforcement or criminal justice. I did not have that. I had a 4-year degree in something other than that. So I needed to obtain a law enforcement certificate. So I went to Alexandria Technical College for roughly 8 months of classes and skills, and that satisfied the post requirement as far as the educational aspect to be eligible for licensing.
And so that was a 2-year degree?
No, that was just a certificate.
Okay. And then do you also have to do like a skills component?
Yes.
Explain that for the jury, would you please?
The program I went through was called the Career Transition. It was for people that had a 4-year degree in something other than law enforcement. It was 1 semester of classes that knocked out a lot of the juvenile law, criminal code, the academics. And then there was a skills portion. I believe it was a 10-week. It was either 8 or 10-week portion, and that's where you do more of the physical aspects of it, learning defensive tactics, handcuffing, there's a driving component, firearms, a variety of more hands-on sort of activities.
Kind of just as it sounds, the skills you need to be a police officer.
Yes, sir.
And did you then, after achieving those things, apply for a job?
I did.
Where did you apply?
I applied several places. One of them was City of Brooklyn Center.
And you got hired there?
Yes, sir.
And that was August of 2000?
Yes, sir.
And what was your first role or position with Brooklyn Center?
I was a patrol officer.
And so out on the streets?
Yes, sir.
What are your duties as a patrol officer, or what were they?
They can be varied, but essentially you're responding to 911 calls for service when people call the police looking for help. When you're not doing that, you're proactively enforcing traffic, interacting with the community and the public, the traditional things you think of when you think of a uniformed officer on the street.
So when you took the job with Brooklyn Center, was it sort of a coming home for you, where you grew up?
More or less. I grew up in Brooklyn Park, right next to Brooklyn Center. I grew up in that community.
And so when you're out there on the streets and doing patrol, are you making arrests?
Yes.
Writing reports?
Yes.
Experience with, well, I'll back up. Did you go through a field training officer portion of your work there?
I did.
How long was the field training officer program when you went through it?
Between 3 and 4 months, probably closer to 4 months.
Are you familiar with the current field training officer program at Brooklyn Center?
I am.
Are they relatively similar?
Very similar.
So you started in 2000. Do you remember the date that you were sworn in?
August 29th of 2000.
And why do you remember that?
It's a significant date. It's when I started this career.
When you're out on, you get your patrol assignment. At some point, you get a promotion to a different position.
Yes.
And when was that?
The first one was in January of 2004. I was promoted to detective.
So as a detective, what did you do?
investigated cases. A lot of times you take a case that was initiated or initially investigated by a patrol officer, and you continue to see it through as far as gathering evidence, eventually potentially presenting it to a prosecuting attorney for review and charging.
And how long did you do that?
A little over 6 years.
Do you specialize in any kind of cases, or just whatever call comes in?
No, we were considered general detectives.
And after that, you said that 6 years, did you receive a promotion then?
Yes, sir.
And what was that promotion?
I was promoted to sergeant.
And can you describe for the jurors, we've heard patrol and sergeant, detective, kind of what the hierarchy is within the Brooklyn Center Police Department?
We've got a chief of police. When we're fully staffed, then we've got 3 commanders and 1 support service manager. The support service manager is a non-sworn position. He or she oversees records and other aspects of just conducting day-to-day business within a department. But then the 3 commanders each oversee a different division. 1 oversees patrol, 1 oversees investigations, and 1 oversees community services.
And so going from detective to sergeant was a promotion sort of in rank?
Yes.
And which area were you the sergeant of?
As a sergeant, I was a patrol sergeant. I was assigned a shift of officers. Throughout most of my tenure as a patrol sergeant, I worked nights, 5:30 at night till 5:30 in the morning. I'd be charged with overseeing and supervising this group of officers as they would go handle 911 calls. They would proactive details, basically carrying out policing throughout the city.
While you were a sergeant, did you pursue some additional education?
I did.
And can you describe that for the jurors, please?
I obtained my master's in police leadership from the University of St. Thomas.
And what year did you achieve that?
2013.
And how was that sort of helpful to your job with Brooklyn Center?
It was a pretty broad program that covered a lot of aspects of police leadership, best practices throughout policing. In some respects, it solidified some of the things that I had learned and discovered over my years, and as well as introduced me to new concepts.
At some point then, did you get another promotion?
Yes, sir.
And when was that?
September of 2015.
What was that promotion?
I was promoted to commander.
And that's where you currently are, your current position?
Yes, sir.
So when you first got promoted, what were your duties as a commander?
I was assigned to patrol, so I was the patrol commander. So I oversaw that position, or that division, which typically consists of 6 patrol sergeants, 26 patrol officers, between 8 and 10 cadets or community service officers, non-sworn positions.
And do you know Kim Potter?
I do.
And how did you get to know Kim Potter?
We were co-workers. She was employed at the police department when I was hired.
How long have you known her?
Since I started working in 2000.
And were there times when you would have been then her supervisor?
There was a few brief periods where I was her sergeant.
Explain why. Or when those periods were, trying to understand why you would have been brief periods as her supervisor.
We end up juggling responsibilities and roles sometimes as people leave. She was a day watch officer for most of the time that I was there. She had a different day watch sergeant. When he retired, we shuffled positions a little bit, and I was the day watch sergeant for a brief period.
So really just as schedules or shifts went?
Yes.
Turning your attention to the investigation of this matter, did you play some role in the follow-up investigation?
Yes.
And were you requested to provide certain documents as part of the investigation?
Yes, sir, I was.
And who requested that assistance?
Bureau of Criminal Apprehension.
And as a commander, are you familiar with sort of the ways that records are stored at the Brooklyn Center Police Department?
Generally, yes.
And how to access them?
Yes.
And were you asked to provide training records relative to Ms. Potter?
Yes, I was.
And were you also asked to provide personnel records with regard to Ms. Potter?
Yes.
And were you able to do that?
Yes.
Either on your own or with the assistance of others, I assume?
I got some of them myself, but primarily I coordinated the efforts of others within the department.
And is it your understanding that the Brooklyn Center Police Department has a record retention policy?
Yes.
And so your department may not have records going back the entire length of Ms. Potter's career?
Correct.
And as well with training records, training or attendance at training is kept track of by the department. Is that true?
Yes.
Is that required by the licensing authority, the post board?
I guess I don't know specifically what post board requires that we submit, but we do have to track whether or not our staff is receiving their continuing education and specific topics.
And does the Brooklyn Center Police Department provide training on its own for its officers?
Yes, we do.
And do you also allow officers to train outside the department?
We do.
Can you just kind of describe what that would be, what kinds of things that might entail? The outside training?
I guess I'm thinking two different things right now. I'm thinking maybe there's an outside vendor that's offering some kind of training that we will send our officers to. And I'm also aware of some of our officers obtaining training on their own. They go to their own class that they pay for and arrange on their own.
Yeah, that's a much better way of explaining what I was trying to ask. So they can go outside the department to get training if they can find the right program or want to do it.
Yes.
But otherwise, you try to provide enough training at Brooklyn Center for the officers to meet their requirements?
We've always provided more than enough training to satisfy the post requirements, yes.
Since becoming a commander, have you had a role in overseeing the provision of training to officers in the department?
Yes.
Can you describe that for the jury, please?
I've had kind of a broad stroke over the training as far as just monitoring that it is taking place, that everyone is satisfying the requirements. I'm not an actual trainer. I've got people that specialize in that and have been trained in that. I really just kind of monitor that it's getting done, that the training we're providing is accurate, is within best practices, continues to evolve as laws change, as technologies change, as experiences change.
Do you supervise those trainers? Does that make sense?
Sure. I oversee. I'm accountable to the chief to make sure that the training takes place and is appropriate.
In that way, in that capacity, do you work with the trainers with regard to the training they're doing?
Yes, not necessarily the nuts and bolts of exactly what's going to take place, but I get an overview of what the plan is, what the objectives are, what the process is going to be, and ultimately I have the final say on if that's what we're going to proceed with or not.
So probably the better question for me to have asked was, do you review lesson plans, materials that are going to be provided for training?
Yes.
And in that capacity, do you interact with the trainers?
Yes.
And do you also have to go through that training?
I do.
So some days you may sit through a training that you already had reviewed to make sure it was a good training.
Yes.
I want to turn your attention now to Brooklyn Center Police Department policies. Does the Brooklyn Center Police Department have a policy manual
We do.
And does that contain specific policies within that manual?
Yes, it's a variety of policies.
Why do you have a variety of policies for police officers?
State law requires that we have certain policies. There's I'll call it a small set of policies that we are mandated to have. I think if you're going to run a business, you need to have a collection of policies. It helps establish standards, it communicates expectations, and when running a business, it really helps drive us towards consistency as far as how our officers are going to carry out their tasks.
And are the officers, are these written policies?
They are.
And are officers required to know them?
Yes.
Are they required to follow them?
Yes.
And how does Brooklyn Center come about having these written policies? Where do they get them from to start?
Our policies have evolved over time. Right now, we use a company, a system called Lexipol. It's a national system, or a national company. I think we transitioned to them spring of 2014-ish. It's a company that's used by, I believe, over 8,000 agencies across the country. They suggest policies for us based on state law, federal law, changes in state or federal law, changes in case law, evolution of best practices, new technologies. And so they're constantly tweaking the policies, and what they do then is provide input or suggestions, recommendations to us. Ultimately, it's our decision what we're going to incorporate, what we're not going to incorporate. Obviously, we incorporate the things that are in compliance with changes in law or best practices. And so that's how we have really moved forward with our policies in the last 6 years.
And so it sounds like, if I can just make sure I understand, you get a standard sort of from Lexipol. You see if it needs to be altered for Brooklyn Center purposes.
Yes, they provide recommendations or changes to our current policy based on changes, a variety of changes, and then we ultimately make the decision what we're going to incorporate, if we're going to change it, if we're going to take it as is. And sometimes it involves a dialogue back and forth with the lawyers and attorneys with Lexipol to make sure that we are establishing the policy that we're comfortable with and is in compliance with a variety of requirements.
And have you been involved in that process of making adjustments to policy?
Yes.
And just, I guess, to help us all out, how do you spell Lexipol?
Lexipol.
And are there, on occasions, changes made to the policies?
Yes.
And is there a way that those changes are recorded by the department, like when they're made?
Yes.
And can you explain that to the jurors, please?
Although we can print out our policy manual, it's, I think last time I checked it was about 700 pages. It's extensive. The primary way we access it through is a web-based portal online where we can go in, review a policy. If there's a new policy or change, it will get a notice sent out to the staff via email. Each staff member has a unique login, username and password. They log in, they'll be able to review that update or change to the policy, and then they acknowledge electronically by a couple of clicks on the computer, and then it's documented. And then in administration, I can go back and audit that at any point to see when policies were released and when they were acknowledged by staff.
So this program keeps track of when the change was put out?
Yes, I'll call it when it was published or when it was released.
And released to whom?
To our department.
Okay. And in what ways are those policy changes communicated to the officers?
They'll always come out via email, a notice, an automated notice by Lexipol, but then we generally will also let everyone know, remind everyone. More significant policies, we'll have sergeants review them with the staff at roll call or at a meeting.
And so does this program then record in some way that if each individual officer has acknowledged the change?
It does.
And how is that done? How do they make that acknowledgement?
One or two boxes they have to click at the bottom of the the policy on the screen.
And they do that remotely from a computer?
From a computer once they've logged in with a unique username and password.
And when there is a new policy change, are they required to acknowledge it?
Yes.
And then expected to know it?
Yes.
Now, you indicated, I believe, that you have access to the program that keeps track of the changes and the acknowledgements by the officers, correct?
Yes, it's the same program. It's just my credentials give me access to different parts of the program that the other staff doesn't have.
And as a part of this case, were you asked to go in and audit the changes to policies and when Officer Potter, at the time, acknowledged them?
I was.
And does that produce then, I'll just call it a spreadsheet of those policies, dates, and dates?
Yes.
And would it assist your testimony today to have a copy of that spreadsheet with you there on the stand?
It would.
And do you have a copy there with you?
I believe I do.
And so, Your Honor, I would ask that the witness be allowed to have that there to refresh his recollection about those specific dates as we go through the individual policies.
You have my permission.
Thank you.
Now, I want to draw your attention to specific policies of the Brooklyn Center Police Department. And so at this time, Your Honor, what I understand is subject to stipulation by the defense. I would offer Exhibit 336.
Okay, 336 is already into evidence, is that correct?
No, Your Honor, I'm saying that defense counsel told us they were stipulating to our exhibits.
Okay. 336 will be in evidence.
And if we can...
If you need
And
to.
Now, I'm going to show you Exhibit 336 on the monitors there. Can you tell us what part of the Brooklyn Center Police Department policy manual this is?
This is one of the first pages that just documents the law enforcement code of ethics.
And why is this the very first page?
It's important to establish standards and expectations.
And the first line, which I will, if I'm technically savvy enough, highlight for you. You see this line here?
Yes.
What does that mean? First of all, read it to the jury if you would and tell us what it means to you as a police officer.
As a law enforcement officer, my fundamental duty is to serve the community.
Why is that there in the first line of the Code of Ethics?
I believe that's the core of what we do, is we serve and protect.
And I want to go down to the second paragraph. The second line starts with, "I will maintain." Can you read that sentence for the jurors, please?
I will maintain courageous calm in the face of danger, scorn, or ridicule, develop self-restraint, and to be constantly mindful of the welfare of others.
Why are those terms there?
It's a difficult job at times, law enforcement, and we need to continue to strive to be our best.
the third paragraph down, it starts with, I will enforce the law courteously and appropriately, without fear or favor, malice or ill will, never employing necessary force or abuse. Why is that in this policy, that language there?
Objective is human, it's obvious why it's there. It's irrelevant. It's the policy. Why it's there is irrelevant.
All right, counsel, are you going to go through this line by line, or?
Some of them, Your Honor, yes, because I don't know if you want me to fully respond, but it is relevant from this commander's perspective and other
Can we
issues.
have a sidebar, please? All right, counsel, you may continue.
So why is it that this unnecessary force language or abuse is right in the Code of Ethics?
Force is significant if we use, and we don't want to use unnecessary force.
In the next line, it talks about the badge of my office as a symbol of public faith. How do you see that fitting in, that language, with your role as a police officer?
I think police officers have an incredibly important role in society. There's statutory requirements or statutory limitations, but I think there is a very special social contract that exists between police officers and the community. Police officers are an extremely forward-facing arm of the government, and it's a special role and relationship we have with society.
You're wearing your badge today, correct?
Yes.
What does it mean when you put that badge on in the morning to you?
It's a reminder that it was given to me by the public to go serve and protect.
The next paragraph down starts with, I know that I am alone responsible for my own standard of professional performance. What does that language mean to you?
I've been trained, I have tools, I have an education, but ultimately I have to go out there and perform well and do my job.
Your Honor, you asked for a standing objection.
May I have a standing objection, which I'm overruling.
And Commander Flesland, as a police officer for the City of Brooklyn Center, are you required to take an oath of office?
Yes.
I'm going to offer formally Exhibit 341 and understand subject to stipulation by defense for its admission.
341 is admitted.
And I will put this up on the screen, Exhibit 341. And Commander Flesland, this indicates upon employment, all employees shall be required to essentially take an oath, correct?
Yes.
Why are officers required to take an oath?
I assume legally there's some kind of requirement there, but I think more important, almost ceremoniously, it's a big deal. It's a special job that we have. And this kind of shows it.
And when you started with the department, did you take an oath?
I did.
I am now going to offer Exhibit 355.
No objection.
And that's been previously stipulated to, and it is in evidence.
And I'll have this put up on the screen for you. Can you see this?
Yes.
And can you describe for the jurors what this is?
It's a copy of the oath that Kim took when on February 27th of 1995.
And when you say Kim, who do you mean?
Kim Potter.
And so it looks like, comparing to the policy, maybe the language of the oath has changed over time.
Yes, our policies have changed and evolved over time.
But that is still this same oath required.
I believe it has the exact same meaning.
Now, this is taken on the first day of employment, correct? This oath?
Typically.
And at a ceremony?
Typically.
And but does the oath, the requirements of what's said in the oath, continue with an officer as they work throughout the department?
Yes.
And have there been changes made to that policy 102 regarding the oath of office?
Yes.
Can you tell the jurors when the last time was that the oath of office policy was revised?
October 31st of 2016.
And can you tell the jurors the last time or the next time that Officer Potter acknowledged receipt of that change?
August 14th of 2017.
When the department is considering hiring new officers, are there certain qualifications that they look for in candidates?
Yes.
And are there certain attributes that the department wants to have in new officers?
Yes.
And are those spelled out in policy as well?
Yes.
That's an expression of those interests that the department has in new candidates?
Yes.
And I'm going to offer Exhibit 349.
Exhibit
We object to that. It's not relevant, Your Honor.
All right. Exhibit 349 is what?
Is the recruitment and selection policy, Your Honor, that counsel told us previously they were stipulating to admission of.
Stipulated the foundations. Only relevant.
All right. The objection is overruled. I'll let you continue. And Exhibit 349 is admitted.
I'm going to draw your attention then to what appears to be the fourth page of the policy. And I'll just draw your attention down, if you could zoom into 1000.3.4, the learning ability. And are these attributes that you want to have in an applicant even to be an officer in the department?
Yes.
And that would include, as it says, the ability to comprehend and retain information,
Yes.
to recall procedures, rules, and regulations,
Yes.
Laws and statutes and codes,
Yes.
to learn and apply what is learned,
Yes.
to apply the material, tactics, and procedures that are required of the position.
Yes.
Going to the next page, judgment under pressure. If you could zoom in a bit on that. You're looking for people with the ability to apply common sense during pressure situations.
Yes.
Why would that be important in a candidate?
Object to that is irrelevant, Your Honor.
The objection is overruled, and you may answer.
I think that's a good quality to have in any employee.
Particularly officers of the law, is that important?
Object to that as leading.
The objection is overruled, and you may answer.
Yes.
And the ability to make effective logical decisions under pressure.
Yes.
Does the department recognize that officers sometimes have to make decisions under pressure?
Yes.
So in dealing with new candidates, it's something the department wants to look for, the ability to do that?
Yes.
This policy 1000 recruitment. Can you tell the jurors when the last time there was a revision to that policy?
August 17th of 2020.
And when did Ms. Potter acknowledge the changes to that policy?
That same day, August 17th of 2020.
So as of August 17th, she was aware of what's in that policy as the jurors have seen it today.
Yes.
And does the Brooklyn Center Police Department expect officers to maintain appropriate conduct when they're on duty?
Yes.
And does the department have a policy on fitness for duty?
Yes.
And I'm going to offer Your Honor Exhibit 351, which is the policy on fitness for duty.
Exhibit 351 will be admitted.
I'll have that put up on the screen, please. And if we can zoom in on the first paragraph at the top. So it says that all officers are required to be free from any physical, emotional, or mental condition that might adversely affect the exercise of peace officer duties. Why is that a part of the fitness for duty?
We want our officers to be in a good place when they're working. We want them to be ready to execute a very difficult job.
When you are working as a peace officer, is that something you think about when you start your shift?
Sure, maybe not real consciously, but there's been days that I've called in sick if I didn't feel like I could do the job.
And can you tell us the most recent version of this that was sent out to officers?
Most recent one of this policy was September 1st of 2015.
And when did then Officer Potter acknowledge receipt of that?
October 7th of 2015.
Are officers expected to conduct themselves in ways that are consistent with the law and with these policies?
Yes.
If they do not, is there a potential for review of their actions and potential administrative or other consequences?
Sure, there's a variety of things that could result from that.
And is there a policy about that as well?
Yes.
Your Honor, I would offer Exhibit 343, which is the conduct policy.
343 will be admitted into evidence.
Put that up, please. I ask you to go to the second page, please. And zoom in on the paragraph that starts with employees. What we just talked about is that contained there in that paragraph that they are expected to follow all applicable laws, ordinances, rules.
Yes.
And would that include policies of the department?
Yes.
And paragraph C, paragraph G, these are circumstances where an officer could face discipline for violations of policy or law.
Yes, there are examples from a lengthy list of things that could.
And C is failure to follow instructions contained in department manuals or city manuals.
Correct.
This policy, 319, the conduct policy, can you tell the jurors last time it was sent out to employees?
September 17th of 2019.
And when did then Officer Potter acknowledge receipt of that?
October 27th of 2019.
Now, you mentioned that police officers have authority to enforce the law, and sometimes the requirement to enforce the law, right?
Yes.
Are they also provided discretion in how they perform their jobs?
Some, yes.
And is that included in the law enforcement authority policy?
Yes.
Your Honor, I would offer Exhibit 340, which is the law enforcement authority policy.
340 will be admitted into evidence.
Can you go to the second page, please? Here the policy is listed, the policy behind this policy is listed at the very end, correct? So if you could scroll down to the bottom.
Yes.
So I'm going to highlight that last paragraph that starts with while. Can you read that to the jurors, please?
While this department recognizes the power of peace officers to make arrests and take other enforcement action, officers are encouraged to use sound discretion in the enforcement of the law. This department does not tolerate abuse of law enforcement authority.
And earlier, in response to my question, you said some discretion. Is that an expression of this within policy that officers are given some discretion?
Yes.
Can you tell the jurors when the last time this policy was sent out to officers?
October 15th of 2019.
And when did then Officer Potter acknowledge it?
October 27th of 2019.
Commander Flesland, police officers are allowed to use of force, correct?
Yes.
And is that regulated, shall we say, somewhat by state statute?
Yes.
And does the department also have a policy on the use of force?
We've got several policies that address use of force.
And the use of force policy in particular, is it to be consistent with state law?
Yes.
And is it intended to comply with state law?
Yes, in some areas I think it may actually be more restrictive than state law, but
And that's something a department can choose to do?
yes.
And so it is, sort of encapsulates state law, but maybe a step further.
Yes.
Your Honor, I would offer Exhibit 333, the use of force policy.
333 will be admitted into evidence.
Ask you to put that up, please. I'm going to draw your attention to the first paragraph of this document. And this is an expression of the basic premise, the reasonable use of force.
Yes.
And it indicates that this policy is guidelines for the reasonable application of force, but also other things like control devices and conducted energy device policies, correct?
Yes.
Now, the jury may already know this, but what is a conducted energy device? Is it a fancy name for something else?
We have a taser that is that device that we use.
So this second paragraph, why does it mention also the control devices and conducted energy device policies?
I think this introduction is trying to get into that there needs to be reasonableness in force that's applied. It also recognizes that I don't believe there is any set of policies that could really address every situation that a peace officer will encounter.
Is the use of a taser a use of force?
Yes.
And so is there a separate taser policy?
There is.
And is this paragraph also, does it indicate whether an officer is supposed to incorporate both of those? Does that make sense? The taser policy and the use of force policy?
Yes, I would almost say that this policy 300 is an overarching umbrella that covers all use of force, and then within our policy manual, we'll get more specific on some of the tools and tactics and techniques.
Okay. And If you would scroll down to the bottom of the page, please. The policy is listed here. Draw your attention to the first line. Use of force is a matter of critical concern both to the public and the law enforcement community. Can you explain, in your mind, why that is a matter of critical concern?
Not many jobs or professions or careers are you authorized and mandated in times to use force. It's a significant reach of the government.
And so that's what's critical about it, right? I mean,
use of force is significant, and it's going to play into any kind of ongoing relationship between the police or the government and the community and society. This, I think, just tries to signal how critical it can be.
The next paragraph talks about officers having an understanding and appreciation for their authority and limitations. Is that true?
Yes.
Why?
We are, peace officers are in a unique role. We've got a unique set of responsibilities, tasks, mandates, and I want our officers to always be aware of that special position, that special job that they have.
And then I would ask you to scroll to the next page. The top paragraph, the policy continues. What is that first line about?
The Brooklyn Center Police Department recognizes and respects the value of all human life and dignity without prejudice to anyone.
And so the second sentence appears to acknowledge the ability to use force.
Vesting officers with the authority to use reasonable force and to protect the public welfare requires monitoring, evaluation, and a careful balancing of all interests.
What interests are being brought up there?
I think essentially all interests. Again, it just speaks to the unique relationship between law enforcement and the community.
Now, I'm not going to spend a lot of time on teaching the application of force with you, but I do want to just touch on a couple areas. So if we could scroll down to 300.3. Fair to say that this is the basic statement about the amount of force that a police officer can use.
Yes.
So in the first line, the amount of force that reasonably appears necessary given the facts and circumstances perceived by the officer at the time to accomplish a legitimate law enforcement purpose.
Yes.
And from there are a lot of other provisions in the policy, but is that the basic explanation?
Yes, that's, I'll call it foundational, is any force used should only be reasonable.
And we see the second paragraph talks about judged from the perspective of a reasonable officer on the scene at the time, correct?
Yes.
And the officers have to make quick decisions sometimes.
Yes.
And in evolving and changing situations, correct?
Yes, the real world changes constantly.
And are your officers expected to take those things into consideration when using force?
We expect them to make good decisions using new information that becomes known to them.
And the third paragraph there, I think the first line is something you've already referred to. It's hard to predict every factual situation, right?
Yes.
But what's the last line of that paragraph?
Officers are entrusted to use well-reasoned discretion in determining the appropriate use of force in each incident.
Now, as long as we're here, please scroll down to 300.3.1. That's an acknowledgement that officers have the authority to make a lawful arrest, correct?
Yes.
And that would include, for instance, on a warrant.
An arrest warrant? Yes.
And if we can scroll down to 300.3.2, this lists the factors that could go into determining the reasonable use of force, correct?
Yes.
And is it your belief that this is consistent with constitutional and state law?
Judge, I object to that. As an opinion on the witness is not qualified to give that opinion.
Okay. Do you want to lay additional foundation, counsel?
Sure. In approving these policies or being part of that process, have you become familiar with the constitutional and state law standards for the factors used to determine reasonable force?
Generally, yes.
And have you also learned those through training?
Yes.
And you've reviewed this policy yourself before today?
Yes.
And are these the kinds of factors that go into determining the reasonableness of force that's used?
I believe so, yes.
And would you expect officers in your department to take these things into consideration in deciding whether to use force or what force to use?
When determining how much force, yes.
And one of those is the immediacy of and severity of a threat to officers.
Yes.
And if you could scroll down, please, to the next page. The seriousness of the suspected offense, another one of those factors.
Yes, sir.
Potential injury to officers, suspects, and others is one of those.
Yes.
Also, the risk and reasonably foreseeable consequences of escape,
Correct.
as well as the apparent need for immediate control of the individual.
Yes.
And if you could scroll down to the next page to 300.4. And does the policy also speak to the use of deadly force?
It does.
And is there also state law describing the use of deadly force?
There is, yes.
Is that in fact actually cited right here in the policy?
Yes.
And so is it your belief that the policy here is consistent with state law?
Yes.
Just below that is a provision on moving vehicles, correct?
Correct.
And why does the use of force policy have a separate section on moving vehicles?
I guess I can't specifically say why it's in this policy and not another policy, but when we look more at 300.4, you're going to see some reference to deadly force.
Okay, so let's go down to the next page and explain to the jury what you mean.
We wanted to articulate here that shooting at a moving vehicle or from a moving vehicle is significant. When, as the policy outlines, when feasible, officers should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their vehicle at a vehicle or any of its occupants. An officer should only discharge a firearm at a moving vehicle or its occupants when the officer reasonably believes there are no other reasonable means available to avert the imminent threat of the vehicle or of deadly force other than the vehicle is directed at the officer or others. We want to discourage officers from being in a position where they could be struck by a moving vehicle, but yet we never want to take away the ability for an officer to defend him or herself or another.
Why do you want to discourage shooting at the occupants of a vehicle? Of a moving vehicle?
Moving vehicle is what we're talking about.
Okay. All right. Excuse me. Mr. Gray, would you please ask to have a sidebar instead of doing talking objections? All you have to do is ask sidebar, and I'll do that. Are you done? I think he corrected himself. and he now, Mr. Frank, you are corrected, correct?
I don't know if the court heard me, but while he was objecting, I was correcting myself, attempting to. So my question is, why do you want to discourage shooting at occupants of a moving vehicle?
If it's to stop the vehicle, my understanding is that's rarely effective.
If you were to injure in some way by shooting the driver of the vehicle, what could happen?
A variety of things could happen.
Like what?
Judge, I object to this as well under Rule 403.
The objection is overruled.
The vehicle could strike something or somebody.
I'm going to ask to scroll down to 300.8. Does the policy speak to training?
Yes.
And does it require that officers be trained on the use of force policies and law?
It does.
And how often do they have to be trained on that?
At least annually.
And do you believe that that happens at the Brooklyn Center Police Department?
Yes.
This use of force policy, can you tell the jurors when the last time it was sent out to officers?
December 8th of 2020.
And the last time that then Officer Potter acknowledged it?
December 29th of 2020.
Separate from use of force, is there a separate policy on firearms?
There is, yes.
And I'm going to offer Exhibit 306, Your Honor, which is the policy on firearms.
306 will be
And, oops, my mistake. I got the wrong exhibit number. 342, I'm sorry.
342 will be
Admitted.
It's policy 306, correct? Do officers carry a firearm every day when they're on the job?
Unless they're on light duty or some kind of administrative detail.
Yeah, I should have been more specific. When they go out on the street, do they carry a firearm?
Yes.
And so this policy, drawing your attention to the 306.1.1, so they are required to complete departmental training regarding the use of force and deadly force and firearms before being authorized to do that, to carry it every day, correct?
Yes.
And does your department provide that training?
Yes.
And how often is firearms training provided?
Ideally quarterly. At a minimum, everyone will qualify with their firearms once a year, and then we try and incorporate additional firearms-related training throughout the year.
And when you say qualify, what does that mean?
There's a course of fire, specific distances, some time frames, some positions and orientations you're shooting from. It's a qualification. It's a pass or fail evolution.
So officers are required to fire their firearms?
Yes.
And at least annually?
Yes.
And that means having them in their holster and drawing them and using them?
Yes.
And they're, I don't want to say graded, that seems a little elementary, but
they're evaluated.
And if we could scroll down to 306.5. Draw your attention to the first line of that paragraph or that section. What does it say?
Members shall not unnecessarily display or handle any firearm.
And I actually meant the sentence before that first, but
Members shall maintain the highest level of safety when handling firearms and shall consider the following.
and then not to unnecessarily display or handle. Correct?
Yes.
As one of many reasons, but you expect officers to have the highest level of safety?
Yes.
Is that part of firearms training and how to safely handle firearms?
Yes.
We see a lot of references in the training to low light training. Can you describe for the jury what that means?
When low light is referenced in the policies, it's getting at either at night or maybe in a building without lights on, basically in the dark. Post mandates are part of the annual firearms qualification, also includes some training in low light and inclement weather.
The reality of police work, right?
Especially in Minnesota, yes.
Yes. So that's all part of the firearms training, those differing conditions.
Yes.
And can you tell the jurors when the last time this firearms policy was sent out to officers?
September 7th of 2017.
And when did then Officer Potter acknowledge it?
October 9th of 2017.
Has the department incorporated a policy on vehicle pursuits?
Yes.
And just to, can you basically describe what's covered by the vehicle pursuit policy? What kind of conduct are we talking about?
When officers may engage in pursuing a vehicle, a car chase, what types of situations that could be warranted and authorized in, what types of situations it's not. It goes into a variety of factors that we ask the officers to constantly reevaluate during the course of a pursuit on whether or not it should be continued or not. And it gets into some tactics.
Your Honor, I would offer Exhibit 338, which is the vehicle pursuit policy.
338 will be admitted into evidence.
I'm going to draw your attention to the second paragraph, the philosophy paragraph. You see the second line starts with a sentence with "in recognizing." Can you describe for the jurors that language there?
In recognizing the risk to public safety created by vehicle pursuits, no officer or supervisor shall be criticized or disciplined for deciding not to engage in a vehicle pursuit or for terminating a pursuit already underway, even if permitted by state statute and department policy.
Sounds like that's giving officers some protection. They're not going to be judged later if they terminate a pursuit.
We want to take away any kind of unnecessary pressure that the officer might feel if they are making a decision that a pursuit is maybe too dangerous for them to continue.
On the second page, the policy addresses when to initiate. At number 1, and then the next page there's a number 2, correct?
Yes.
And to initiate a pursuit, there is in number 1 a list of crimes that officers in your department are authorized to initiate a pursuit for, correct?
Yes.
And do any of those include a gross misdemeanor warrant?
Not these probable cause crimes, no.
Now, if we go to number 2 on the next page, there is another provision for initiating, and what is required under that provision to initiate a vehicle pursuit?
The pursuing officer or officers have reason to believe that there is an imminent safety risk to the public or an officer if the driver or one of the occupants of the vehicle is not immediately apprehended.
So those are the sort of two bases upon which an officer could initiate pursuit?
Yes.
A little farther down on that page, 307.6, factors in initiating or continuing a pursuit. So these are things officers are expected to consider, correct?
Yes, these are some of the things that they should be evaluating throughout a pursuit.
Or even initiating a pursuit.
Or even before a pursuit is initiated, yes.
In paragraph F, one of those is the ability of the officer to identify the driver at a later time.
Yes.
At the very bottom of that page starts the section on terminating a pursuit, correct?
Yes.
And one of those factors is in paragraph C, the identity of the offender is known and delaying apprehension does not create a known and substantial risk of injury or death to another?
Yes, that's a possible factor to consider.
Can you tell the jurors when the last time was that this policy was sent out to the officers?
March 11th of 2021.
And when was then Officer Potter, when did she acknowledge it?
April 6th of 2021.
Now, this is news to me, but is there actually a policy on foot pursuits even?
We do have one, yes.
Why is there a separate section on foot pursuits?
It's a significant event for an officer to participate in. Although there are some overlaps as far as concepts and thought processes with vehicle pursuits, there's also some unique aspects to foot pursuits as opposed to vehicle pursuits.
Your Honor, I would offer Exhibit 346, which is Policy 425, the foot pursuit policy. This would be irrelevant.
346 will be admitted over defense of protection.
Put that up, please. And drawing your attention to the second paragraph under the policy, there is language here about absent exigent circumstances. Safety of the officers and the public should be primary consideration when determining whether a foot pursuit should be initiated or continued, correct?
Yes.
Now, what does that last line say?
Officers must be mindful that immediate apprehension of a suspect is rarely more important than the safety of the public and department personnel.
So again, here is a balancing of interests in deciding whether to initiate or pursue a foot pursuit?
Yes, another example of the risk-reward analysis that our officers must make frequently.
And if we go down to the bottom of that page, sentence that starts with, if circumstances reasonably permit, what are some other options besides a foot pursuit that an officer can do, basically drawing your attention to the first line there of that paragraph?
Containment of the area.
So surveillance means what?
Surveillance, setting up a perimeter, saturating the area with peace officers to try and locate the individual or individuals.
And then on the next page is paragraph E. And what does this paragraph speak to?
Apprehension at another time when the identity of the suspect is known or there's information available that would likely allow for later apprehension and the need to immediately apprehend the suspect does not reasonably appear to outweigh the risk of continuing the pursuit. It's getting at another approach you could take in response to someone fleeing on foot.
Can you tell the jurors when the last time is that this policy was sent out to officers?
September 1st of 2015.
And when did Officer Potter acknowledge it?
October 12th of 2015.
Members of the jury?
We're going to take a 20-minute break, okay?
Can I just leave this stuff here?
Yes, you may. All right, Counsel, we should probably talk about this Blakely issue, whether it's going to be a unitary proceeding or a bifurcated proceeding. I know we're getting ahead of ourselves again because the Blakely would not come up unless there were a guilty verdict, but I think we should discuss this now because it might impact what evidence goes in as we go forward.
Yes, it's our position.
Oh, could you put your microphone, maybe switch places with, no, why don't you go to the podium, Mr. Gray?
Your Honor, it's our position that we did not agree to try the Blakely issue along with the jury trial. Neither did our client. If Mr. Prosecution thinks that we did, we didn't, and I don't think there's any record of us ever doing that. In order to do that, we would have to first get permission of our client. What I understood was that if we would lose the jury trial, after the jury trial, we would have a bifurcated trial with the court and let the court decide the Blakely issues. I would never agree to combine both of them. That was my understanding, and I believe it was Mr. Ames and our client. Thank you.
Your Honor, we absolutely did discuss this in chambers with counsel. We did talk about leaving the determination of the Blakely issues to the court rather than the jury. Counsel indicated that their client would agree to that. Not a huge, real surprise to anybody that does this. And then we talked about still having a unitary trial, not a bifurcated trial. And it was agreed to by everybody in the room. Now, Ms. Potter, of course, was not in the room at that time, but her attorneys represented at that time that they would not be requesting a bifurcated trial, that we were going to have a unitary trial. And you know, I'm a little bit concerned that counsel is now saying on the record, absolutely, we did not agree to that, because we did agree to it. It was discussed and agreed to. Now, having said all of that, again, as I said this morning, this evidence disputed today is going to come in for two purposes, the Blakely purpose as well as the fact that it's relevant to Ms. Potter's job then as a police officer, and that goes to her awareness. But additionally, Your Honor, we had a real brief discussion, is my recollection, about the recognition that the Blakely only evidence would be very minimal, that most of the evidence for the Blakely factors would be relevant to the guilt factor, or the guilt issues anyway. And so practically there would be no need, or very little need, for a bifurcated trial. And so we do need to make a record that Ms. Potter is waiving her jury rights to the Blakely factors if they are going to stay with that position. But I firmly recall saying to the court that we would have then a unitary and not a bifurcated trial and that was agreed to. That's the way we've proceeded with the proof in this case. And really, I think, as we talked the other day, just a little bit about the injuries to the other people down the street, there's been very little Blakely only information anyway, if really even at all.
All right. I think everybody has kind of a different recollection. I'll tell you mine. I remember the issue coming up. I remember the defense saying that they wanted me to decide the Blakely issues. I don't recall that we went into any detailed discussion whether it would be a unitary or a bifurcated proceeding. I specifically do recall that a unitary trial on both was not agreed to. I don't think we discussed it at all. And I think counsel has a different memory of it. But my recollection is that we didn't discuss unitary versus bifurcated.
As a prosecutor, we are very sensitive about Blakely issues. I mean, we know this is something that has to be handled. It's in the rules, unitary or bifurcated. So with all due respect, I do specifically remember bringing up whether it be unitary or bifurcated, and we talked about it being unitary because there would be so little evidence, really, if any. Now, if you really recall last week, after some testimony about the crash afterwards, this came up, and we discussed it then about there being a unitary trial, and this claim that counsel's trying to set up now that there's some error here wasn't brought up then. It was discussed that we were having a unitary trial on it, and that's how it was to go forward. Now, I want to add to the court, I think that really, I think almost all of the evidence has been admissible on both issues anyway. So there is no prejudice from not having a bifurcated trial so far.
Okay, I don't think there has been any prejudice so far because the second crash relates to reasonable use of force with the taser in a allegedly moving vehicle. So I don't think there's been any prejudice, but what I think we need, I don't think it matters what our respective recollections are anymore, because what is critical is Officer Potter was not in chambers with us. There was never a record made of her agreement to have a unitary trial. The defense is now saying Officer Potter does not want that, so we're going to go with that. We're not going to have a unitary trial on Blakely and the main issues. Okay? So,
Your Honor, one of the reasons that Ms. Potter never spoke to it is because she was never required to come to court. We never had the ability to make a record with her here until the first day of trial. Because we did want to make that record. She wasn't here. So, but my understanding of the court's ruling is I'm going to try my case the same. If counsel feels that there's no doubt they will object if they feel something is Blakely evidence, we'll have to just dispute it at that point, I guess. But my understanding is you're not going backwards and striking any testimony or finding that there has been any prejudicial testimony presented so far.
I don't see any. Why don't we do this right now, just so we have a clear record? Counsel, could you deal with the Blakely issue and your client's wishes on that issue for the record?
Yes, I know.
And Mr. Gray, could you put that microphone near your mouth because the court reporter has been having difficulty?
Yes.
Okay, and Mr. Ng, could you put the microphone closer to your client? And you've got a microphone too. Mr. Ng, there's another microphone sitting right there. Okay. All right.
Your Honor, we do not intend to have one trial. If our client is convicted, we would want a bifurcated trial and try the Blakely issues after the factual issues in the trial. And we've never, ever discussed with our client about waiving that. I don't believe that anything was discussed in the chambers about this issue. We said we would try it to the court after the case is tried, which I assume would be a bifurcated trial. In any event, our client wasn't there ever, and she will not waive any right not to have a bifurcated trial.
Okay. And just to be clear, should there be guilty verdicts in this case, that issue will be submitted to me. And therefore, there won't be any evidence pertaining to Blakely during the main trial here. Okay.
I'm sorry.
Yes.
Ms. Potter needs to do a jury trial waiver of her Blakely issues. A formal waiver needs to be done on the record, and now we have learned the hard way why, but that still needs to be done. She needs to waive the jury trial and Blakely issues and decide on a bifurcated process.
Okay. Ms. Potter, let me find her. There are two Blakely issues that the state has submitted, and the two Blakely issues are that defendant's conduct caused a greater than normal danger to the safety of other people as she fired into a motor vehicle in which a passenger was present and two other officers were in close proximity while the vehicle was operational on a busy public street. After defendant fired, the vehicle traveled down the street and struck an unoccupied vehicle heading in the opposite direction. That's the first alleged Blakely factor. The second one is that defendant abused her position of authority as she was a licensed police officer in full uniform who had seized Mr. Wright. And I'm sure that your attorneys have explained to you what Blakely is all about, but those issues would not be an issue at all if you were found not guilty of either charge. If you were found guilty of one or two of the charges, your attorneys have indicated that they want me to decide whether these aggravating factors exist. The aggravating factors generally would allow me to impose a more severe sentence. Now, you have the right to have a jury decide the existence of these aggravating factors. You have the right to call witnesses. You have the right to cross-examine any witnesses that the state would call. And I suppose you'd have the right to testify, too, if you wanted to, on those issues. You'd be represented by counsel. And the jury would have to find beyond a reasonable doubt that these factors existed. And the burden would be on the state. Is it your wish to give up your right to a jury trial on whether or not the two Blakely factors exist in the event of a guilty verdict?
Yes, Your Honor.
Okay. Counsel, do you have additional questions on the waiver?
No.
Okay. Does the state have additional questions on the waiver?
Yeah, I would just ask the court, or I could ask if the defendant if you want, but to acknowledge that she has discussed this with her attorneys. She's had a sufficient amount of time to discuss it, and she doesn't need any more time today before making this waiver on the record.
Okay. You've had time to discuss this, right, with your lawyers?
Yep.
Do you need more time to think about it? Okay. All right. Okay, counsel, let's take a 15-minute break. Okay. Sorry. Okay.
Well, hello everyone. Tim Blotz in the Fox 9 newsroom, welcoming you to our streaming coverage of the trial against Kimberly Potter in the matter of the death of Daunte Wright. Some legal issues going on here at the end of the break here for the morning session, and we want to bring in our Marsh Hallberg right away, a criminal defense attorney here in town from Hallberg Criminal Defense. And Marsh, I want you to be a legal professor for us, if we could, here right now, and explain what just transpired. And I think we should really start with the Blakely issue and explain what the Blakely issue is, and then we'll get into why this is relevant and important.
That was a kind of interesting development at the end, wasn't it? You got to step back. So what Minnesota has is the Minnesota Sentencing Guidelines, which most states now have. And that's a mathematical calculation that people should be treated the same. There shouldn't be factors that could go to how wealthy you are, or your race, or other factors. So the good intentions behind these guidelines was to say that when a specific crime is you're convicted of a specific crime, you look at that and your prior criminal history score, and those two main factors are then used to calculate a number range within which you're supposed to be sentenced. It's a guideline. It's discretionary. A judge can go up, a judge can go down from that number, but it's a guideline range. The state, however, prior to trial, can file what's called a Blakely motion. That's based upon a case, and that's basically saying that the state can say, Judge, if we are successful in convicting this defendant, we are going to ask you to do more than what the guidelines suggest. And there are certain factors that we think you should consider in saying, no, this isn't your average garden variety type crime. There's more to this case than happens in others. And different cases have different kind of factors. In this case, the state has said there are two factors, and they actually give a written notice to the defense to say that if you are convicted, we are going to argue that these couple of factors should make your sentence more serious. And those factors in this case were the public safety issue of shooting at this car and it caused this other accident, shooting inside this car caused the other accident. And there's also the breach of trust. We saw the testimony from this witness about the oath of office and their obligation to have public safety, protect and serve. So those are the two factors. But what it requires is those are fact questions. Did those things occur? Was there an endangerment of public safety? Was this a breach of her public oath, of her position of authority? Those are fact questions, and a defendant has the right to have facts decided by a jury, just like it does all the other facts in a case. So a defendant has the right to have a jury decide whether someone is actually factually guilty of these aggravating factors. So the defendant has to decide, if I am convicted, do I want a judge to decide these factors, or do I want a jury to decide these factors? If it's not in play, really, what those issues are, or it's too prejudicial, it's good tactics by the defense, which they are doing here, to say, Judge, we are going to let you decide whether the Blakely factors apply. So if this Potter is convicted, we are going to have you decide whether, in fact, these occur, so that then the jury doesn't have to hear a lot of these prejudicial things that might otherwise come out. In this case, again, it's always important to keep things where everybody's fighting here now what was said or wasn't said in chambers. and the understanding of everybody.
All right. Marsh, we're having some difficulty with your bandwidth here. We're going to try and reestablish the connection here. In the meantime, I'm going to bring in Paul Bloom to talk more about the testimony here today, because there were a couple of important rulings on motions as things were getting underway here today, Paul. And a lot of this had to do with use of force. And could certain witnesses here be questioned on their opinions regarding police use of force in this case? And this all goes back to former Sergeant Johnson's testimony on Friday, when during cross-examination and Earl asked him whether it would be authorized under the use of force policy for Kim Potter to use her gun in that incident, and he said yes, it would, under the instance of protecting a fellow officer's life. Correct, Paul?
Well, a couple things. One, I just want to jump off. I know Marsh got cut off because of bandwidth. The other issue is they talk about Blakely and its impact, and if there is a guilty conviction, that the state could seek an enhanced or upward departure at sentencing, was the idea that it is a bifurcated situation. So what the defense wants basically is to complete this trial, and if she is found guilty, then basically have a second trial now with the judge where the rest of the evidence would come in. You heard the state say there's not really much additional evidence. They've already talked about the car crash that subsequently occurred after Daunte Wright is shot and the car gets away. So again, the idea that the state seemed frustrated that they had an agreement or an understanding in chambers that it would all sort of be done at one time, unity at one time during the trial. But now apparently Kim Potter there saying she wants it bifurcated, which would separate the two proceedings, and there would be almost a mini trial afterwards. Now, as for the two motions this morning, an interesting development from the state. They went 0 for 2, let's be frank. They had two motions before this judge. One, let's get out of the way, the union membership. As you see the commander today testifying, he and Kim Potter once upon a time were in the same union. The state wants the opportunity to probe on the union issue. Potter was the president of the union in Brooklyn Center, and her role there might have some influence over some of these people, and they want a chance to sort of probe potential biases based on her role as union president. Again, very much getting away from the recklessness, the culpable negligence at the scene, but the judge did reject the state's motion, so don't expect any union testimony, if you will. And then the second matter is this idea that the state just does not want police officers getting up on the stand in uniform, as this Commander Flesland is. Now, he's their witness, so perhaps better prepared today. But they don't want them opining legally. The idea is they can talk about what they saw, what they see, what they know, what the training is, but they can't make a conclusion that by legal state statute, Kim Potter was authorized to use force in that moment. That's exactly what Sergeant Johnson volunteered last week. You heard Earl Gray say that Sergeant Johnson brought it up. It wasn't their attempt to elicit a legal response. The state believes the idea of a state statute, whether use of force is legally justified, should only be provided by experts, not officers in the field. But you heard there the state lost this motion. So, in fact, police officers, if asked and appropriately qualified, will be allowed to opine about whether or not state statute would dictate the use of force. Again, getting to this two-pronged defense approach here, that not only is this an innocent mistake, not only is it an innocent accident, if you will, a heat of the moment error, human error, but there's this idea that Kim Potter was authorized to use force and lethal force in that situation, given the risk to the two officers at the scene and this fleeing suspect wanted on a weapons and outstanding gross misdemeanor weapons violation and having an order for protection against a woman who they don't know the identity of, and there's a woman in that car. So you take the totality of this situation. Sergeant Johnson said Potter was legally authorized by state statute to shoot, to use deadly force. The state, although it was their witness and they didn't object in that moment, now wanted no more officers to opine about that, but you heard the judge cut them down at their legs there, and they will be allowed to answer that type of question moving forward. And as we get into these sort of expert police officer use of force expertise, I think that ruling becomes a bigger and bigger issue as this trial winds down.
Perhaps. In fact, Judge Chu here today, I wrote down her quotes in her comments. She said, quote, "This was Officer Johnson's opinion. I'm not going to tell the jury to disregard." And as she elaborated a little more, she said, quote, "I believe that the police officers, due to their training, would be able to offer that opinion on that." And that's when she was talking about the questioning by Earl Gray. And she then added, quote, "It's appropriate for them to do that." And then she later added, "I'm not going to preclude any officer from testifying." So it was clear from the judge today that she wasn't going to go down that road, and she certainly was not going to go back to the jury and say, "Remember that conversation with Earl Gray from last Friday about whether use of force would have been authorized? I want you to forget that now." She clearly said she wasn't going to go there on this particular matter. Okay, I think we've got a clear connection now with Marsh Hallberg. Marsh, we apologize about that. We could hear you before, we just could not see you. So thanks for rejoining us here. We deeply appreciate it. We kind of left off with the whole Blakely matter here. And while we're reestablishing connection here, I think Paul gave a great explanation as to why this is important going forward, and how the state had assumed that this was going to be a unitary trial, and it's now going to be a bifurcated trial where we will have a separate proceedings after the jury renders guilt or not guilty verdicts here. But in this case, I'm curious, Marsh, why wasn't this on the record with the judge and the attorneys before this trial started? And I realize there's a lot of conversations that go on in chambers, but this seems to me to be kind of important. Why didn't this not get on the record?
It should have, right? I mean, and clearly it's really important to have a waiver of the issue on Blakely with the defendant, and usually you do that right on the very first day. And to have not done that, I think was oops. Yeah, it was a mistake by everybody. I think the state tried to cover that a little by saying, hinting or saying, "Judge, you were always saying that Officer Potter didn't have to be at some of these prior hearings, so it's kind of that's not on us because she wasn't physically here to do that." But they should have done that earlier in this case.
It's a matter of as a matter of purpose here in practice, I guess I should say, educate us a little bit on this, Marsh. How much of those conversations are on the record between the judge and attorneys when they're meeting in chambers?
Not a lot. A lot of times it's just everybody's an officer of the court. It means they're all bound to be honest and truthful. And if other attorneys have different memories of those events, or even if they agreed, they would step up and say that, and you'd expect that to happen. So a lot of this is just routine. But the major things like a waiver of Blakely, judge or jury, that should be on the record. You do that early. Whether it's going to be a bifurcated trial or a unified trial, that's done early, and that's clearly put on the record somehow, or email or text exchange or something to document that. So that should have been done.
And Marsh, how could this possibly affect the prosecution going forward? We heard Matt Frank there said this dramatically affects how they prepared for this case.
Right, because they plan to put their whole case in through certain witnesses and just have all the facts come out. Now they have to pick and choose. They're going to have to cut out things that are only Blakely issue. Their position is going to be that most of the things that would come in for Blakely come in anyway. The fact that there was another car accident, that other people were hurt, that there's this oath of office that came in through the witness we saw today. A lot of those are all Blakely issues anyway. So, and the judge made it really clear that she's feeling there's no prejudice now, because if there was, they'd be stopping this case and doing a do-over right now, but they don't. So they are just going to have to be very careful with their witnesses and talk to them before they put witnesses on the stand to say, we're not going into these topic areas now. Don't talk about such and such unless I specifically ask you a point-blank question on that issue.
And Marsh, Paul Bloom again joining the conversation. A couple quick thoughts on that and what we heard during those arguments. Sort of this reference to not having Potter in court or on the record opportunity to waive this Blakely motion. her desire not to have it heard by the jury almost sounded pandemic related, that they haven't had the parties together. I thought that was just sort of interesting that, Potter hasn't been required. I know there have only been 1 or 2 hearings, some on the record done via Zoom, certainly not in chambers. So they haven't had the opportunity to do that. I think that speaks to sort of the unique moment in time where we're at. And the judge read back the 2 factors as why the state would be seeking the upward departure. And again, you mentioned the crash, the additional risk people were put at because of the fleeing car, and then obviously the grave injuries that were suffered by the elderly gentleman in the crash. So, I mean, I don't see clearly where the state would have trouble moving forward and separating quote unquote Blakely matters from the rest of their prosecution. The second factor being defendant abused her position of authority as she was a licensed police officer in full uniform who had seized Daunte Wright. I think that's pretty well established. But again, we're talking potential aggravated sentencing, upward departures, but that, of course, only if there is a guilty verdict. The one thing, Marsh, I did want to get you to comment on is that the state seems awfully frustrated here. Just they feel they had an agreement in chambers. They did not. Yesterday, I was in court. They wanted to give the jury the taser to physically hold and feel it, and they thought they had an agreement to do that, and it was stopped short. In fact, the deputy was basically 2-3 steps across the room to take the sample taser and bring it to the jury, and then the defense objects. They were frustrated this morning losing this motion on Sergeant Johnson's and his sort of legal analysis of deadly use of force last week. I just feel that the state right now is flummoxed, is frustrated. Maybe some things haven't gone their way as this case has started. Are you seeing that? Are you sensing that? Would you comment on that?
I have, Paul, and I think that's a good observation. This isn't trying to be one-sided. Although I'm a defense attorney now, I was a prosecutor for 26 years full-time, most of it in Hennepin County. So I think the point is, in any trial, you can't plan on things going the way you think they're going to. You have a general game plan, you have a general roadmap, but things are going to change through that course of the trial. So you do as much as you can planning-wise to minimize those unknowns. I'm not sure that happened here. Through this whole case, I kind of felt the state has not been as solid as they've been in other cases. I thought the opening statement was way too long. It was at least an hour long. I think the defense was a half hour. It just, I thought, bogged down in the beginning. Letting the horse out of the barn by allowing the testimony last week on the reasonable use of deadly force was a big mistake by the state. It's now opened that whole door, and they're going to ram through that with more officers probably opining on that, both whether it's a taser or that. All these other little nuances about structurally how it happens. Juries pick up on that. Paul, you've done a lot of trials. You've been in a lot of courtrooms. And you're sitting really close generally. I know we've got the screens in place here and everything else, but juries pick up on the nuances of confusion and mismanagement.
And Marsh, again, Paul Bloom, continuing with this conversation, the jury, obviously they're sensing it. I took a question on social media this morning, like, when are, Potter is not charged with violating department policy, yet we're reading through every oath, the exact language on her oath, the policy of foot pursuits. I just think the state is bringing a very wide approach to this case. Where is the heart of the 12 or 13 seconds and the mistake they've made? Where do they see manslaughter in the first degree? Where do they see manslaughter in the second degree? Where is this testimony?
If I had been at the defense counsel, I probably would have passed my co-counsel a note that said yawn or something during the morning, because, again, they chose to put all of the stuff in that there's no argument that there was a horrible mistake here, Mary. Of course she takes an oath to protect and serve. Of course she does other things to try to be the best officer she can be. But that's not what the defense is about here. And the state is, I think, way too far, way too wide in their approach.
And Marsh, I'm going to cut you off there. Thank you for this conversation. We'll see you at lunch. Let's get our viewers back into the courtroom. Judge Regina Chu is on the bench. I did see Commander Flesland walk back up on the witness stand. We'll join them in progress now.
Okay, please be seated. All right, counsel, you may continue.
Thank you, Your Honor. Commander Flesland, when we left off, I was about to ask you about officer-involved shootings. Has the department developed, through Lexipol, a policy on officer-involved shootings?
We have, yes.
Your Honor, I would offer Exhibit 337, which is that policy, 305.
337 will be admitted.
And this is another one we're not going to go through at length, but can you tell the jurors why you have a separate policy about officer-involved shootings and such incidents?
I would say first and foremost the significance and severity of such an incident, but it can be a slightly unique investigation to work through, and we just want to make sure that we've thought through everything ahead of time, have some best practices, have some guidance that we can lean on, that we can work through this sort of situation if it ever happens.
And in this case, did your department refer the investigation out to an outside agency?
We did.
And which agency was that?
The BCA, the Bureau of Criminal Apprehension.
And why was that done?
Well, we've long known that you're going to have someone else investigate it. And there's been a lot of movement through the state legislature as well as others as far as which agency is the maybe the preferred or the ideal one in Minnesota.
And so, anyway, the bottom line there is to have an outside agency do it.
Yes.
And if we zoom in on the policy provision here, 305.2, is that the reason for that expressed here?
Yes, the policy of the Brooklyn Center Police Department is to ensure that officer-involved shootings and deaths are investigated in a thorough, fair, and impartial manner.
Even though the department refers the investigation itself to an outside agency, does the department still have some responsibilities? No, strike that. Does the department and its officers still have some responsibilities at the scene initially?
Absolutely, yes.
And if we go, to 305.5.2, so this provision spells out responsibilities for supervisors at the scene, correct?
Correct.
And fair to say that I'm trying to speed this up to say like the supervisors get some information, control the scene, and then pass it on.
Generally, big picture, yes.
And securing the scene is part of the responsibility there.
Yes.
Preserving the integrity of evidence. If we were to go down a little farther, this would be just above 305.5.6. See on this page that the care should be taken to preserve integrity of any physical evidence.
Yes.
So it's within the department's policy to secure relevant evidence before turning, so that can be turned over to the outside agency.
We want to safeguard the scene and the evidence as best we can.
And then the policy seems to separate between involved officers and uninvolved officers, correct?
Yes.
And bottom line for involved officers under the policy is what? Do they have any role in the ongoing investigation, uninvolved officers?
not a significant active role that they're going to be taking actions on their own.
And involved officers, generally what is provided for in the policy regarding them?
Big picture, we're going to get any involved officer away from the scene. We're going to get them back to a secure location, probably the police department. We're going to make sure that physically any kind of injuries are evaluated and treated. We're going to work to help them contact union representative to help ensure that safeguards and everyone's rights are intact.
Now, I asked you earlier about the field training officer program at Brooklyn Center. You're familiar with that?
Yes.
And is there, in fact, a field training officer policy or program policy in Brooklyn Center as well?
There is, yes.
Your Honor, I would offer Exhibit 344, which is the FTO program policy.
Exhibit 344 will be admitted.
And can you put that up, please? And if you can, zoom in on the second paragraph. So this defines the policy of the department to put new officers in a structured field training officer program, correct?
Yes.
What is the purpose of the FTO program?
It's really to indoctrinate the new officers into police work in Brooklyn Center. They've already passed all the requirements by the state as far as licensing. They've got a license. They've demonstrated competency and skills in other academic programs. And now we're going to work to make sure that they know how to be a Brooklyn Center police officer.
And the policy here seems to indicate that, well, is it the intention to have that new officer acquires the skills needed to operate in a safe, productive, and professional manner?
Yes.
And does any officer get to be a field training officer?
No.
Are there requirements for that spelled out here in the selection and training provisions?
Yes.
And the first paragraph, the FTO is an experienced officer, correct?
Yes.
And trained in the art of supervising, training, and evaluating entry-level and lateral police officers, correct?
Yes.
And if we scroll down a little bit farther, does this speak to training?
This part speaks to the selection of who we're going to have as a field training officer.
Yeah, I was a little imprecise there. Below the selection process, continued training.
Yes.
Are Brooklyn Center FTOs required to be trained?
Yes.
Now, I'm going to, do you know if Kim Potter was working as an FTO on April 11th of this year?
She was.
And in obtaining the personnel records, are there records concerning her training for being an FTO?
Yes.
And Your Honor, I would offer Exhibit 391.
391 will be admitted.
Can you describe for the jurors what this is? And this is, I think, actually a two-page document, so I'll have you just explain both pages.
This first page is just a training notice that one of our administrative staff would have sent out notifying Kim Potter that she was scheduled for FTO basic certification. It was training began February 7th of 2011. It was a one-week course, ended on the 11th of 2011. And then once Kim finished the training, she signs it acknowledging that she finished it and submits it back to our administrative assistant to file and log it.
And does this appear to be her signature at the bottom?
Yes.
And if you can go to the second page of that exhibit, what is this?
It's the certificate of completion. So my assumption is this is what she got at the end of the training course. She returned back to the police department. When she submitted the signed confirmation slip acknowledging that she attended the training, she also submitted this certificate, just helping to show that she was there.
And this indicates, well, if we can go back to the first page, up at the top it says description of training, basic certification, correct?
Yes.
So would this be the first training as an FTO to be an FTO?
Yes.
And if then Your Honor, I would offer Exhibit 392.
392 will be admitted.
And can you describe this for the jurors, please?
It's another training notification slip. This one, description of training, is FTO update. The dates were in April of 2013, so this would have been, I assume, the first refresher course that Kim attended.
And is that her signature down at the bottom?
Yes.
And then finally, I would offer Exhibit 393, which is another certificate.
393
3, correct.
will be admitted.
And do you see this as well?
Yes.
And what is this?
Certificate of completion from when Kim finished another FTO update back in April of 2018.
And Commander Flesland, are you certified to carry a taser?
I am.
How long have you been certified?
Since shortly after we got him, back in 2002 or 2003 timeframe.
And what do you mean by shortly after we got him?
When I first started in 2000, we didn't have tasers. Eventually, when we first got them as a department, there was only a handful of officers and sergeants that were allowed to carry them. They were the ones that had gone through some CIT training. And then eventually, shortly thereafter, we rolled it out to all of the whole department. So initially, I wasn't part of that small cadre of officers that had them.
And what do you mean by CIT?
Crisis intervention training.
Okay. So and then, so at some point, did you obtain your initial certification?
Yes.
Was that while you were at Brooklyn Center?
Yes.
And then have you been recertified every year?
I have.
And when you were first certified to carry a taser for Brooklyn Center, how did you carry it? Where on your body did you carry it?
Initially, it was in a drop-down holster on my reaction side, or my side opposite where I carry my handgun.
So by reaction side, just want to make sure we're clear because sometimes there's different terminology. So what side do you carry your firearm on?
I carry it on my right side. I'm right-handed. I'm dominant on my right side, so my left side is what I would consider my reaction side.
And so you've carried your taser on your left side?
Yes.
Is that throughout your career?
Yes.
Why do you carry it on the other side?
That's how the policy has always been, and that's how we've always been trained.
Okay, one last policy, I promise. Is there a specific policy on the use of a taser?
Yes.
Your Honor, I would offer Exhibit 334, which is the taser policy.
334 will be admitted.
I want to draw your attention to the second paragraph, 304.2 policy. tell the jurors basically, what's being communicated here? What's the basic role of a taser in policing in Brooklyn Center?
Can I start by just reading it?
Of course.
The taser device is intended to control a violent or potentially violent individual while minimizing the risk of serious injury. The appropriate use of such a device should result in fewer serious injuries to officers and suspects. When we incorporated the taser into our repertoire, it gave us what I believe is a powerful new tool that can allow us more options in a wide variety of situations that hopefully, potentially, are going to minimize any unnecessary violence or injuries.
And, okay, you can take that down, please. Does the taser allow you to use force on an individual from a distance?
It can, yes.
And, is training required to carry a taser in Brooklyn Center?
Yes.
And is that laid out here in the policy under issuance and carrying?
It is.
A couple of paragraphs below is a sentence that starts with members carrying. Do you see that?
Yes.
Can you describe what that is, please?
Members carrying the taser device should perform a spark test on the unit prior to every shift.
Do you know what a spark test is?
Yes.
And have you performed that yourself?
Yes.
And is there an exception to this policy provision?
Not that I'm aware of.
And I'm going to have that policy addressed later, so we'll move on right for now. When was the most recent time that this policy was sent out to officers?
September 1st of 2015.
And when did then Officer Potter acknowledge it?
September 23rd of 2015.
When officers like yourself are certified, you have to go through some training for that, correct?
Yes.
And then there's some documentation of that certification, correct?
Yes.
And in your search of the personnel records, did you find some records of Officer Potter being certified?
Yes.
Do you know if she was certified to carry throughout her career at Brooklyn Park once you got tasers?
In Brooklyn Center, yes.
I mean in Brooklyn Center? And the answer is yes?
Yes.
All right. Do you know if the department has all the records of those certifications or just some of them?
I think we've got a decent collection of them, but I don't think we have every document that we've ever had on the taser.
Your Honor, at this time I'm going to offer Exhibits 246 through 255.
Exhibits 246 through 255 are admitted into evidence.
And I'm going to start in sort of reverse order with Exhibit 255. Do you recognize what is Exhibit 255?
I do.
And what is that?
It's taser certification for Kim back in December of 2002.
Okay.
And it was for the M26, which was the initial model of the taser that we had.
Have you had some different models over time?
Yes, they've evolved.
Okay. So December of 2002, do you recall when Brooklyn Center got those initial tasers?
Probably shortly before that. That sounds like the right time frame.
And I'm going to show you Exhibit 254. What is this?
Training certification for Kim when she was trained on the X26, which is a newer version of the taser. And this was May of 2005.
Showing you then Exhibit 253. Can you describe this, please?
This looks like it's a recertification. When Kim recertified with the Taser, it looks like it was the M26 back in 2007.
I just want to take a quick look at this. You would have received a document like this when you were certified, correct?
Yes.
And the name at the bottom where it says print name, do you recognize that name?
Yes.
Whose name is that?
Sergeant Pastor.
Is that Pastor?
Yes.
And do you recognize, I mean, was he one of the Taser trainers?
He was and still is one of our Taser instructors.
And the area above that where the check marks are,
Yes.
what is the purpose of those check marks?
They were indicating what all had been included in that training session.
And back then was an actual written test required?
Yes.
It appears that Ms. Potter got 100% on that test, correct?
Yes.
I'll show you Exhibit 252. Can you describe this for the jurors, please?
It's the very similar recertification form where Kim would have gotten some more Taser or recertification on April of 2015.
And above the date on that line is a name. Do you recognize that name?
Yes.
Whose name is that?
Officer Knight.
And was she, well, it's a female officer, correct?
Yes.
And was she one of the Taser trainers?
Yes.
So this is Ms. Potter being certified again in 2015.
Yes.
Here's the score of 50 out of 50 on that.
Yes.
And I'll show you Exhibit 251. Can you describe this for the jurors, please?
It's another Taser recertification form where Kim was recertified in November 2016 and was certified by Sergeant Peterson, another one of our Taser instructors.
Okay, and that is Mike Peterson?
Yes, sir.
So that's his name above the date?
It is.
And again, it appears here Ms. Potter got a perfect score.
Yes.
Showing you then Exhibit 250. Do you recognize this?
Yes.
And what is this?
Another Taser recertification form showing that Kim was recertified November 2017 by Officer Knight.
And there is in the middle of the page, and if we can zoom in on the signature there, do you recognize that signature?
Looks like Kim's signature.
Okay. And so the signature here acknowledges what?
Receipt of Taser's version 20 product warnings, understanding that she must read and understand these warnings prior to participating in any hands-on CEW drills required by the certification course.
And if we scroll down a little, there are a series of X's. And why are those there? What do they signify?
That she participated in those portions of the training, I guess. I assume that those are Officer Knight's X's.
And again, it appears that Ms. Potter got 50 out of 50 on the test.
Yes.
Showing you then Exhibit 248. Do you recognize that?
Yes.
And what is that?
Another Taser recertification form showing that Kim was recertified November 12th, 2019 by Officer Knight.
Now above that, instead of X's, we have some initials, correct?
Yes.
Can you tell whose initials those are?
I believe it's Officer Knight's initials.
And above that, if we could zoom in on the signature there, that is the student's signature, which would be Ms. Potter, correct?
Yes.
And again, that's certifying that she understood and read the warnings, correct?
Yes.
And I'll show you Exhibit 247. Do you recognize this?
Yes.
Okay, and what is that?
Another Taser recertification for Kim from November 2020.
Now, at the very top of the page, there's an X by one of the model numbers, correct?
Yes.
And what model was she recertified on at that training?
X26P.
And again, there's her signature below that,
Yes.
and making the same acknowledgement.
Yes.
Below that are the indications of what was covered.
Yes.
The bottom line is blank. It refers to the X2 and X3, correct?
Yes, different models.
And again, Officer Knight, the trainer.
Correct.
And then finally, Exhibit 246. Can you describe that for us, please?
It's another Taser recertification form showing that Kim was certified March of 2021 by Sergeant Pastor.
Now, the title of this form refers to a Taser 7. At some point, did the department move to a different model from the X26?
From the X26P, yes.
Okay, and so what model was this training done on?
This document is showing training on the Taser 7.
And it indicates a transition course, correct?
Yes.
And are you currently certified on the Taser 7?
Yes.
Did you have to go through a transition course when the Taser 7s came?
I did.
And in the middle of the page there appears to be a signature again, correct?
Yes.
And that is for the student?
Yes.
There is underneath that the check marks for what all was involved in that training, correct?
Correct.
That includes a de-escalation warning arc, correct? The third line down.
Yes.
The top line is reviewing the PowerPoint presentation and training bulletins, correct?
Yes.
And can you tell a jury who was the certifying instructor for this certification?
Sergeant Peterson.
Commander Flesland, were you asked to review some videos from prior Brooklyn Center Police Department incidents in which Ms. Potter appears as an officer?
I was.
And have you reviewed those videos and still images from them when Ms. Potter was a responding officer to those incidents?
Yes.
And particularly, did you view dash cam video from a Brooklyn Center Police Department incident on April 30 of 2016?
Yes.
In reviewing that video, did you recognize the squad car as a Brooklyn Center squad car?
I did.
Did you recognize the software running the video as consistent with what your department uses or used back then for video?
It was.
And did you recognize Ms. Potter in the video?
I did.
Your Honor, we would offer Exhibit 382.
Any objection to 382?
No objection.
382 will be admitted into evidence and you may publish.
Now, showing you this photograph, Exhibit 382, this is a still photograph from the video of that incident, correct?
Yes.
And there should be a small stylus in front of you if you want to use that, and maybe draw on the screen where Officer Potter is. And when you were watching the video, were you able to discern where she was wearing her taser at that time?
I was.
And I think the two slices of video are attempts at a closer up view of that, correct?
Yes.
But from watching the video, were you able to determine where she was wearing her taser?
Yes.
And where was she wearing it?
On her left. It was on the left side of her duty belt.
And when officers are wearing their taser, are there two different orientations that they can wear it in?
Yes.
And what are those two different orientations?
I'm going to call them a cross draw and a reaction hand draw.
Okay. And what's the difference? And if it would help to demonstrate to the jurors, if you want to stand up and just show them, you can do that if you want.
The way I have mine oriented is for a cross draw. So I'm right-handed, right hand dominant. I carry my handgun on my right side, carry my taser on my reaction side. So this holster is set up so that I would cross draw using my dominant hand to draw across my body. When I refer to a reaction hand draw, the taser would be oriented so the handle's aft, not forward, and you would use your reaction hand to draw the taser that way. So it basically which way the handle is pointed, whether it's going to be forward or aft.
And Exhibit 382, can you tell which orientation Ms. Potter is wearing her taser?
Reaction hand draw, yes.
Did you also review body-worn camera video from a Brooklyn Center Police Department incident on November 2 of 2017?
I did.
Did you recognize the officers in that video?
Yes.
Did you also recognize the computer program running the video as that which your department used then?
Yes.
And did you recognize Officer Potter in the video?
I did.
I'm going to offer Exhibit 383.
383 will be admitted into evidence and you may publish.
And with this on the screen, were you able to determine the side on which Ms. Potter was wearing her taser?
Yes, it was on her left side, her reaction side, and it's set up for a reaction hand draw.
Were you also asked to review body-worn camera video of a Brooklyn Center Police Department incident on February 21 of 2018?
I was.
And in doing so, did you recognize the voice of the officer speaking as a Brooklyn Center police officer?
I did.
Did you recognize other officers in the video?
I did.
Did you recognize the squad car that the video was being taken from?
I did. It was a Brooklyn Center squad.
Okay. At this time, Your Honor, I'm going to offer Exhibit 384.
384 will be admitted into evidence and you may publish.
And is this Officer Potter in the video?
It is.
And can you determine how she is wearing her taser in this incident?
It's on her left side, reaction side, set up for a reaction hand draw.
Were you asked to view body-worn camera video from a Brooklyn Center Police Department incident on November 4 of 2019?
Yes.
And did you obtain the videos for that incident from the Brooklyn Center Police Department records?
Yes.
So if you could just real briefly describe for the jury how you would do that, after a body-worn camera video is made, where it goes and how you get it.
For the body-worn camera video?
Correct.
When the recording is done, or when generally at the end of your shift, you'll take your body-worn camera off your body, you'll dock it into a docking station. We've got 8 bay chargers where 8 different body-worn cameras can dock. Once you dock that into the charger, a few things happen. The battery starts to recharge, and any videos that are on it will get pulled off of the body-worn camera and pulled onto a city network. It's a secure drive, it's a secure network, and there's a repository there for the videos. We'll access the videos, or we can access the videos through, again, it's a web-based program or interface. I guess it's not actually a web-based, correct? It's a standalone system on our computers, but we'll log in and we can access the videos. Different people have different rights, different abilities to view videos. Every officer has the ability to view their own video, has the ability to categorize it, attach a label to it, whether it's a case number or such, and then part of that labeling will determine data retention, how long it will be retained for. Certain people, certain supervisors have the ability to go in and view anyone's video. So that's what I was able to do in some of these, is when I had a case that I was going to look at, or a time date range, I was able to plug that in, pull up all the videos that satisfied that request, and that's how I was able to find these videos.
And did you recognize Officer Potter in the video?
Yes.
Your Honor, I would offer Exhibit 385.
385 will be admitted into evidence and you may publish.
And are you able to determine how Officer Potter is wearing her taser during that incident?
Yes, it was on her left side again, set up for a reaction hand draw.
Did you also obtain video from a Brooklyn Center Police Department incident that occurred on June 15 of 2020?
Yes.
And did you recognize the officer in that incident as a Brooklyn Center Police Department officer?
Yes.
And you obtained this video in the same manner as you did the previous one?
Yes.
Did you recognize Officer Potter in the video?
I did.
Your Honor, I would offer Exhibit 386.
386 will be admitted and you may publish.
Based on this video, and just for the record, this is a still from that video, are you able to determine how Officer Potter was wearing her taser on that occasion?
Yes, it was on her left side, set up for a reaction hand draw.
And for purposes of this, did you also review a portion of Officer Anthony Lucky's body-worn camera video from this incident?
I did.
And Your Honor, I would offer Exhibit 387.
387 is admitted over defense objection and you may publish.
And from that, are you able to determine how Officer Potter was wearing her taser on that date?
It was on her left side, set up for a reaction hand draw.
Now, based on your role as a commander, you're familiar with how records are kept of training attendance?
Generally, yes.
And is there a computer program that you have to keep those attendance records?
We've had a few programs through the years.
Okay. And so is attendance at trainings for officers kept in the ordinary course of business at the Brooklyn Center Police Department?
Yes, they are.
And were you able to obtain a summary of all of the trainings that Officer Potter has attended since being a Brooklyn Center police officer?
As much as our systems were able to allow us to.
And, Your Honor, I would offer Exhibit 335.
Exhibit 335 will be admitted and you may publish.
So I'm going to scroll through this. We're looking at page 1 of Exhibit 335, correct?
Yes.
And, just for lack of a better term, this looks to be kind of a spreadsheet, correct?
Yes.
And this is for Ms. Potter's attendance, correct?
Yes.
So on the left column is in yellow is a date for an entry of the year, correct?
Yes.
And then the blue column, the numbers in blue, are for what?
Date attended.
Then there's a red column, indicates completed.
Yes.
And then there is a type of training column and a name of training column, correct?
Yes.
Do you know who enters that information, the name?
Someone from our records division.
And it also keeps track of the number of hours, correct?
Correct.
And so then if we scroll down, this starts in 2021 and works backwards, correct?
Yes.
And then so let's keep scrolling down until the format changes. Here we see a slightly different version once we start 2016, correct?
Essentially, it's the same. It just appears to be black and white.
Right. So we'll keep scrolling down. Now here we see slightly less robust version of that, correct?
Much less sophisticated.
So this was a previous version of the software you used to record these?
Yes.
All right. Then let's just keep scrolling down. So these are trainings that go back to 1995, 96, correct?
Yes.
Your Honor, those are all the questions that I have for this witness.
Okay. Counsel, you may cross.
That last, well, it's good afternoon, I guess. It's 1 minute after 12. I gotta get a drink of water. Would it be fair to say, Commander, that our client, Kim Potter, did not miss any training sessions throughout her career?
I'm not aware of any.
Okay. And what the exhibit that you just went through with the prosecution, that was a record of her training, correct?
Yes.
And you know Officer Potter from the years you worked with her, correct?
Yes.
And she took her training seriously, did she not?
She did.
However, when you train as a police officer, no matter how much training you do, it's not like real life, like an emergency situation out on the street, is it?
Never exactly, no.
And you don't know how you're going to react until that emergency situation takes place, correct?
Correct.
So, the report that you gave the prosecution, or a statement you gave them, was about Officer Potter, or former Officer Potter, and what she did as a police officer in addition to her job. And you remember telling them that? I'll refresh your memory. Did you tell them that she worked as a field training officer? We know that, correct?
Yes.
Did she get paid for that?
Yes.
Any extra pay? What about a crisis negotiator team member? Was that a volunteer situation?
She volunteered for it and was selected. Yes.
Okay, and what is a crisis negotiator team member? What do they do?
Sometimes they're referred to as hostage negotiators. They really can work in collaboration with maybe a SWAT team trying to resolve an incident. They're communicators. They communicate with someone that is perhaps committing a crime, perhaps in crisis, a variety of situations where crisis negotiators will try and persuade people to resolve the situation as peacefully as possible.
And do you know how long she was on that program?
Several years. I don't know exactly how many years.
And that's a program that you volunteered, is that right?
Yes.
And with respect to DART, what is that?
DART is Domestic Abuse Response Team. It's a collection of officers and detectives that have volunteered to help address some ongoing domestic abuse or domestic violence incidents. We found through research, and it's best practice, once our officers respond to a domestic abuse sort of situation, they may come up with a resolution for that night, whether it's an arrest or whatever. But we will have volunteer officers that have volunteered for this program reach back out to domestic assault victims days or maybe a week later. For a variety of reasons. They could collect more evidence. Maybe there's bruises now that appear that weren't visible initially. And then the officers can help, hopefully, establish a rapport with that victim, help them navigate the upcoming process through the criminal justice system, help make sure they have the resources, trying to end the circle of violence.
And she did that for many years?
Yes.
And besides that, she worked as a LEMA. What's LEMA? What does that mean?
Law Enforcement Memorial Association.
And what is that?
It's an organization.
Was she an honor guard representative?
Yes, she was.
Tell us about that.
The organization is set up to support fallen peace officers and their families. The honor guard portion of it performs at funerals of officers that are killed in the line of duty. There's also a variety of other events that they perform and support that fallen officers' families.
And has she done that for many years?
Many years.
And did she volunteer to do that?
Yes.
Now, with respect to her being a union steward and president, was she voted into that position by the other officers?
Yes, by the other officers and detectives in the 82 union.
And so that the jury understands this type of union steward, her only duty is to negotiate a contract with the chief. Is that a fair statement?
I believe there's many more duties besides just negotiating contracts.
And what else would there be?
They're there to represent the officers and detectives, or whoever's in that bargaining unit. They can help that officer negotiate if they believe they've been wronged and are going to potentially go down the grievance route or something like that. The union stewards can help them navigate that process so that
and they're voted in by the other officers, is that right?
Yes, sir.
And that's also a non-paying volunteer job?
Correct. In your 21 years there, has Officer Potter ever been accused by the public or anybody of an abuse of power, use of force? Has she ever been accused of using her position abusively? Not the...
The objection is overruled. You may answer.
Not that I'm aware of, sir.
And has she ever been charged with any violation of the policies at the Brooklyn Center Police Department?
I'm aware of some driving incidents with motor vehicle accidents, but...
And that was back when she first started, correct?
I believe so, yes.
There was 2 car accidents within the first couple of years, is that right?
That was the version I heard.
And that was about 24, 25, 26 years ago?
That sounds about right, sir.
Now, on these policies that we talk about, excuse me again. First we'll do the vehicle pursuits. That was policy 307. That policy deals with a vehicle that's moving, correct? Or stopped and took off.
Yes.
For example, if a police officer goes to stop a vehicle and it takes off like a jet, you don't chase it for just a traffic violation. Is that correct?
Generally, no, but that's just one of the factors that would have to be evaluated.
All right. And that has nothing to do with a vehicle that's stopped at the scene and you're executing a warrant for the arrest. Is that correct? About a car fleeing?
I think one situation could potentially lead into the other situation, but generally no.
But the officer, potentially that would lead in, the officer that stopped that vehicle or officers would attempt to stop the vehicle from fleeing, correct?
I guess I'm...
Well, the officer stopped the vehicle. Hypothetical, this case, 3 officers come up and try to arrest the individual for a warrant, trying to find out who the TRO, if the girl in the car is the person in the TRO. No license, no insurance, no real identification. Would they be in their right to stop that person from fleeing once he was stopped and he was outside the car?
Objection, Your Honor, this statement.
The objection is overruled. You may answer.
Based on the way you laid it out, yes.
Well, what difference did I make from what actually happened here that day, sir? Was there something I didn't add?
I haven't investigated what happened here this day. I have limited knowledge of the particulars of this.
Okay. Have you looked at the videos, the body-worn camera videos of this incident?
I've seen portions of it.
All right. And did I misstate anything that you saw on that video?
I don't believe so.
And by the way, Officer Lucky is still working with the Brooklyn Center Police Department, is that right?
Yes.
And he didn't receive any sanction or punishment for his conduct that day, did he?
Objection relevant.
The objection is overruled. You may answer.
No.
And what about Sergeant Johnson, the man that went in the car to try and stop Mr. Wright from leaving? He worked at the Brooklyn Center Police Department up until recently, correct?
Yes.
Was he ever sanctioned or punished or anything as a result of his conduct that day?
No.
And with respect to foot pursuits, that would be if you start chasing somebody out in the park, and if he's gaining ground on you, or if you're gaining ground on him, if it appears futile, you stop chasing him. Is that a fair statement?
Yes, that's one of the factors or those are some of the factors that would be considered.
And it depends on what you're chasing him for. If you're chasing him for shooting somebody, you would chase him a little longer than you would if he had parked his car wrong, correct?
I'd like to think I would, yes.
Okay. And then we get to the use of force. You can use deadly force in your Brooklyn Center if force reasonably anticipated and intended to create a substantial likelihood of causing death or great bodily harm. Is that a fair statement?
I believe that's a fair definition according to our policy.
Okay. And that's the definition of deadly force.
According to our policy, yes.
That's what I'm talking about. And if someone hypothetically is inside a vehicle that's trying to take off, and as part of his body's hung out and part of it's in the car, and the car took off, that person would be dragged down the road, correct?
Very likely, yes.
And that would cause great bodily harm. Fair statement?
I would be concerned about that, yes.
Or if the car all of a sudden went in reverse and that body was hanging part out of the car, it would also cause great bodily harm, correct? Was that speculation? I'm sorry.
The objection is overruled. You may answer.
You've experienced in your 21 years as a commander and as a police officer situations like that, haven't you?
Some.
Where officers were injured at the scene by somebody that
Yes.
they're trying to arrest?
Yes.
In fact, nowadays, isn't it true that the officers, and I believe I wrote it down here someplace, it's incredibly, this is how you described it, sir, in the beginning. It's incredibly more difficult, and I throw in dangerous, nowadays to be a police officer. Do you remember saying incredibly more difficult when you first testified? Here, did you say that?
I don't remember those specific words comparing it to another period, but
Okay, well, is it incredibly more difficult nowadays to be a police officer than it was when you first started out?
I think so, yes.
More guns?
I see more guns more frequently now than in 2000.
And when you do a traffic stop, that's a very dangerous stop, is it not?
It can be, yes.
And that's because you don't know if the individual you stop has a gun or not.
Correct.
You don't know if he has a warrant, correct?
Correct.
And you have to find that out. In fact, you approach a car, a vehicle that you stop for some reason, and you don't know who you stopped, correct?
Sometimes you know who you stopped, but
Okay.
oftentimes you don't.
Okay. And when you're somebody you don't know who you stopped, that causes you to be concerned about who it is, correct?
Absolutely, yes.
And in fact, you get the license, and what you do is you go back to your car and you check the license on your computer to see if there are any warrants, correct?
Oftentimes, yes.
And also to see if there's any restraining orders, correct?
Yes.
And if there is a bench warrant for weapons violation, does that alert you a little bit more that maybe this guy might have a gun in his car?
The objection is overruled. You may answer.
It would be concerning, yes.
And when it's determined what reasonable force can be used, and I'm talking about deadly force, you look at the totality of circumstances, correct?
Yes.
And in your policy, and I believe it tracks the statute somewhat, all facts and circumstances, and this is a definition of totality of circumstances, all facts and circumstances known to the officer at the time taken as a whole, including the conduct of the officer and the subject leading up to the use of force. At the time of when you use the reasonable force, what you know at that time authorizes you to use either reasonable force or maybe deadly force, correct?
Yes.
It's not something you learn later. It's right there, that time, what you perceive at the time that you use the force, correct?
It's based on what a reasonable officer would know, perceive at that moment without the benefit of hindsight 2020.
Yes. And that's indoctrinated into all of you officers as far as exercising reasonable force, deadly force. You have to know, what you know right then. It's not later, it's right then, what you perceive. And that's part of the law, correct?
Yes.
And you can use force to effect an arrest too, correct? And that's in your policy.
Yes.
You can use force in effecting a lawful arrest, execution of a legal process, enforcing an order of the court, and a bench warrant is an order of the court, correct?
Yes.
And executing any other duty that may be imposed by you by your position, correct?
Correct.
And then there's another one, and the use of force to effective arrest in your policy. In preventing the escape or retake following the escape of a person lawfully held on a charge or conviction of a crime. You can do that too, correct?
Yes.
And if somebody's outside of a vehicle and there's a bench warrant for a weapons violation, and if he tries to flee, you can use force to stop him, correct? Reasonable force.
Yes.
And if he keeps resisting after using the physical force of pulling on him, getting him out of the car, you can also use other forces, like a taser, correct?
Yes.
If the car isn't moving. And if he still persists on it after the man is warned that I'm going to use a taser, and he keeps fighting, and another officer is now in the car trying to stop him.
Objection.
I'm not done with my question.
The objection is overruled. You may finish.
And another officer is in the front seat laying over the passenger trying to stop this guy from going. And he is ignoring the warnings, taser, taser, I'm going to tase you. You have a right to use deadly force to save that cop, that police officer that's lying over the seat, correct?
The objection is overruled. You may answer.
Potentially, yes, but I wasn't there.
I know.
Yeah.
But if that fact scenario, yes. You've got to save that officer that's laying over the seat, correct?
Yes.
If you're dragged down the street by this driver, if he gets away, that man's going to be seriously injured or dead. Fair statement?
Could likely happen, yes.
And some of the factors in your policy, the immediacy and severity of the threat to officers or others. And if somebody's lying over that seat and another individual, an arrestee, is trying to get away driving and he ignores the taser, that would be the severity of the situation, would it not?
The objection is overruled. You may answer.
That would be, I'll rephrase it, that would be the immediacy and severity of the threat to the officers, would it not?
I think it would be severe and significant, yes.
And the conduct of the individual at the time of being confronted by the officers, that's another factor, is it not?
It's a factor, yes.
The effects of suspected drug or alcohol use, that's another factor, correct?
Yes.
If you go up to the car and you see marijuana shake or seedlings or whatever it is, and you smell marijuana, that would be an indication from an experienced officer like yourself, there may be marijuana in that car, correct?
Good, yes.
Or maybe the fellow driving the car is using marijuana, correct?
Possibly, yes.
And when the individual doesn't comply with your demands, you have to escalate the force that you use, correct?
Sometimes, yes.
And when you go up to that car and you know it's a weapons bench warrant where this man has been charged, although it's a gross misdemeanor, with having a weapon on his person or in his constructive possession without a permit, correct?
Well, the objection is overruled. You may answer if you can.
You want me to rephrase it?
I would be extremely concerned
Okay.
if I was going to arrest someone that had an arrest warrant for some sort of weapons violation.
And the policy with respect to moving vehicles, that's talking about vehicles moving. It's not talking about a vehicle stopped, correct?
I think that policy on vehicle pursuits talks about vehicles moving or potentially initiating a vehicle pursuit. Or are you talking about the shooting at or from a moving vehicle?
Yes.
The shooting at or from a moving vehicle, I believe, is focused on a vehicle in motion.
But if, okay. How would you describe Kim Potter as a police officer in Brooklyn Center from the 20 years that you worked with her and you were her commander? Objections.
The objection is overruled. You may answer.
She's a good cop. She's a good person. She's a friend. I had no concerns going to calls with her. I had no concerns with her.
You're interrupting.
Okay, let's sidebar, please. The objection is sustained. Don't answer that, please.
Previous portion of the answer be stricken. The jury's vote.
Your Honor, yes, you said that.
I'll let the answer stand. The reason for me sustaining the objection is beyond the scope of the direct.
Did you, on the date of this incident, did you and the police chief Gannon go over to Kimberly Potter's home?
Yes.
Objection scope.
I don't know where he's going. I'll let you said yes, I'll let the answer stand.
Why did you go there?
Objection scope, Your Honor.
The objection is overruled. You may answer that.
We have been told she had hurt herself.
You mean self-hurt?
Okay, the objection is sustained now. And the jury is to disregard that last question and answer.
May I confer with Mr. Engen? I think I'm done.
Yes.
Thank you, Commander. I'm done.
Mr. Frank? Mr. Frank, I think we're going to take a lunch break, unless it's going to be like 5 minutes.
I would think so, Your Honor.
Okay. All right, members of the jury, we're going to take our lunch break. Oh, you said it would take 5 minutes? Okay, sure. Sure.
Trying to be thoughtful of the officer's time as well. You were asked, Commander Flesland, about the use of force and things to consider. I won't be quite as demonstrative, but does the law and your policy also require that officers take into consideration the potential injury to officers, suspects, and others through their use of force?
Yes, that should be a factor that's considered.
Do they also have to consider collateral injuries to others by their use of force?
Yes.
Do they also have to consider less force if they can?
If they can and it's reasonable.
You were asked about people who are fleeing, and it was represented to you that, how would you think about that if they weren't fully identified? Should an officer take into consideration when deciding how to handle a fleeing person if they have been fully identified?
That could be a factor.
I object unless is he talking about somebody?
Okay, no talking objections.
I'll withdraw the objection.
Oh.
I can't remember if you answered the question even fully.
Could you restate the question,
Sure.
please?
In deciding the amount of force to use, you were asked a lot about a person who was fleeing. And is one thing an officer should consider is whether they have already fully identified that person.
That should be one of the factors considered.
And are officers then, in exercising force, whether it be deadly force, are they required to use no more force than necessary?
They should use no more than is reasonably necessary to accomplish the task.
You were asked several times in very dramatic ways about how an officer should act when people are hanging out of the car. Remember some of those examples?
Yes.
Were your answers to those questions based entirely on the representations from counsel about the fact scenario of those questions?
Excuse me, I'll place an objection.
Overruled.
So, do you recall the question?
If you could state it one more time, please.
You were asked on many occasions about various factual scenarios and how you would react to those and perceive the use of force in those. Mr. Gray made representations to you about the situation and asked your opinion. Do you recall all of that?
Yes.
Were your answers based entirely on what Mr. Gray was representing to you as the facts to consider?
No, I included other thoughts I guess I had.
About what? I mean, what other thoughts?
Other situations I may have been involved in, may have witnessed.
Sure, in deciding how you would act or what you might do. But I'm saying all of the facts of that incident, Mr. Gray gave to you, correct?
I was trying my best to answer based on the facts that he had said.
Regarding this incident involving Ms. Potter, did you interview any witnesses?
No.
Did you watch all of the body camera or dash camera video?
No.
Have you reviewed any of the reports regarding the case?
No.
In the answers that you were giving to Mr. Gray, are you basing those answers at all on what happened with Ms. Potter and Daunte Wright on April 11th?
I'm sure I'm thinking of the small portions of the video that I've seen and relying on Mr. Gray laying out a set of possible events.
But do you know if any of those events occurred?
They seem to be in line with the portions of the videos that I saw, but I am by no means an expert on what happened that day.
Well, you said you didn't watch all the videos.
No.
Haven't interviewed the people involved.
No.
And so you're allowing, when you're answering these questions, are you answering them based on the additional drama that Mr. Gray has added to the situation?
Object to that is asked and answered in a meeting, and asked that you not mention drama again.
Okay, yes. The objection is sustained as to using drama.
All right. I'm sorry about that. Let me ask it this way. Are you offering an opinion on Kim Potter's use of force that day?
No.
Your answers to Mr. Gray, you've been telling us you had this video in your mind, not based on, are your answers to Mr. Gray's questions not based on what actually happened out there, but what little bits you saw plus what Mr. Gray added for you?
I was trying my best to answer them based on what Mr. Gray was explaining the events that he articulated.
You indicated that training is not real life, correct?
It's never exactly like real life.
Is part of the training trying to teach officers to think in stressful situations in real life?
Yes, we strive to try and really encourage critical thinking. We try and make training as realistic as we can, but we acknowledge we can't make training exactly like real life.
And would a good police officer try to make good decisions under pressure?
Object to that is leading, Your Honor. Also, opinion of the witness.
The objection is overruled. You may answer.
I expect good officers to make good decisions.
You were asked about moving vehicles, and does an officer have to take into consideration whether a vehicle that's sitting still could be put in motion when they're deciding whether to use force and what level of force?
It should be a factor considered.
That's all I have, Your Honor.
I have just a couple of things. Good afternoon, Commander. You did see parts of the video of the traffic stop in this case, correct?
I've seen parts.
Okay. And you did say that good officers make good decisions, correct? You just testified to that?
My hope is good officers make good decisions, yes.
And you did describe Kimberly Potter as a good officer, correct?
I did.
I have no further questions.
Anything further? Please step down. Okay, members of the jury, we are going to start. It's like what is it now? It's almost quarter to one. We'll start at 1:45. Okay, so you get a full hour for lunch. Okay, have a good lunch.
Welcome back, everyone. Tim Blotz, along with Paul Bloom and the Fox 9 News team. You've been watching live streaming coverage of the manslaughter trial against Kimberly Potter and the death of Daunte Wright from that traffic stop on April 11th this past spring, where she pulled her gun instead of a taser and killed Daunte Wright during that traffic stop. You've just been watching Commander Garrick Friesland on the stand today. He is with Brooklyn Center Police Department, going over the record of the kind of training that Kim Potter has had in the past in both department policy, with her weapons, and especially with the taser, where she passed all of her training, in fact, got perfect scores in all of her training with her taser. But what's most interesting was the exchange with Earl Gray that just happened with the defense attorney in the past half hour here. And this is a good point to bring in Marsh Hallberg, who is the defense attorney himself with Hallberg Criminal Defense. And Marsh, I want to bring up kind of an observation here, and that is, did Mr. Gray effectively use the commander here as his own witness? This was a prosecution witness, and it seemed as though he could have turned the tables and made it one of his own witnesses.
Exactly, Tim. This, at the end of the day, if you think back, if you've seen the last couple hours, whose witness was this, right? Do you remember any of the first couple hours of today about all of the details about this policy page numbers, code number, blah, blah, blah? It just got too bogged down. And people want the meat, right? The jury wants the solid stuff about, did she attend her training? Was she conscientious about it? Is she a good person? So as far as that whole training manual and comparison of what happened here and what happened in the training manual, the defense is going to agree in closing that, yeah, of course the policy manual wasn't followed, but it's because it was a tragic accident. But it was a good person who made an honest mistake. So it's a classic example of a witness being turned and being careful with what you're trying to do. I thought it was, I didn't learn a lot in law school, and a lot of us don't learn a lot at school, right? What we learn in life is in real life in the courtroom, and I've done lots of trials. And what I do remember from law school is my professor saying, trial is not an evidence class. And that's the exact problem here, is that the state repeatedly, over and over and over, objected to Mr. Gray's questioning. And while technically under a law school tight analysis, you might say that some of his questioning was improper. But the judge repeatedly, and I counted at least a dozen times, that the judge overruled the objections and allowed the witness to answer. And that gives the impression to the jury that the state is trying to hide something, that the state is afraid of the truth. Just let the witness talk. So from a tactical standpoint, I thought that was a poor decision by the government in continually objecting over and over.
And this really kind of reflects back to the motion that she ruled on this morning, where she would allow officers to give their opinion on use of force. And Earl saw that window, that opening, and ran right through it here this afternoon with Commander Flesland when he specifically talked about the incidents that day, correct?
Correct. Wide hole, it's open there. The advantage the defense has in this case is that obviously we don't know Officer Potter very well, But everything we've seen from how she reacted in the video and the testimony is that she's a really nice person. And we already know she's going to testify. So unlike a lot of cases where it's easy to dislike a defendant and to not like them, in this case, it's really going to be hard not to like her. She sounds like an extremely likable person. And the defense has the advantage of being able to not be worried about prior problems she's had, prior allegations against her, that she's not liked. All of that comes through in this mode of questioning.
And hey, Marsh, Paul Bloom joining the conversation. I just want to alert our viewers on the stream that the parties still remain in court and sort of, well, now they're putting down the headsets. Just want to keep an eye on that in case they do. Regina Chu does call them sort of back in to discuss something in the public courtroom, but they were meeting about something here going into the lunch hour. And in fact, they're going to keep their headsets on. We're just monitoring on a second screen here. Marsh, I got to be honest, I thought the state case got shredded again today with this witness. You and Tim speaking to it. I thought I was watching a defense witness when this was all said and done. It is crystal clear now that the officers involved, the state witnesses, I know prosecution has to call the witnesses at that traffic stop. Officer Lucky said he would have tased Daunte Wright in that moment if he could have. Sergeant Johnson said by state statute she was legally authorized to use deadly force. Now another friend of hers from the department, while going over policy and sort of being a perfunctory, yep, here's where she got 100% on Taser recertification. It comes down to, as Earl Grey, maybe a little dramatic. Obviously, it plays to a lot of jurors in that courtroom. I can tell you, I was in that room yesterday. Earl Grey, demonstrative. Jurors take note. Has them reading out of his hands as he's doing this. And you heard Matthew Frank try to kind of say, oh, I'm not going to be as dramatic as Earl Grey, but very effective getting this witness to also acknowledge, based on sort of most of the facts he knows, that there was all sorts of authorization there to detain Wright, to potentially use force to stop him by any means possible, and then use force to protect fellow officers. I just don't know where the state is going to go. Who is going to assess their case and say this is manslaughter in the first or second degree? I know they have a national use of force expert coming down the pike, but you know, he's an academic. Certainly there don't seem to be cops who are going to say this. Who's going to call this man one and man two and not an innocent mistake or a human error?
Only an expert. Right? Only a paid expert's going to do that, and the defense can neutralize that with their own expert. So you're the defense, you argue, let's wash. You got one expert says it was bad, one expert says it was good, but we got all these officers. And you come back to the theme that Earl Grey did with his commander, that real life is different than training manuals and policies, and it's a snap decision that people have to make. I'm speculating right now that I think one of the things this judge just did in the headset discussion was to remind the attorneys to not do talking objections. The way it's supposed to work in a courtroom is you give just a couple word objection. You cite to a rule, you cite to leading, overbroad, outside the scope, but you don't go into a long narrative and speech about why you're right. And both attorneys strayed into that area. So I think she is trying to rein that in a little bit.
Marsh, Tim Blountz here. We've been talking about some of the objections that and the questioning that Earl Grey has had here in court. And I wrote down a number of the quotes here that I think will give our viewers who have just joined in the stream here an idea as to what happened. When Earl Grey, the defense attorney, had his chance to question the commander here today, he took that open door provided by the judge this morning about whether he could question witnesses about their opinions on use of force. And here's what he said. Earl was asking about an officer getting a hand stuck in a car that would be speeding down the road, and he said, quote, "That would cause great bodily harm, right?" The commander said yes. He followed up, "If you're dragged down the street by this person, this is going to be seriously injured or dead, right?" The commander said yes. He followed up again. "That would be immediacy and a threat to the officer, would it not?" The commander said, "That would be very serious." So what Earl is trying to do here is establish that this was a dangerous situation, and Officer Potter had the right to use that gun even though it was a mistake. Is that the direction that he's clearly trying to go here, Marsh?
He is, and he followed up with that even more, Tim, with the really good point that we've all thought of, but it really hadn't been pressed home till today, is that the warrant was for a weapons violation. This wasn't a warrant for something else, right? Unpaid child support or something else, right? This was a weapons charge, which is going to make an officer more leery of that, concern about what's going on when this defendant starts to move around, when the driver starts to move around. So I thought it was really important to bring that home. Yeah, excellent cross-examination by Earl on this today. I think one interesting point, just from a legal standpoint, we kept hearing people talking about outside the scope, and it might be interesting for people to understand that. So the way a trial works is that when a person calls a witness, you ask them all the questions you're going to do. And if it's your own witness, you can't ask leading questions. You have to ask open-ended questions. For example, you can't ask, isn't it true that it's cold outside? You have to say, what's the weather like? Now, when it's cross-examination, the scope or the number of type of questions that the other attorney can ask can only be inside the box of what was talked about. So if the first set of questions never talked about the weather, you can't talk about the weather. And so that objection kept coming up. And so what happens is you can have direct exam, cross-exam, direct exam, cross-exam. It keeps going back and forth. But each time, the number of questions or the area you go into gets smaller and smaller and smaller, because you can only ask questions about what was asked in the prior set of questions by the other lawyer. So Earl won most of those. The judge let him, quite frankly, go outside the scope, I thought, a fair amount. But that goes to that ruling, Tim, that you mentioned this morning, that they were free to talk about whether it was appropriate to use a gun or a taser here. But that objection was made many times by the state, and they lost over and over. And the state should have just stopped making that objection.
So, Marsh, where does the prosecution have to go from here, do you think?
I don't know what they've got left, right? This is a tough case for the state. There are some people that'll say this case shouldn't have been charged, that it doesn't fit the situation very well. And it's a real struggle. It was a hard case for the state from the very beginning. They're probably going to finish up with an expert to talk about reasonable use of force, because they're going to be, I assume, an articulate professional witness who will do a nice job. And they're going to finish with that. But I think that's all I've got.
Marsh, I just want to add one more time here, even though most of our audience knows you as a very prominent defense attorney in this town, you were also a prosecutor too for a number of years. Did I hear you say like 20 years? So you've prosecuted your own cases in the past.
You know, I was a prosecutor for 26 years, both in Carver County and Hennepin County, and was the city attorney for a number of years. So I did that in the earlier part of my career, and then started this firm with some other lawyers, and we do exclusively defense work now. So I try to remember those days, remember what that was like. But kind of the corny analogy I give to him is I'm old enough to remember the early Green Bay Packers when they were good back in the 1960s. And they used to run the power sweep, the Green Bay sweep. And the idea is they'd show up at the line and say, here's what we're going to do. We're going to run this play. Try to stop us. You know what we're going to do. Try to stop us. And I always use that as an analogy for prosecution. All the discovery has happened. All the police reports have gone to the defense. They've got all the evidence that the state has. They know what the state's case is. And basically the government is trying to say, here we come, Earl and Paul Ling, here we come, try to stop us. And I think they're stopping. They're at least creating a reasonable doubt. And that's the important part. If a jury really understands what a reasonable doubt is in this case, I think this is a difficult case. As of right now, it's difficult for the state to pull this out.
And Marsh, Paul Bloom joining the conversation again. And to your point, 5-10 years ago, this case probably isn't charged. It goes down as an accidental discharge, a mistake. The city of Brooklyn Park is held civilly liable, agreeing that no one should be dead in that situation. But this movement to hold police accountable for their actions in the heat of the moment. And eventually, let's be honest, a jury of 12 will make the ultimate decision here. They'll get the entirety of the case, likely sometime early next week. They'll go into their deliberation room and decide. Now remember, it all started as a hanging air freshener, and then expired tabs and so forth and so on. You know, is there some, anti-police sentiment in that room? We will see, but certainly at this point, it feels like the state is quote unquote winning this case. My question to you, I know, out in Illinois in the last couple of weeks, we watched Kyle Rittenhouse. I totally understand a different case, but at this point in the trial, I do remember some legal experts saying, if I'm the defense, I probably don't need to put Kyle Rittenhouse on the witness stand. The case started coming in sort of in the direction of the defense. I ask you here now, I know the jury's been promised her, and I have no doubt we will see her. She seems absolutely committed to telling her story on the stand. But had they not made that proclamation and promise, would you start rethinking whether you need to actually put Potter on the stand, or do you believe the defense feels she absolutely has to tell her side of the story?
She has to take the stand. And most of the trials I do, when I talk to my clients about whether they choose to testify, and that's a decision that the defendant makes in the case. The attorney cannot make that decision. Only the client, the defendant, makes that decision. And I don't care what you tell juries about their right to remain silent and do not hold their silence against them. Juries want and hope and expect that a defendant's going to look them in the eye and go, I didn't do it. And the reason you won't put a defendant on the stand is maybe they just aren't a good witness for a number of reasons, right? They may not be bright enough to be able to handle it. They may not come off well. Whatever the reason is, the facts are too bad to even let them talk about it. But in this case, we have, it seems like a very articulate, intelligent, pleasant person, and she will do well on the stand, and they will prep that. A number of times I have, even to this day, I'll have defense lawyers have me come over to their office and cross-examine their client to practice for a trial, and be a real jerk with them as best I can, be as aggressive as I can, so they can practice that before they go in. The defense here, before this whole, that it was okay to use a gun anyway defense kind of came up, the main defense in this case has been, until the trial started, that it was a mistake, this action error, that I just grabbed the taser when I meant, excuse me, I grabbed my gun when I meant to grab my taser. And that takes two people to make that argument. The expert to say what action error is, but that expert can't say that Potter was going through that. Only Potter can say that. And so she has to take the stand to put the second half in. Otherwise, it's mere speculation that this action error applies to this case. So they will again try to narrow that scope. They'll try to keep her just within that box.
And Marsh, give us a little insight here. I mean, when you're prepping your attorneys or when you're prepping your clients to testify, you know, based upon mock trials or focus groups, how well they're going to perform. And I have to believe that Earl and Paul have tested her in front of a mock jury, and they know she will perform well.
Yeah, maybe not a mock jury, Tim, but yes, something along that line. Absolutely. They have practiced that with him. And you violated your code, and you pledged to be the most, what was it called? Cautious. I wrote down the phrase before, whatever the phrase was they had in their book about even under the heat of fire, being cautious, courageous, calm. I think that's what it was. That you use courageous, calm, and control yourself. And you pledged to, save lives. I would expect she may well cry at that point on the stand, which, as a defense lawyer, that's not all bad.
All right, Marsh Hallberg, thanks for your insight here. We're going to be coming back to you probably throughout the day. Thanks so much for joining us here during the noon hour. Just to let our viewers know, we have just begun here the afternoon lunch break. That's going to go to about 1:45 Central Time for those of you who are watching across different time zones here. And what we're going to do now for about the next 50 minutes is take you back to the testimony starting today with Commander Garrick Flesland, and he's with the Brooklyn Center Police Department. Interesting background on him that you're going to learn about, because he does not come to this profession going up the normal route by going to law enforcement school. He's a Navy veteran and has his Bachelor of Science degree in applied physics that he used in the nuclear Navy. So he comes to it from a different point of view and a different background, but he's all about public service, as you will hear him testify here today, and that's why he wanted to become a police officer. So let's take you back to the opening witness today in trial this morning, in court this morning, up in the Hennepin County Government Center. Commander Garrick Flesland, let's join him now.
Do you know Kim Potter?
I do.
And how did you get to know Kim Potter?
We were co-workers. She was employed at the police department when I was hired.
How long have you known her?
Since I started working in 2000.
And were there times when you would have been then her supervisor?
There was a few brief periods where I was her sergeant.
Explain why. Or when those periods were, trying to understand why you would have been brief periods as your supervisor.
We end up juggling responsibilities and roles sometimes as people leave. She was a day watch officer for most of the time that I was there. She had a different day watch sergeant. When he retired, we shuffled positions a little bit, and I was the day watch sergeant for a brief period
So really just as schedules or shifts went.
Yes.
Turning your attention to the investigation of this matter, did you play some role in the follow-up investigation?
Yes.
And were you requested to provide certain documents as part of the investigation?
Yes, sir, I was.
And who requested that assistance?
Bureau of Criminal Apprehension.
And as a commander, are you familiar with sort of the ways that records are stored at the Brooklyn Center Police Department?
Generally, yes.
And how to access them?
Yes.
And were you asked to provide training records relative to Ms. Potter?
Yes, I was.
And were you also asked to provide personnel records with regard to Ms. Potter?
Yes.
And were you able to do that?
Yes.
Either on your own or with the assistance of others, I assume?
I got some of them myself, but primarily I coordinated the efforts of others within the department.
And is it your understanding that the Brooklyn Center Police Department has a record retention policy?
Yes.
And so your department may not have records going back the entire length of Ms. Potter's career?
Correct.
And that, and as well with training records, training or attendance at training is kept track of by the department. Is that true?
Yes.
Is that required by the licensing authority, the post board?
I guess I don't know specifically what post board requires that we submit, but we do have to track whether or not our staff is receiving their continuing education in specific topics.
And does the Brooklyn Center Police Department provide training on its own for its officers?
Yes, we do.
And do you also allow officers to train outside the department?
We do.
Can you just kind of describe what that would be, what kinds of things that might entail? The outside training?
I guess I'm thinking two different things right now. I'm thinking maybe there's an outside vendor that's offering some kind of training that we will send our officers to. And I'm also aware of some of our officers obtaining training on their own. They go to their own class that they pay for and arrange on their own.
Yeah, that's a much better way of explaining what I was trying to ask. So they can go outside the department to get training if they can find the right program or want to do it.
Yes.
But otherwise, you try to provide enough training at Brooklyn Center for the officers to meet their requirements?
We've always provided more than enough training to satisfy the post requirements, yes.
Since becoming a commander, have you had a role in overseeing the provision of training to officers in the department?
Yes.
Can you describe that for the jury, please?
I've had kind of a broad stroke over the training as far as just monitoring that it is taking place, that everyone is satisfying the requirements. I'm not an actual trainer. I've got people that specialize in that and have been trained in that. I really just kind of monitor that it's getting done, that the training we're providing is accurate, is within best practices, continues to evolve as laws change, as technologies change, as experiences change.
Do you supervise those trainers? Does that make sense?
Sure. I oversee. I'm accountable to the chief to make sure that the training takes place and is appropriate.
In that way, in that capacity, do you work with the trainers with regard to the training they're doing?
Yes, not necessarily the nuts and bolts of exactly what's going to take place, but I get an overview of what the plan is, what the objectives are, what the process is going to be, and ultimately I have the final say on if that's what we're going to proceed with or not.
So probably the better question for me to have asked was, do you review lesson plans, materials that are going to be provided for training?
Yes.
And in that capacity, do you interact with the trainers?
Yes.
And do you also have to go through that training?
I do.
So some days you may sit through a training that you already had reviewed to make sure it was a good training.
Yes.
I want to turn your attention now to Brooklyn Center Police Department policies. Does the Brooklyn Center Police Department have a policy manual?
We do.
And does that contain specific policies within that manual?
Yes, it's a variety of policies.
Why do you have a variety of policies for police officers?
State law requires that we have certain policies. There's I'll call it a small set of policies that we are mandated to have. I think if you're going to run a business, you need to have a collection of policies. It helps establish standards. It communicates expectations. And when running a business, it really helps drive us towards consistency as far as how our officers are going to carry out their tasks.
And are the officers, are these written policies?
They are.
And are officers required to know them?
Yes.
Are they required to follow them?
Yes.
And how does Brooklyn Center come about having these written policies? Where do they get them from to start?
Our policies have evolved over time. Right now, we use a system called Lexipol. It's a national system or a national company. I think we transitioned to them spring of 2014-ish. It's a company that's used by, I believe, over 8,000 agencies across the country. They suggest policies for us based on state law, federal law, changes in state or federal law, changes in case law, evolution of best practices, new technologies. And so they're constantly tweaking the policies, and what they do then is provide input or suggestions, recommendations to us. Ultimately, it's our decision what we're going to incorporate, what we're not going to incorporate. Obviously, we incorporate the things that are in compliance with changes in law or best practices. And so that's how we have really moved forward with our policies in the last 6 years.
And so it sounds like, if I can just make sure I understand, you get a standard sort of from Lexipol. You see if it needs to be altered for Brooklyn Center purposes.
Yes, they provide recommendations or changes to our current policy based on changes, a variety of changes, and then we ultimately make the decision what we're going to incorporate, if we're going to change it, if we're going to take it as is. And sometimes it involves a dialogue back and forth with the lawyers and attorneys with Lexipol to make sure that we are establishing the policy that we're comfortable with and is in compliance with a variety of requirements.
And have you been involved in that process of making adjustments to policy?
Yes.
And just, I guess, to help us all out, how do you spell Lexipol?
Lexipol.
And are there, on occasions, changes made to the policies?
Yes.
And is there a way that those changes are recorded by the department, like when they're made?
Yes.
And can you explain that to the jurors, please?
Although we can print out our policy manual, it's, I think last time I checked it was about 700 pages. It's extensive. The primary way we access it through is a web-based portal online where we can go in, review a policy. If there's a new policy or change, it will get a notice sent out to the staff via email. Each staff member has a unique login, username and password. They log in, they'll be able to review that update or change to the policy, and then they acknowledge electronically by a couple of clicks on the computer, and then it's documented. And then in administration, I can go back and audit that at any point to see when policies were released and when they were acknowledged by staff.
So this program keeps track of when the change was put out?
Yes, I'll call it when it was published or when it was released.
And released to whom?
To our department.
Okay. And in what ways are those policy changes communicated to the officers?
They'll always come out via email, a notice, an automated notice by Lexipol, but then we generally will also let everyone know, remind everyone. More significant policies, we'll have sergeants review them with the staff at roll call or at a meeting.
And so does this program then record in some way that if each individual officer has acknowledged the change?
It does.
And how is that done? How do they make that acknowledgement?
One or two boxes they have to click at the bottom of the policy on the screen.
And they do that remotely from a computer?
From a computer once they've logged in with a unique username and password.
And when there is a new policy change, are they required to acknowledge it?
Yes.
And then expected to know it?
Yes.
Now, you indicated, I believe, that you have access to the program that keeps track of the changes and the acknowledgements by the officers, correct?
Yes, it's the same program. It's just my credentials give me access to different parts of the program that other staff doesn't have.
And as a part of this case, were you asked to go in and audit the changes to policies and when Officer Potter, at the time, acknowledged them?
I was.
And does that produce then, I'll just call it a spreadsheet of those policies, dates?
Yes.
And would it assist your testimony today to have a copy of that spreadsheet with you there on the stand?
It would.
And do you have a copy there with you?
I believe I do.
And so, Your Honor, I'd ask that the witness be allowed to have that there to refresh his recollection about those specific dates as we go through the individual policies.
You have my permission.
Thank you.
Now, I want to draw your attention to specific policies of the Brooklyn Center Police Department. And so at this time, Your Honor, what I understand is subject to stipulation by the defense. I would offer Exhibit 336.
And 336
It's already into evidence, is that correct?
No, Your Honor, I'm saying that defense counsel told us they were stipulating to our exhibits.
Okay. 336 will be in evidence.
And if we can,
If you need
and
to.
Now, I'm going to show you Exhibit 336 on the monitors there. Can you tell us what part of the Brooklyn Center Police Department policy manual this is?
This is one of the first pages that just documents the law enforcement code of ethics.
And why is this the very first page?
It's important to establish standards and expectations.
And the first line, which I will, if I'm technically savvy enough, highlight for you. You see this line here?
Yes.
What does that mean? First of all, read it to the jury if you would and tell us what it means to you as a police officer.
As a law enforcement officer, my fundamental duty is to serve the community.
Why is that there in the first line of the Code of Ethics?
I believe that's the core of what we do, is we serve and protect.
And I want to go down to the second paragraph. The second line starts with, "I will maintain." Can you read that sentence for the jurors, please?
I will maintain courageous calm in the face of danger, scorn, or ridicule, develop self-restraint, and to be constantly mindful of the welfare of others.
Why are those terms there?
It's a difficult job at times, law enforcement, and we need to continue to strive to be our best.
In the third paragraph down, it starts with, "I will enforce the law courteously and appropriately, without fear or favor, malice or ill will, never employing necessary force or abuse." Why is that in this policy, that language there?
Objective is human, it's obviously it's there. It's irrelevant. It's a policy. Why it's there is irrelevant.
All right, counsel, are you going to go through this line by line, or?
Some of them, Your Honor, yes, because I don't know if you want me to fully respond, but it is relevant from this commander's perspective and other
Can we
issues.
have a sidebar, please? All right, counsel, you may continue.
So why is it that this unnecessary force language or abuse is right in the Code of Ethics?
Force is significant if we use, and we don't want to use unnecessary force.
In the next line, it talks about the badge of my office as a symbol of public faith. How do you see that fitting in, that language, with your role as a police officer?
I think police officers have an incredibly important role in society. There's statutory requirements or statutory limitations, but I think there is a very special social contract that exists between police officers and the community. Police officers are an extremely forward-facing arm of the government, and it's a special role and relationship we have with society.
You're wearing your badge today, correct?
Yes.
What does it mean when you put that badge on in the morning to you?
It's a reminder that it was given to me by the public to go serve and protect.
The next paragraph down starts with, "I know that I am alone responsible for my own standard of professional performance." What does that language mean to you?
I've been trained, I have tools, I have an education, but ultimately I have to go out there and perform well and do my job.
Your Honor, could I ask for a standing objection?
May I have a standing objection, which I'm overruling.
And Commander Flesland, as a police officer for the City of Brooklyn Center, are you required to take an oath of office?
Yes.
I'm going to offer formally Exhibit 341 and understand subject to stipulation by defense for its admission.
341 is admitted.
And I will put this up on the screen, Exhibit 341. And Commander Flesland, this indicates upon employment, all employees shall be required to essentially take an oath, correct?
Yes.
Why are officers required to take an oath?
I assume legally there's some kind of requirement there, but I think more important, almost ceremoniously, it's a big deal. It's a special job that we have. This kind of shows it.
And when you started with the department, did you take an oath?
I did.
I am now going to offer Exhibit 355. No objection.
And that's been previously stipulated to, and it is in evidence.
And I'll have this put up on the screen for you. Can you see this?
Yes.
And can you describe for the jurors what this is?
It's a copy of the oath that Kim took when on February 27th of 1995.
And when you say Kim, who do you mean?
Kim Potter.
And so it looks like, comparing to the policy, maybe the language of the oath has changed over time.
Yes, our policies have changed and evolved over time.
But that is still this same oath required.
I believe it has the exact same meaning.
Now, this is taken on the first day of employment, correct? This oath?
Typically.
And at a ceremony?
Typically.
And but does the oath, the requirements of what's said in the oath, continue with an officer as they work throughout the department?
Yes.
And have there been changes made to that policy 102 regarding the oath of office?
Yes.
Can you tell the jurors when the last time was that the oath of office policy was revised?
October 31st of 2016.
And can you tell the jurors the last time or the next time that Officer Potter acknowledged receipt of that change?
August 14th of 2017.
When the department is considering hiring new officers, are there certain qualifications that they look for in candidates?
Yes.
You know, there are certain attributes that the department wants to have in new officers.
Yes.
And are those spelled out in policy as well?
Yes.
That's an expression of those interests that the department has in new candidates?
Yes.
And I'm going to offer Exhibit 349.
Exhibit 349.
That is not relevant, Your Honor.
All right. Exhibit 349 is what?
Is the recruitment and selection policy, Your Honor, that counsel told us previously they were stipulating to admission.
Stipulated a foundation. Only relevant.
All right. The objection is overruled. I'll let you continue. And Exhibit 349 is admitted.
I'm going to draw your attention then to what appears to be the fourth page of the policy. And I'll just draw your attention down, if you could zoom into 1000.3.4, the learning ability. And are these attributes that you want to have in an applicant even to be an officer in the department?
Yes.
And that would include, as it says, the ability to comprehend and retain information,
Yes.
to recall procedures, rules, and regulations,
Yes.
Laws and statutes and codes,
Yes.
to learn and apply what is learned,
Yes.
to apply the material tactics and procedures that are required of the position?
Yes.
Going to the next page, judgment under pressure. If you could zoom in a bit on that. You're looking for people with the ability to apply common sense during pressure situations.
Yes.
Why would that be important in a candidate?
Objective that is irrelevant, Your Honor.
The objection is overruled and you may answer.
I think that's a good quality to have in any employee.
Particularly officers of the law, is that important?
Objective that is leading.
The objection is overruled and you may answer.
Yes.
And the ability to make effective logical decisions under pressure?
Yes.
Does the department recognize that officers sometimes have to make decisions under pressure?
Yes.
So in dealing with new candidates, it's something the department wants to look for, the ability to do that?
Yes.
This policy 1000 recruitment, can you tell the jurors when the last time there was a revision to that policy?
August 17th of 2020.
And when did Ms. Potter acknowledge the changes to that policy?
That same day, August 17th of 2020.
So as of August 17th, she was aware of what's in that policy as the jurors have seen it today.
Yes.
And does the Brooklyn Center Police Department expect officers to maintain appropriate conduct when they're on duty?
Yes.
And does the department have a policy on fitness for duty?
Yes.
And I'm going to offer Your Honor Exhibit 351, which is the policy on fitness for duty.
Exhibit 351 will be admitted.
And I'll have that put up on the screen, please. And if we can zoom in on the first paragraph at the top. So it says that all officers are required to be free from any physical, emotional, or mental condition that might adversely affect the exercise of peace officer duties. Why is that a part of the fitness for duty?
We want our officers to be in a good place when they're working. We want them to be ready to execute a very difficult job.
When you are working as a peace officer, is that something you think about when you start your shift?
Sure, maybe not real consciously, but there's been days that I've called in sick if I didn't feel like I could do the job.
And can you tell us the most recent version of this that was sent out to officers?
Most recent one of this policy was September 1st of 2015.
And when did then Officer Potter acknowledge receipt of that?
October 7th of 2015.
Are officers expected to conduct themselves in ways that are consistent with the law and with these policies?
Yes.
If they do not, is there a potential for review of their actions and potential administrative or other consequences?
Sure, there's a variety of things that could result from that.
And is there a policy about that as well?
Yes.
Your Honor, I would offer Exhibit 343, which is the conduct policy.
343 will be admitted into evidence.
put that up, please. I ask you to go to the second page, please. Zoom in on the paragraph that starts with employees. What we just talked about is that contained there in that paragraph, that they are expected to follow all applicable laws, ordinances, rules.
Yes.
And would that include policies of the department?
Yes.
And paragraph C, paragraph G, these are circumstances where an officer could face discipline for violations of policy or law.
Yes, there are examples from a lengthy list of things that could.
And C is failure to follow instructions contained in department manuals or city manuals.
Correct.
This policy, 319, the conduct policy, can you tell the jurors last time it was sent out to employees?
September 17th of 2019.
And when did then Officer Potter acknowledge receipt of that?
October 27th of 2019.
Now, you mentioned that police officers have authority to enforce the law, and sometimes the requirement to enforce the law, right?
Yes.
Are they also provided discretion in how they perform their jobs?
Some, yes.
And is that included in the law enforcement authority policy?
Yes.
Your Honor, I offer Exhibit 340, which is the law enforcement authority policy.
340 will be admitted into evidence.
Can you go to the second page, please? Here the policy is listed, the policy behind this policy is listed at the very end, correct? If you could scroll down to the bottom.
Yes.
So I'm going to highlight that last paragraph that starts with while. Can you read that to the jurors, please?
While this department recognizes the power of peace officers to make arrests and take other enforcement action, officers are encouraged to use sound discretion in the enforcement of the law. This department does not tolerate abuse of law enforcement authority.
Earlier, in response to my question, you said some discretion. Is that an expression of this within policy that officers are given some discretion?
Yes.
Can you tell the jurors when the last time this policy was sent out to officers?
October 15th of 2019.
And when did then Officer Potter acknowledge it?
October 27th of 2019.
Now, Commander Flesland, police officers are allowed to use of force, correct?
Yes.
And is that regulated, shall we say, somewhat by state statute?
Yes.
And does the department also have a policy on the use of force?
We've got several policies that address use of force.
And the use of force policy in particular, is it to be consistent with state law?
Yes.
And is it intended to comply with state law?
Yes. In some areas, I think it may actually be more restrictive than state law, but.
And that's something a department can choose to do?
Yes.
And so it is sort of encapsulates state law, but maybe a step further.
Yes.
Yeah, I would offer Exhibit 333, the use of force policy.
333 will be admitted into evidence.
Ask you to put that up, please. I'm going to draw your attention to the first paragraph of this document. And this is an expression of the basic premise, the reasonable use of force.
Yes.
And it indicates that this policy is guidelines for the reasonable application of force, but also other things like control devices and conducted energy device policies, correct?
Yes.
Now, the jury may already know this, but what is a conducted energy device? Is it a fancy name for something else?
We have a taser that is that device that we use.
So this second paragraph, why does it mention also the control devices and conducted energy device policies?
I think this introduction is trying to get into that there needs to be reasonableness in force that's applied. It also recognizes that I don't believe there is any set of policies that could really address every situation that a peace officer will encounter.
Is the use of a taser a use of force?
Yes.
And so is there a separate taser policy?
There is.
And is this paragraph also, does it indicate whether an officer is supposed to incorporate both of those? Does that make sense? The taser policy and the use of force policy?
Yes, I would almost say that this policy 300 is an overarching umbrella that covers all use of force, and then within our policy manual, we'll get more specific on some of the tools and tactics and techniques.
Okay. And if you would scroll down to the bottom of the page, please. The policy is listed here. Draw your attention to the first line. Use of force is a matter of critical concern both to the public and the law enforcement community. Can you explain, in your mind, why that is a matter of critical concern?
Not many jobs or professions or careers are you authorized and mandated in times to use force. It's a significant reach of the government.
And so that's what's critical about it, right? I mean,
use of force is significant, and it's going to play into any kind of ongoing relationship between the police or the government and the community and society. This, I think, just tries to signal how critical it can be.
Now, the next paragraph talks about officers having an understanding and appreciation for their authority and limitations. Is that true?
Yes.
Why?
Peace officers are in a unique role. We've got a unique set of responsibilities, tasks, mandates, and I want our officers to always be aware of that special position, that special job that they have.
And then I would ask you to scroll to the next page. Top paragraph, the policy continues. What is that first line about?
The Brooklyn Center Police Department recognizes and respects the value of all human life and dignity without prejudice to anyone.
And so the second sentence appears to acknowledge the ability to use force.
Vesting officers with the authority to use reasonable force and to protect the public welfare requires monitoring, evaluation, and a careful balancing of all interests.
What interests are being brought up there?
I think essentially all interests. Again, it just speaks to the unique relationship between law enforcement and the community.
Now, I'm not going to spend a lot of time on teaching the application of force with you, but I do want to just touch on a couple areas. So if we could scroll down to 300.3. Fair to say that this is the basic statement about the amount of force that a police officer can use.
Yes.
So in the first line, the amount of force that reasonably appears necessary given the facts and circumstances perceived by the officer at the time to accomplish a legitimate law enforcement purpose.
Yes.
And from there are a lot of other provisions in the policy, but is that the basic explanation?
Yes, that's, I'll call it foundational, is any force used should only be reasonable.
And we see the second paragraph talks about judged from the perspective of a reasonable officer on the scene at the time, correct?
Yes.
And the officers have to make quick decisions sometimes.
Yes.
And in evolving and changing situations, correct?
Yes, the real world changes constantly.
And are your officers expected to take those things into consideration when using force?
We expect them to make good decisions using new information that becomes known to them.
And the third paragraph there, I think the first line is something you've already referred to. It's hard to predict every factual situation, right?
Yes.
But what's the last line of that paragraph?
Officers are entrusted to use well-reasoned discretion in determining the appropriate use of force in each incident.
Now, as long as we're here, please scroll down to 300.3.1. That's an acknowledgement that officers have the authority to make a lawful arrest, correct?
Yes.
And that would include, for instance, on a warrant.
An arrest warrant, yes.
And if we can scroll down to 300.3.2, this lists the factors that could go into determining the reasonable use of force, correct?
Yes.
And is it your belief that this is consistent with constitutional and state law?
Judge, I object to that as a senior witness and not qualified to give that opinion.
Okay. Do you want to lay additional foundation, counsel?
Sure. In approving these policies or being part of that process, have you become familiar with the constitutional and state law standards for the factors used to determine reasonable force?
Generally, yes. Generally, yes.
And have you also learned those through training?
Yes.
And you've reviewed this policy yourself before today?
Yes.
And are these the kinds of factors that go into determining the reasonableness of force that's used?
I believe so, yes.
And would you expect officers in your department to take these things into consideration in deciding whether to use force or what force to use?
When determining how much force, yes.
And one of those is the immediacy of and severity of a threat to officers.
Yes.
And if you could scroll down, please, to the next page. The seriousness of the suspected offense, another one of those factors.
Yes, sir.
Potential injury to officers, suspects, and others is one of those.
Yes.
Also the risk and reasonably foreseeable consequences of escape.
Correct.
As well as the apparent need for immediate control of the individual.
Yes.
And if you could scroll down to the next page to 300.4. And does the policy also speak to the use of deadly force?
It does.
And is there also state law describing the use of deadly force.
There is, yes.
Is that in fact actually cited right here in the policy?
Yes.
And so is it your belief that the policy here is consistent with state law?
Yes.
Just below that is a provision on moving vehicles, correct?
Correct.
And why does the use of force policy have a separate section on moving vehicles?
I guess I can't specifically say why it's in this policy and not another policy, but when we look more at 300.4, you're going to see some reference to deadly force.
Okay, so let's scroll down to the next page and explain to the jury what you mean.
We wanted to articulate here that shooting at a moving vehicle or from a moving vehicle is significant. When, as the policy outlines, when feasible, officers take reasonable steps to move out of the path of an approaching vehicle instead of discharging their vehicle at a vehicle or any of its occupants. An officer should only discharge a firearm at a moving vehicle or its occupants when the officer reasonably believes there are no other reasonable means available to avert the imminent threat of the vehicle or of deadly force other than the vehicle is directed at the officer or others. We want to discourage officers from being in a position where they could be struck by a moving vehicle, but yet we never want to take away the ability for an officer to defend him or herself or another.
Why do you want to discourage shooting at the occupants of a vehicle? Of a moving vehicle?
Moving vehicle.
Okay. All right. Excuse me. Mr. Gray, would you please ask to have a sidebar instead of doing talking objections? All you have to do is ask sidebar, and I'll do that. Are you done? I think he corrected himself, and he now, Mr. Frank, you are corrected, correct?
I don't know if the court heard me, but while he was objecting, I was correcting myself, attempting to. So my question is, why do you want to discourage shooting at occupants of a moving vehicle?
If it's to stop the vehicle, my understanding is that's rarely effective.
If you were to injure in some way by shooting the driver of the vehicle, what could happen?
A variety of things could happen.
Like what?
Judge, I object to this as well under Rule 403.
The objection is overruled.
The vehicle could strike something or somebody.
I'm going to ask to scroll down to 300.8. Does the policy speak to training?
Yes.
And does it require that officers be trained on the use of force policies and law?
It does.
And how often do they have to be trained on that?
At least annually.
And do you believe that that happens at the Brooklyn Center Police Department?
Yes.
This use of force policy, can you tell the jurors when the last time it was sent out to officers?
December 8th of 2020.
And the last time that then Officer Potter acknowledged it?
December 29th of 2020.
Separate from use of force, is there a separate policy on firearms?
There is, yes.
And I'm going to offer Exhibit 306, Your Honor, which is the policy on firearms.
306 will be
And, oops, my mistake. I got the wrong exhibit number. 342, I'm sorry.
342 will be admitted.
It's policy 306, correct? Do officers carry a firearm every day when they're on the job?
unless they're on light duty or some kind of administrative detail.
Yeah, I should have been more specific. When they go out on the street, do they carry a firearm?
Yes.
And so this policy, drawing your attention to the 306.1.1, so they are required to complete departmental training regarding the use of force and deadly force and firearms before being authorized to do that, to carry it every day, correct?
Yes.
And does your department provide that training?
Yes.
And how often is firearms training provided?
Ideally quarterly. At a minimum, everyone will qualify with their firearms once a year, and then we try and incorporate additional firearms related training throughout the year.
And when you say qualify, what does that mean?
There's a course of fire, specific distances, some time frames, some positions and orientations you're shooting from. It's a qualification. It's a pass or fail evolution.
So officers are required to fire their firearms?
Yes.
And at least annually?
Yes.
And that means having them in their holster and drawing them and using them?
Yes.
And they're, I don't want to say graded, that seems a little elementary, but...
They're evaluated.
And if we could scroll down to 306.5. Draw your attention to the first line of that paragraph or that section. What does it say?
Members shall not unnecessarily display or handle any firearm.
And I actually meant the sentence before that first, but...
Members shall maintain the highest level of safety when handling firearms and shall consider the following.
And then not to unnecessarily display or handle. Correct?
Yes.
As one of many reasons, but you expect officers to have the highest level of safety?
Yes.
Is that part of firearms training and how to safely handle firearms?
Yes.
We see a lot of references in the training to low light training. Can you describe for the jury what that means?
When low light is referenced in the policies, it's getting at either at night or maybe in a building without lights on, basically in the dark. Post mandates are part of the annual firearms qualification, also includes some training in low light and inclement weather.
The reality of police work, right?
Especially in Minnesota, yes.
Yes. So that's all part of the firearms training, those differing conditions.
Yes.
And can you tell the jurors when the last time this firearms policy was sent out to officers?
September 7th of 2017.
And when did then Officer Potter acknowledge it?
October 9th of 2017.
Has the department incorporated a policy on vehicle pursuits?
Yes.
And just to, can you basically describe what's covered by the vehicle pursuit policy? What kind of conduct are we talking about?
When officers may engage in pursuing a vehicle, a car chase, what types of situations that could be warranted and authorized in, what types of situations it's not. It goes into a variety of factors that we ask the officers to constantly reevaluate during the course of a pursuit. on whether or not it should be continued or not. And it gets into some tactics.
Your Honor, I would offer Exhibit 338, which is the vehicle pursuit policy.
338 will be admitted into evidence.
I'm going to draw your attention to the second paragraph, the philosophy paragraph. You see the second line starts with a sentence with "in recognizing." Can you describe for the jurors that language there?
In recognizing the risk to public safety created by vehicle pursuits, no officer or supervisor shall be criticized or disciplined for deciding not to engage in a vehicle pursuit.
Hello everyone, Tim Blotz here in the Fox 9 studios, welcoming you back to our coverage of the Kim Potter trial and the manslaughter trial where she has pleaded not guilty in the death of Daunte Wright from the traffic stop from last April. You've just been watching during the lunch break Garrett Flesland, a commander with the Brooklyn Center Police Department. He was on the stand this morning. We are now just back from our lunch break this afternoon where we are expecting on this time a use of force expert from Brooklyn Center Police Department to take the witness stand. Let's return you now back to the courtroom live for the streaming coverage. Here's Judge Regina Chu.
Okay, please be seated. Oops. Okay. Please be seated. The state may call its next witness.
Thank you, Your Honor. The state would call Sergeant Mike Peterson to the stand.
Okay, Sergeant, please come forward. Stand behind the witness chair. And raise your right hand. Do you swear under penalty of perjury that you will truthfully answer questions pertaining to this case?
I do.
Please have a seat. And then state your full name and spell it.
Can I take my mask off?
Yes, take your mask off.
Sergeant Mike Peterson, M-I-K-E-P-E-T-E-R-S-O-N.
All right, Sergeant, the court reporter is taking everything down. Yes or no answers, no shaking of your head, no or wait until the question's finished before you answer so that two people are talking at a time. If you don't understand a question, please let the lawyer know. And finally, if an objection is made, stop talking. Don't answer it unless I tell you to. Okay? Counsel?
Thank you, Your Honor. Sergeant Peterson, can you tell us how you are currently employed?
I am currently a police sergeant at the City of Brooklyn Center.
And so are you a peace officer?
I'm a licensed peace officer in the state of Minnesota.
How long have you been licensed as a peace officer?
16 years.
Can you tell the jurors what your educational background is leading up to your work as a police officer?
Yes. I obtained a 4-year degree from Metropolitan State University in law enforcement. During that time, I completed my practical skills, which allowed me to take the licensure test, which I passed, and then was hired by the City of Brooklyn Center as a police officer.
So, when did you complete your education at Metro State?
2005.
And when did you complete the skills?
2005.
And do you recall when you obtained your license?
I would have been in late August, early September of 2005.
And how long after that then did you become employed for the City of Brooklyn Center?
I was employed on September 12th, 2005.
Do you remember the date specifically?
I do.
Why?
It's relation to September 11th.
I see. And that was the day that you started? Did you get sworn in that day?
It's the day that I started my training. I don't remember when I specifically was sworn in.
Now, did you have any law enforcement related experience before being a licensed peace officer?
In 2004, I was hired by the City of Brooklyn Center as a community service officer and worked during that time while I was going through school until I was hired as a police officer.
So, community service officers are not sworn licensed officers, but they work for the department. Is that fair?
Correct.
Okay. And so you did that 2 years as you completed your education, your skills, and then applied with Brooklyn Center to be a police officer.
Correct.
And you got hired then, correct?
Yes.
And what were your first duties when you started?
Once I was through the field training, I was a patrol officer working the night shift.
Okay. And so that beat me to the question. You did work as in the field training program when you first started?
Yeah, when I first started, I was trained by senior officers in how to become a police officer.
And do you recall how long you were in that program, roughly?
Approximately 3.5 months is the program that we use.
When you started, you went on patrol, correct?
Correct.
So you're handling calls in the streets and whatever comes up, right?
Yes.
And how long did you do that?
Approximately 5 years until I received an assignment.
Okay, and what was that assignment?
The assignment there was I moved into our street crimes unit.
And how did that change your duties, what you did?
I was not bound to calls for service, so I didn't have to listen to dispatch to tell me to go to a specific thing. My job was more to analyze some of the problems in the city with the group that I was assigned into that unit with and try and solve those problems.
And how long did you do that?
Roughly 4 years, but I was in and out of patrol during that time as well. So it was 2 years in street crimes, but it took quite a while to get that 2 years in.
And why was that?
Staffing issues.
Okay. And at some point, did you get a promotion, for lack of a better term?
Years down the road, I was promoted to sergeant, yes.
Okay. Do you recall when it was that you became a sergeant?
I became a sergeant in 2018.
And is that what your current position is?
Correct.
When you became a sergeant, what was your role? What kind of sergeant, for what purpose?
I was a sergeant of patrol.
Okay, I think you said that, sorry. And so when you became a sergeant patrol, did you supervise a number of other officers?
I did. Initially, I was assigned to the night shift supervision.
So how many officers typically would you have under your supervision during a shift?
Anywhere between 5 and 8.
Now, at some point in your career with Brooklyn Center, did you get involved in training?
I did.
And when did you first really get involved in the training, in presenting training, not going to it?
2007 was when I was selected as a use of force instructor.
And when you say selected, who selected you?
The sergeant who is currently in charge of our training program.
And when you were selected for that, did you do some additional training to become a use of force instructor?
Over the years, I've been through numerous trainings to prepare me to become an instructor.
Okay. And if you could just kind of tell the jury, like over which years, and just kind of generally what that training means, or what it's like.
Well, every officer that we select for use of force instructor is slightly different. There's no set curriculum. When I was selected as an instructor, the first training that I went to is to become a Taser instructor. After I was able to show my skills and becoming an instructor for that, I then went to firearms instruction school, and that became my primary training method, where I trained in firearms. Eventually, I went through an arrest and control school and many other schools in the different disciplines that we teach our officers in.
And so was this a career move that you decided on, or was
Yes,
given
it's
to you?
something that I wanted to do.
Why?
I enjoy teaching. I have teaching kind of in my family. I wanted to make sure that the partners that I work with are some of the best trained officers in the state of Minnesota.
And why would that be important to you?
Selfishly, my own personal safety.
Okay. As a police officer, do you serve the community?
I do,
And is that a factor in why you wanted to do it?
of course.
Now, we have seen in some records and things the title of training sergeant. Is that your... Was that your title?
It's an ancillary title, yes. Additional duties on top of my other duties.
Yeah, and that's the thing I was going to ask. When you get involved in training, does that mean you don't have to do other work as much?
No, it's additional duties on top of becoming a patrol officer or whatever assignment you have at the time.
So, since 2007, when you became a use of force instructor, you continued to work as a patrol officer and now a sergeant.
Yes, through all of my assignments.
Currently, are you still involved in training as an instructor?
Yes.
And so who are your supervisors above you?
I couldn't hear the question.
Who are your supervisors above you? Like, who do you respond to? Or
I have several bosses. Commander Flesland is my boss in charge of training, and I also have a boss in charge of the patrol division.
Okay. And who is that?
Currently, Commander Flesland. Last year it was Acting Chief Grunig. At the time, Commander Grunig.
Okay. So if you would describe for the jurors, since you became let me back up a little. In 2007, you became a use and force instructor. And does that, or did that, include many different kinds of force that an officer could use? Horribly worded question. Let me try over.
Thank you.
We think of use of force as maybe pulling a gun, punching somebody. When you're a use of force instructor, you talked about taser and a firearm, but is it all kinds of force that an officer might use?
Yes.
And at some point, did you sort of take on a supervisory role in Brooklyn Center trainings for police officers?
An informal leader role amongst the other instructors, yes.
Okay. How many use of force instructors does the department typically have?
We try to have somewhere between 6 and 10, but it fluctuates based on our staffing levels.
And so can you tell the jurors, how you get involved in, or what your role is in putting a training together?
Currently today?
Sure.
So as the training sergeant, I work with the instructors to develop a plan ahead of the training to go over some concepts that meet the requirements that we must train our officers in by state regulations. I give them a general idea of what we're thinking of doing, give them the ability to come up with some different plans that they want to implement the ideas, and then we write a lesson plan together. That lesson plan is submitted to the state post board for approval of training credits.
And why do you have to submit that to the post board for approval?
To show that we're meeting the obligations that the state has put on us for use of force training.
So as a licensed peace officer, are you required to get a certain number of hours of training to keep your license?
It's not a certain number of hours, but that you go through specific training each year for use of force.
And as the training sergeant, do you take on some responsibility for making sure that happens for the officers?
Yes.
How do you do that?
As we go through the year, we have what's called a post roster, where we know what officers attended those trainings, what post board elements are during those trainings, and I have a spreadsheet that I complete with who was there and what they have done through the year. And as we go through the year, we make sure that everyone gets the mandated training.
While there are, are there topics that are mandated to be part of training for peace officers in Minnesota?
Yes.
Okay. If I'm not using the right term, and let me know. Right, like firearm training, you have to have that a certain number of times?
So we're still talking about use of force instruction?
Correct.
Okay. Yes, there are several categories that are specific to different disciplines that we have to teach.
Disciplines is probably the word I should have used. And so even though there are these mandated disciplines, areas, does your department still have some discretion in how that is provided to individual officers?
Yes.
Has Brooklyn Center's police department's approach to providing training to officers changed in the years that you've been involved?
Yes.
How so? Explain that to the jury, would you please?
When I first was hired and became an instructor, many of our instructors were kind of trained only in specific disciplines, so they may only want to work in firearms or they may only want to work in Taser. And as the years went on, I felt that there's a need based on where our industry was going, and the best thing for our department and city is that our instructors were able to cross-train in the other platforms. So when an officer would move from one area where they're being trained to another area, we had some commonality of techniques.
And did that also influence how the actual classes were presented or the trainings were presented to the officers?
Yes.
How did that change?
We would train on those different disciplines, and then as much as we could during our trainings, we would bring those different disciplines into reality-based training.
And what do you mean by reality-based training?
Placing officers under scenarios that are as lifelike as possible in a training environment to provide them with alternatives to solve the scenario in front of them.
And why do you want to do it that way?
So that they have a vast array of responses that they can use when possibly presented with one of these scenarios out in the real world on the street.
So for instance, do you have just a Taser class one day where you deal only with Tasers?
We do.
But then when you do these scenarios, do they involve only Tasers?
No, we want them to be able to utilize as many of the platforms as they can.
And if you would just give the jury an idea of what, a scenario-based training is like.
Sure. It depends on the venue that we have at the time. If it's a building or if it's outside, or we may incorporate vehicles into it. I will bring in generally civilians, some of our civilian staff, to act as participants in it, whether they're victims or witnesses or suspects. And then we would have a script to play. The officer would not know anything about what we were doing until they were given a dispatched call to start that training session. And then they would have to go into the session and work their way through it.
And to the students, if you will, the officers, know what that scenario is about?
No.
And do the actors know what that scenario is about?
My role players?
Correct.
Yes.
And are they given strict direction on what to do and say?
I wouldn't say strict, but some guidelines and where I would like the direction of the scenario to go.
And so is it, then is it, what do you do after the scenario is run?
When we conclude the scenario, we come together as a group, the instructors, the officer, and then the role players, and we provide a debrief as much as possible. I try and have the officer debrief the situation on their own so that they can say what went well and what did not go well.
Part of those scenarios involve deciding what level of force to use?
Yes.
Could it involve what weapons to use?
Yes.
And when they do these, would they have a firearm on them?
A firearm that's not capable of firing live rounds. It's a training weapon.
And would they have a taser?
Yes, depending on the platform we're on at the time.
What do you mean by that?
Well, we've had different models of Taser product over the years, and some of them were better at doing training than others.
Okay. And would they have like a baton, chemical aerosols, the entire range of what they would wear out on the street?
Yeah, foam baton, inert chemicals, something that would not hurt somebody.
And how often, or what percentage of your trainings involve that type of scenario-based training?
What percentage of that specific training or throughout the year?
Yeah, like throughout the year.
Well, I try and incorporate it into all of our trainings as much as possible.
And so it's been about how long that you've been conducting trainings in that manner?
Well, we've conducted reality-based training for a really long time before I started, encompassing it into as many trainings as we can. Probably started in 2012 or 2013.
So if there is a training where you're not the actual instructor, you've still been familiar with the training plans and what's being taught in that class?
I will have reviewed the lesson plans, correct.
Are you a certified Taser instructor?
Yes.
And does that also mean that you're certified to carry a Taser?
Yes.
And can you describe for the jurors what it means to be a Taser instructor, certified Taser instructor?
How do I become a Taser instructor, or?
Well, yeah, explain to us how you become it and then what it allows you to do.
Okay, so Axon, which is the parent company that sells tasers, they host trainings throughout the country. They have what are called master instructors. Those master instructors hold those classes in every state across the country. You have to attend one of those classes. Their current curriculum has you doing an online study prior to going to a 8-hour practical day where you work with that instructor and other students.
And so what is the purpose of that? When you become a certified instructor, what does it allow you to do?
It allows me to teach end user in the Taser.
And when you say end user, what do you mean?
In our agency, it's a police officer, but it ultimately could be anybody who would be authorized to carry a Taser, a security guard at a hospital, a community service officer at another agency.
So when did you first become certified to carry a Taser?
In 2005.
And when did you become certified as an instructor?
2007.
And have you been a Taser instructor ever since then?
Yes.
How many Taser instructors does the department have now, or typically?
Currently we have 3, and we've gone with 3 for a really long time.
And when did you first start carrying a Taser for your job?
In 2005.
Does the Brooklyn Center Police Department have a policy on Tasers?
Yes.
And are you familiar with that policy?
Yes.
I'm going to show you and put up on the board Exhibit 334. Do you recognize the policy?
I do.
And the Taser policy requires that an officer receive training before carrying their Taser, correct?
Correct.
And certification as well, right?
Can you say that again?
Yeah, so the training leads to what we call a certification, correct?
Yep, the initial is a certification.
So, and then is there a recertification?
Yes.
So, assume everybody has sort of figured out that the certification is the first time, right?
Yes.
And then the recertification, how often does that have to happen?
Annually.
And this certification is issued by whom? You know what I mean? What is it? Who certifies you? Yes.
The instructor does on behalf of Taser for the organization.
Okay. So if you would describe for us, sort of in big picture, how Taser training is done.
That's a really broad question.
I'll try and narrow it down. So at the Brooklyn Center Police Department, you've been doing Taser training since at least 2007, correct?
Correct.
So maybe just kind of run us through, like, what does a student, an officer, go through when they attend a Taser training?
Okay, and so it's changed over the years, and the requirements are mandated by Taser themselves of what we have to do. They provide their curriculum, which is a PowerPoint. They tell us how many cartridges somebody would have to fire in order to be certified, and over the years they've set a certain number of hours that we have to spend doing Taser training. When we get into a recertification, because Tasers have been around for quite a while and we have been carrying them for a long time, we're able to do an annual update, which is, we know that a lot of this stuff has been hashed out for the past 10, 15 years. We're just going to give you the important information that we have right now about the product.
And so there is, for Taser training, some classroom instruction.
Yes.
That's basically the PowerPoint from Axon.
Yes.
And are there other materials that the students are given at those trainings?
There are.
What are those?
The policy is reviewed.
And which policy do you mean?
Policy 304.
So Brooklyn Center's policy.
Yes.
And that in a classroom type setting?
Yes.
And other documents that are provided to the students, the officers?
Provided or made available, yes.
And what is that?
I won't get their actual names correct, but there's law enforcement warnings, and then if somebody is going to take a voluntary exposure, meaning we use a Taser on them in a training scenario, some warnings about what that can do to that person, and they need to consent to having a Taser to be used on them during a training session.
And so there is, it sounds like, fair to say, this classroom segment of it.
Correct.
And is there something outside of the classroom that is done typically as well?
Yes.
Explain that, please.
The officer has to show proficiency in use of a Taser, and that is done by showing how to load a cartridge, how to arm a Taser, and how to deploy cartridges from the Taser.
And by deploy, you mean actually fire it?
Actually firing it, correct.
So proficiency means learn how to operate it.
Proficiency, yes, and show me that you know how to operate it.
Sort of hands-on.
Yes.
Does that include holstering, drawing, and deploying?
Typically, but not always.
And then are students then also sort of evaluated on their use of the Taser through the scenario-based training that you talked about before?
Yes.
This time, Your Honor, I'm going to offer Exhibit 369.
Any objection to 369? 369 is admitted into evidence, and you may show it.
Do you recognize what's depicted in this exhibit?
I do.
And can you describe for the jurors what that is?
This is a slide from the version 22 PowerPoint that Axon released for 2020.
And this talks about warnings that students have to acknowledge, correct?
Correct.
And so earlier when you testified about sort of the warnings that they have to be provided, that's what this slide is referring to, correct?
Correct.
And is this, well, to be fair, this is it says at the bottom, Axon. I think you said that's the parent company of Taser, correct?
Yes.
So this is would be a slide from one of the PowerPoints that you provide at classes.
Yes.
And so this requirement, the warning acknowledgement, has that been something that has been taught in Taser instruction for quite some time?
Yes.
Is this sort of a standard part of the Taser instruction?
Yes.
At this time, I'm going to offer, Your Honor, Exhibit 270.
Okay, 270 will be admitted.
Now, do you recognize what's depicted in Exhibit 270?
Yes.
And can you describe for the jury what this document is?
This document is provided by Taser International, Axon, which is the basis or guideline of the PowerPoint that is presented to the end user.
And so is this the warnings you were referring to earlier?
Yes.
And this is provided or made available to students, and this is what they are acknowledging that they have read and understand?
That's not my understanding.
What is your understanding?
When you say sign, what are they signing?
No, that's a very good point. I'm sorry. In the previous slide that we looked at, it talked about acknowledging the warnings, right?
Yes.
And are these the warnings that are provided to them?
Yes.
Okay. You looked hesitant.
Well, you said a signature, and on that previous slide, there's no signature. That's why I'm hesitant.
Yep, you're right. No, that was my mistake in using that term. The question really is this: the warnings that students are provided.
Yes.
And if we could just, there you go, that's it. The very top warning box indicates that the taser can temporarily incapacitate a target, correct?
Yes.
And sometimes there's a glare on that screen. You may have to...
Nope, I can see it. I
Okay.
wasn't sure where you were referring to, but I found it now.
I was going to say, very gently move that screen since none of us own it. And then the taser can cause death or serious injury, correct?
Yes.
And that person should obey all warnings, instructions, and all laws and comply with current training materials, right?
Yes.
And if we scroll down, the warning indicates that you should complete training first, correct? Do you see that there in number 1?
Yes. Sorry.
And to be candid, this one indicates it's effective May 19th of 2017, right?
Yes.
Is this form pretty consistent with the form of these warnings over many years?
Format, yes.
And this is sort of a summary of the information provided in the class instruction itself. Is that fair?
I would categorize as the PowerPoint as the summary of this document.
Very good. And so if we scroll down a little farther and onto the next page, keep going down if you would, please. Oops. At the top of that page, you will see preferred target areas, correct?
Yes.
And avoiding sensitive areas, correct?
Yes.
That's taught in the class as well, is that correct?
Yes.
And all right, you can narrow that down again, please. All right, so in the middle of this page, you'll see a box called secondary injury, correct?
Yes.
And this is a warning about secondary injuries from an uncontrolled movement or fall, correct?
Yes.
And then after that, below it, it goes on to explain that a person needs to, an operator needs to concern themselves with the person's location before using a taser, correct?
Yes.
And below that, there are some examples, and if we go to the top example on the next page, it talks about not to use a taser on a person who is operating or riding any mode of transportation, including a vehicle, correct?
Correct.
So that's one thing that they have to consider, correct?
Yes.
And then we'll go to the top of the next page, please. You'll see a warning box here with 3 separate warnings. And you see that the top one is confusing handgun with CEW. And just for the record, what does CEW mean?
Conducted energy weapon.
And is that a fancy name for taser?
Yes.
And so there's a paragraph here about confusing a handgun with a taser, correct?
Yes.
Has that been a part of your experience working with tasers throughout your career?
Yes.
As a topic that is taught and attention is paid to?
Yes.
And is that then something that is dealt with in taser training?
Yes.
And has it always been a part of taser training?
From the time I've been involved, yes.
At the bottom, under the black bar that says safety information, there's also a paragraph that taser may not work as intended, correct?
Correct.
And so operators have to think sometimes about whether it's going to accomplish its intended result?
Yes.
And if we go on to the next page, there's an acknowledgement there that CEWs are not precision-aimed weapons. Would you agree with that characterization?
I don't see it on the page, but I would
sorry.
agree with that.
Okay. So the user also has to consider that they may not hit their target even.
Yes.
And then, I'm sorry, one more thing I want to point out on the next page. The warning in the middle. Number 1, do you see that? What is this is a requirement that an officer safely perform a spark function test before each shift. Is that something that is taught as part of Taser training?
Yes.
Is that also required by Brooklyn Center policy?
Yes.
Bear with me just a second. We were talking before about the Taser policy, Brooklyn Center's policy. You are familiar with that?
Yes.
And when you teach a training class, you go over this policy with them?
We do.
Do you give them a copy, read it word for word? How do you teach it?
It depends on the training session. Sometimes we read it. Sometimes I read it. Sometimes I have the class read it, taking turns.
And can you go back to Exhibit 334, please? And about halfway down, there's a sentence that starts, members carrying the Taser. Do you see that?
Yes.
And is that a requirement for the spark test that we saw in the warnings? Same kind of thing.
Yes.
Right. And I asked you earlier about this notion of weapons confusion. Has that played a part in how the Taser is carried in Brooklyn Center?
Yes.
Can you explain that to the jury, please?
So our policy requires us to carry our Taser on the opposite side of our body from that which we carry our firearm.
And has that been policy since you've been carrying a Taser in Brooklyn Center?
Since I remember, yes.
Okay. Going back to the policy below that, it indicates that it shall be distinctly marked to differentiate it from the weapon, correct?
Correct.
And are there ways that it is distinctive from the firearm?
Yes.
How so?
Color is the main one for our agency that we use, but others in feel, weight.
And are there, well, let me ask you this way. There are Brooklyn Center Tasers are bright yellow, correct?
Correct.
Are there Tasers that are not bright yellow?
Yes.
Can you buy them in black?
Yes.
Has the department ever done that
Yes.
early on?
No.
Okay.
In error.
Okay. So sent them back?
Couldn't.
Really? How were you able to differentiate them then from the firearm?
It was easy when they were in a desk drawer and never came out of it.
Okay. Bad investment maybe, huh?
Yes.
Okay. Back to the policy, Exhibit 334. Section 304.4 talks about a verbal warning. Is that part of the training on Tasers as well?
Yes.
And what is the purpose of a verbal warning?
There are multiple.
Okay. Can you just describe them for the jury?
One is to alert your partners about your intended actions so that they know that the potential sound is that of a taser and not any other sound. The other is to give the person that you are intending to deploy a taser on a final opportunity to comply.
And so is that part of the training to always provide a verbal warning before using it, deploying it?
When they have a chance, yes.
Okay. And by when you have a chance, you're referring to time there?
Time, or for tactical purposes, it may be better to not tell the person or say, give them a warning.
Getting a little ahead of myself, but I'm going to offer at this time Exhibit 372. I'm offering Exhibit 372. Is there
an objection to 372? 372 will be admitted.
Do you kind of recognize where this slide is from?
I have seen it before.
Okay. Is this from Axon or Taser as well?
It's from a Taser PowerPoint, correct?
And so this talks about the decision on where to holster your Taser, correct?
Correct.
And one is support side, the other dominant side, correct? Does the potential for mistaking a firearm for a Taser appear on both sides of this slide?
Yes.
So I was asking you earlier, this is something that has informed practice and training in Brooklyn Center for quite a while?
Yes.
Even though an officer is required to carry their Taser on the opposite side of their weapon, correct?
Yes.
Do they have a choice about which direction they use it or holster it?
Yes.
And can you explain the two different choices there?
There's two different holster manufacturers that we currently use, and it depends on how the officer needs to get at the Taser as to which one that they prefer to choose.
And so what are the two choices that they can use?
So one is you would draw it out so that I'm right-handed, so my right hand would be grasping it and pulling it out. The other is you would be using my left hand, my support hand, to draw the Taser out and then press it out to the person.
You know what terminology you use for each one?
That I use?
Yeah.
I call one a rock draw and the other one is a straight draw.
Okay. So which one is the rock draw?
Rock draw would be where it rocks out of the holster and then it comes out, where a straight draw comes straight up out of the holster.
Okay. So you wear your Taser on your left side and you're right-handed?
Correct.
So you reach around to grab your Taser?
Yes.
Which draw is that?
I use a rock draw with my right hand.
Okay. And what's the rock part of it? I don't understand.
The Taser rocks out of the holster rather than coming straight up out of it, similar to a firearm has to come straight up out of a holster, be able to clear it. This, it rocks forward a little bit to get out of the safety, and then you can just pull it out of the holster.
When you have it in the other orientation, you still have to press a release on the holster?
There's still a safety release on it, yes.
And you still have to move it a certain direction before you pull it out?
More straight up.
Okay. Did you bring your Taser 7 with you today?
I did.
And I'm going to ask you to basically describe it for the jury. But before we do that, not a huge lesson in how a Taser works, but when a Taser is deployed, what is the intended effect that it should have on the body?
It is called neuromuscular incapacitation, and it's where the electricity interferes with the body's systems to engage all of the muscles into like a locked up scenario, and then also creates a little bit of pain.
And so it does this to the body how? You know what I mean? What comes out of the Taser that causes that?
Electricity.
And shoots 2 barbs, correct?
Correct.
And when you are deploying a Taser, is there a preferred way to make sure that that happens as it should, incapacitating neuromuscularly?
Well, we have our preferred target zones.
Okay, and what are those?
On the front of a person, you want to engage them below the rib cage, avoiding any sensitive areas. And then on the back, anywhere from the neck down. The back being the preferred target if it's available.
And Your Honor, I'm going to offer Exhibit 376.
Any objection to 376?
376 will be admitted.
I'm sorry, Your Honor, my notes are just horrible. But let's talk about this while we can. 376 is talking about authorized use, when to use it, correct?
No.
I'm sorry, what is Exhibit 376 about?
Well, it says CEW should not be used on individuals.
Right. And so this says it should not be used on individuals who are passively resisting and are not an immediate threat or flight risk, correct?
Correct.
And it has some other circumstances in which it should not be used.
Correct.
All right. Now, the second page of this also talks about the preferred target zones, correct? You can scroll down to the next page.
Yes.
And do you recognize this as a slide from a Taser PowerPoint?
Yes.
And so the green areas on the front are the preferred areas, correct?
Correct.
And the next page and on the back, the indication is to reduce cardiac risks, problems with the heart. Should target the back area, correct?
Yes.
And when you deploy a Taser, is there something that you want with regard to how far apart the probes are?
Yeah, the optimal spread between the 2 probes would be 12 inches.
And if you don't get that kind of spread, what happens?
If you're too close, you can end up with nothing more than what we call pain compliance. It does not induce neuromuscular incapacitation. If you get further than that, you still have a really good likelihood of getting neuromuscular incapacitation, but the chances of you getting both probes on somebody diminishes.
And I'm going to offer at this time, Your Honor, 374.
Any objection to 374?
No objection.
374 will be admitted.
and this is what I was referring to earlier. Is this part of training as well, and reflecting that warning that we talked about earlier, to not deploy a taser on somebody who is operating vehicle or machinery. Is that correct?
Yes.
All right, now I said I was going to ask you to show us your taser, and what I would like to do, Sergeant Peterson, if you would, and I'm going to offer Exhibit 370 and 371.
Any objections to 370 and 371? Those exhibits will be admitted into evidence.
And I would ask you to, put up 370, please. And do you recognize this as the basic Taser 7?
Yes.
Similar to the one you have today?
Yes.
And does this have a trigger?
Yes.
Does it have a safety switch?
Yes.
And a front sight?
Yes.
And if we go to 371, this is a close-up of the safety switch, correct?
Correct.
Can you describe for the jurors, how this safety switch works?
The safety is linked from the left side to the right side, so you cannot move it independently from side to side. When it is down, it is in a safe, unarmed position. When you push it up, it is now in an armed position, and it activates many internal logging features to happen.
And
members of the jury, I just want you to stand up. It's kind of late in the afternoon, and I think if you could just stand up and stretch your legs. Okay. All right, you may be seated. All right, I'm sorry, you may continue.
thank you. So, when you move the safety switch up, does it essentially turn on the taser?
Yes.
And what changes are visible in the taser then once the safety switch is moved up?
In our department, we have the lasers and the flashlight or illumination turned on.
And when you say lasers, how many lasers come out of it?
On a Taser 7-2.
And what is the purpose of those lasers?
To give the user a general idea of where the top probe and the bottom probe are going to go.
And the flashlight probably speaks for itself, right? Is that yes?
Yes.
And so when you do that, when you arm it, and is there also a screen in the back of the taser that provides some information?
Yes.
And that is visible to the person holding the taser?
It is.
It provides information about the operation of the taser?
The status of it.
Okay, status, good. Did previous models of the taser that your department used have a safety switch?
Yes.
Do you recall how far back the tasers were that had safety switches that you used?
Everything from the X26 and the X26P, which are the ones that I was trained in and how to use since 2005.
If we can go back to 370, please. I started out a while ago talking to you about the spark function test, is that right?
A function test, yes.
And policy requiring that be done every shift?
Should be done, yes.
And is the button that you use for that depicted here on Exhibit 370?
Yes.
Labeled arc switch?
Yes.
All right. You can probably take that now. What I would like to have you do, Sergeant Peterson, and if you want to stand up and show the jury, walk us through the process of how a spark function test, would be done at the beginning of a shift for an officer with the Taser 7. And then I'm going to ask you to operate the spark function test. Now, can that be done safely here in the courtroom?
Yes.
And so if you could, like I said, just walk us through the process and show the jury how that's done.
Okay. It's going to depend on the day. If I'm just coming on to shift, I may have to get some equipment out of our armory and then assign it to myself. Once I have done that, I may holster it, or I may just go right into my spark test. So I carry my Taser on my left side. I'm going to draw it. As I draw it, I'm going to press both arc switches, one on the left side, one on the right side at the same time. It now illuminates my CAD, tells me that I'm in a function test mode. I can then turn on my Taser. My CAD has changed colors. I know that it's now in a function test mode. And now I simply press my arc switch again. It runs through a 5-second spark test. While it's doing that on the CAD, it's counting 1, 2, 3, 4, 5. That's the duration of a cycle that we want somebody to end at. I check the status of it again, I disarm it, and I holster it.
Thank you. Now, before we move on, I want to just go back to the policy briefly. If we can go back to Exhibit 334. And I want to go to the second page, starting at use of the Taser device. Taser has limitations and restrictions, correct?
Yes.
And we've talked a little bit about those in general. And I assume those limitations and restrictions are part of Taser training, correct?
Yes.
And again, here at the bottom of that same paragraph, an awareness that the device may not achieve the intended results, correct?
Correct.
And that refers to may not achieve neuromuscular incapacitation, correct?
Correct.
And 304.5.1, the next paragraph, is Brooklyn Center's policy regarding the use of the Taser in circumstances in which it could be used, correct?
Correct.
And it talks about subject who is violent or physically resisting. Correct, is one of them?
Yes.
And the other is demonstrated by words or action an intent to be violent or to physically resist and appears to present potential harm to officers, himself, or others, correct?
Yes.
And then the sentence under that, mere flight without other known circumstances or factors is not good cause, correct?
Correct.
So that is one part of the policy that officers have to consider.
Yes.
Okay. The following paragraph, 304.5.2, special deployment considerations. Certain individuals, it should be avoided unless the totality of circumstances indicates, correct?
Correct.
And the last paragraph, F, is those who are in a position or activity that may result in collateral injury. And it references in the example paragraph operating vehicles, correct?
Correct.
So this is something that officers have to consider as well when deploying.
Yeah.
I'm sorry.
Yes.
And this is consistent with the training thing we looked at earlier.
The Taser training?
Yes.
Yes.
If you can go to the next page, 304.5.3 discusses targeting considerations there, correct?
Yes.
And that's consistent with the training that we talked about as well.
Yes.
On page 304.5.4, the following page, 304.9, is a repetition of the training requirement, correct? I think you have to go back up a page, yep. Right, they have to complete training before they can carry, correct?
Correct.
And then on the next page, the first full paragraph requires proficiency training. That's what we've already talked about.
Yes.
And below that, there's a reference to the training sergeant being responsible for, among other things, at trainings, a review of the policy, correct?
Yes.
A review of the use of force policy. Right?
Yes.
And that's the general use of force policy, correct?
Yes.
Is the use of a taser the use of force?
Can you repeat?
Is the use of a taser the use of force?
A use of force?
Yes.
Yes.
And training also requires performing reaction hand draws or cross draws to reduce the possibility of accidentally drawing and firing a firearm.
Correct.
So that's something that is, by policy, part of the training as well, correct?
Yes.
Okay, members of the jury, we're going to take our afternoon break, okay? So it'll be 20 minutes. Okay, officer, you may step down. Okay.
Welcome back, everyone. Tim Blotz here in the Fox 9 newsroom for our continuing streaming coverage of the trial against Kim Potter for the death of Daunte Wright in that traffic stop back on April 11th of this year. Joining me now is Paul Bloom, who's been reporting on this trial all along. The judge has taken a quick break here this afternoon. We've only been back about an hour and 15 minutes, and if you've been listening in, it would appear to me, Paul, that maybe some of the jurors have been drifting off. About 10 minutes ago, she took a break here in court, asking the jury to stand up and stretch their legs. And I'll be honest, I've covered a lot of courts in the past, a lot of trials in the past. I've never seen that happen. And now she just abruptly called a quick break here today. I get the impression, without being in the courtroom, there might be a little drifting going on there against in the middle of some rather tedious testimony about department policy.
Yeah, to steal a baseball analogy there, I kind of felt that was a seventh inning stretch there during the witness questioning. I think maybe hearing that taser, the spark test in there may have woken some people up, but certainly unusual, especially interrupting the middle of Matthew Frank's questioning. The prosecutor, while it may be tedious, maybe a little boring from afar, but Matthew Frank's, has a rhythm going, and he's asking his witness about policy he wants to go through, and then interrupted by the judge to get them to stand up. As you talk about dozing off, just one observation I had yesterday during my time in the courtroom where I could eyeball the jury across the room. I did note one of the jurors dozing off. He was struggling late in the morning. I noticed in the afternoon he had a Diet Coke with some caffeine in it on his jury desk. I did note also today in one of the pool notes that same juror was struggling to stay awake in the early morning session. So, judge is obviously cognizant of that. She wants this jury focused. They, of course, have big jobs to do, and they do have to consume all of this. And it is a lot. It's been emotional at times. It is heavy testimony. And obviously, the way the state is building the case requires some deep focus and attention, and that they are just building it very broadly. Here are our policies. Here is the oath. Here's what she's supposed to do. We learned yesterday she was not testing her taser every day. And that is department policy, to fire it up, both to make sure it's working. And I also think, although it hasn't really been testified to, it gives that officer the opportunity to feel it, to see how it comes out of that holster every day. And we've learned she did not follow that policy. Now, what I'll be watching for this afternoon is cross-examination for this police sergeant, because other officers who have testified, when pressed about the use of force at the scene, the defense is arguing it was an accident, it was a mistake, but they have argued under the facts that they knew it, that Officer Potter was authorized to use force. And I will now, a good time to bring in our legal analyst here, Marsh Hallberg Criminal Defense, a longtime criminal defense attorney, as well as a prosecutor. City Attorney of Edina, if I remember correctly. Marsh, thank you for joining us. And Marsh, I would just, I guess, start off with kind of just what we just witnessed in court, was this idea that the judge asked the jury to stand up, to stretch their legs, and then went into a break a few minutes later. I noted to Tim while you were joining us that, in some respects, she cut off Matt Frank in the middle of his rhythm of questioning. Is that just sort of a boring time in court, and that's something the judge needs to do from time to time?
Pretty common for them to have everybody stretch their legs. They'll even tell jurors when the trial starts that if you have a bad back or you have issues that you just need to address, you can certainly stand even during a trial, even while testimony is going on, if you just need to do it for physical reasons. So, let's be honest about this. This was kind of some of the boring stuff, right? I mean, it wasn't the most exciting stuff we've seen, but it's important in a sense to put it forward. But I think the concern we have here, Paul and Tim, is that just like we saw this morning, is that by the time the cross is done with this witness, we're going to think it's a defense witness. They're going to go into all the issues of use of force, that she's an excellent person, that she did all of her training, that granted she may have not tested the taser a few times, but in the long run, that's really not the core issue here. So I think it's going to be, at the end of the day, I think it's going to be a defense day, even though it's a state's day to present witnesses.
Well, Marsh, you just hit on something there that crossed my mind when they asked the officer here, the sergeant, to do the test on the taser. She's not being charged for not testing her taser. So how does that build into the foundation then of what the prosecution is trying to do?
Not much, and I think she did even test it, didn't she, Tim? The 2 days before this incident, she had tested it. I think it was days before that. So you do the same thing, by the way, when you go out on your test for when you're running radar for testing for speeding tickets. You go out on you have a log, you do that every time too. So it's not the only thing you kind of do as a daily check. I don't think it's worth much, really. I just don't. I guess trying to think where it's going, it shows a sloppiness by her and indifference. Kind of, I've done this a million times. I can be cavalier, and her cavalierness led to her grabbing the wrong handle, the wrong weapon.
Your thoughts there, Marsh. My quick takeaway, again, I know it's just a test, is it working that day, but also, as I mentioned to Tim, just the idea of handling it. I know we haven't necessarily heard that testimony, but it would give that officer, who doesn't, she's acknowledged she's never used her gun, she's never used her taser in the line of duty, just to give an officer the feel of pulling it each and every day and firing it up. And if you had done it a few hours before you make this traffic stop, maybe it's a little bit more familiar to you as opposed to this slip activity where up and then draws her gun. I have to believe at some point the state has a cop who is going to stand their ground on this idea of the use of force was justified in that moment. If anyone's going to do it, it's got to be Sergeant Peterson here, the use of force trainee. They know where Earl Grey is going. They have put him on the stand today. They didn't have to bring in more policy initiatives. I have to believe at some point a cop on cross-examination will stand up and sort of speak to maybe an excessive use of force in the field and in that moment. But you're convinced, Marsh, in the end, a guy will flip and we'll be talking about a defense witness by the end of this?
Not for this guy. I think, well, we'll see. I think the whole expert use of force person is a little different animal in that it's a paid expert. That's a little different. I think they'll end with that strong person. I think we're going to end probably with the state by tomorrow, don't you think? So they plan on that. And any experts you give also, you have to give a summary of their testimony. So the state and defense have to know what the other experts are going to conclude or tell. So the defense already knows that and they'll prepare for that. I think your last point was a really good one, Paul, that you and Tim had about some of the issues that she wasn't as familiar with it had she continued to use it every day. Potter will take the stand. We know that. There are going to be some hits she takes because they're going to go through this. Officer Potter isn't true. This is a different color. It's a different weight. It's in a different place on your belt. It's got this charge up time. It's got the 2 dots that appear, blah, blah, blah. It's going to go through all those. And despite all that, despite all your training, and despite your pledge to protect and serve, you still did this, didn't you? Right. So that's the kind of cross I expect.
Marsh, Tim here, getting along some of the line of questioning so far. My observation has been, and I'm curious to know yours, that Matthew Frank has been very careful in how he's questioning Sergeant Peterson with regards to the use of force policy as to not allow Earl Grey to go back on cross-examination to go over any of the sections to open him up to become an effective defense witness. What's your observation?
Just like we talked about, Tim, this morning about that, outside the scope, that a cross-examination can talk about topics that weren't covered on the direct examination. If you want to cover that topic with a witness, you have to recall them to do that. But again, it's a trial. It's not an evidence class. So I expect Mr. Grey or Mr. Ng to say to this witness something to the effect of, wouldn't you have shot this person anyway, or whatever it would have been, right? Some kind of question. It'll be objected to. Even if it's sustained and the person is not allowed to answer the question, the jury heard the question. And they know the defense wanted to ask that question of the witness, so they will score points for that, even if the answer doesn't come up. They've already got it out there through a couple of people.
So stand by to stand by is what you're saying.
Right.
Right? Yeah.
Exactly. That's kind of what fun may be the wrong word. We're dealing with people's lives, but the real challenge and excitement to be a trial lawyer is that you really have to think on your feet quickly. And it's a real challenging career.
And Marsh, I have a question. You kind of talked about the eventual cross-examination, the difficult questions Kim Potter will face. We haven't asked you this question. It was picked up on body camera. Those who've tuned in have certainly seen the body camera footage from the various angles of the officers at the Daunte Wright traffic stop. And in the moment, in the immediate aftermath, Kim Potter is heard on the video saying, "I am going to prison." At some point, she's going to be grilled on that. I've asked other experts about it. You're joining us for the first time during this trial. She's caught in the moment saying something like that. I would imagine she'll be grilled on that. You're a police officer. How did you know you're going to go to prison in the immediate aftermath? You knew you did something illegal. You knew you did something wrong. How worried are you in terms of that statement being uttered and that it's captured on body camera? Would you anticipate her having to dance around an answer on that topic?
That's one of those questions, Paul, that I would have asked my client many times over and over to practice my answer to that. And again, you can almost write it out exactly and you would work with her on it. And my answer, if I had it off the cuff right now, say what would be my answer I would like Officer Potter to say if I was her attorney, I would want her to say something like, I know what's going on in the world around us, and I'm afraid that people won't take the time to learn that my case is different from other cases that have gotten worldwide publicity. And everybody's going to jump to conclusion, and they're going to have their own thoughts and won't take the time to learn the facts.
What do you know Ruger did?
Marsh, I'm curious to know what direction do you think the questioning will take yet this afternoon of Sergeant Peterson?
Well, like I said, if you follow your thought, which is a good one, keep it simple, stupid, right? That you just narrow this down, that you've covered this, that it really shouldn't be much more than we've already covered. I think you deal with the facts are kind of out there. You finish it up with the use of force experts saying it was not a reasonable use, that you're trained to pressure situations to not react in the wrong way, that she did. That was reckless. It was intentional. It was negligence. It was very negligent, given all of her years of training and importance of the decision. And that's what they're going to hang it on. And they will argue that to a jury to bring it home at the end, that this isn't about whether Ms. Potter is a nice person. And it isn't about that the law is blind to that the court can factor those things into any sentencing, that this is about whether she committed a crime. And that's the angle they'll take.
As we kind of wrap up and we think we're getting close to the end of the state case here, I would just point out to our viewers, we do expect one last spark of life witness on the stand. Daunte Wright's dad has basically been waiting in the wings for his moment. There have been motions to the effect that he is not sequestered. He can be in the courtroom. I haven't seen much of him at the trial in the courtroom itself, but we do know the state did say in a motion that they expect him at the end of witness testimony, and thus when you kind of, we assess the case at all of these breaks, each and kind of plodding along, but at some point the case, you kind of look at it in its totality, which we kicked off the state case with the emotional testimony of mom, Katie Wright, Katie Bryant, if you will, on the witness stand, the emotion she brought to it, the loss of her son. And then my understanding is the state intends to bookend that testimony with dad yet to come. And that might give this jury a little bit of a kick after a couple of defeats on sort of police testimony. And I would just point that out. But in the end, when Aubrey Wright takes the stand, he'll very much be limited, right, Marsh, by law, by the way the courts work in terms of what he can testify to. He's going to just put a human emotion on the loss of his 20-year-old son, correct?
Yeah, and that's a really good way to put it, the bookends, because the state wants, like every case, right, you want to start and finish strongly. And in this case, that's going to be very emotional. He'll cry, he'll talk, they'll show us some very emotional pictures of Mr. Wright, and that'll be a real strong way to finish by him. And the general thought is, when I've done these trials, you don't mess with spark of life. You don't challenge somebody that's dead about being a good person or bad person. Now, this defense was very aggressive here and said that they want to put in a photograph, I think, of Mr. Wright holding a gun into a camera, right? Some picture that appeared on the internet somewhere. And they might have just put that in and said no further questions, because a lot of times you just don't ask any questions on spark of life. You let them, you take the hit on that and you go on. And that's where you try to counter that, just like I just talked about how the state will talk about, it doesn't matter whether this officer is a nice person or not. The same thing will be here, is that the defense can up in closing and say, Mr. Wright's life had value. He was loved by many. The loss is great, but that again is not a reason to convict Ms. Potter. So we'll just try to reverse that and to, take that emotion out of it.
And Marsh, before Daunte's father takes the stand, we fully expect there to be an expert witness or two to testify in this trial. Given what has happened to the prosecution today in terms of motions rulings and some of the testimonies so far, especially in the last day and a half here, how important are those expert witnesses going to be to the prosecution, and what is Matt Frank going to have to ask them to try and prove their case of first and second degree manslaughter here?
Tim, I think we all agree that so far the state has had a really difficult time trying to show that it wasn't reasonable to use a firearm, let alone a taser. So if she made the mistake, it's okay in the sense that she could have shot him anyway. So I think that state expert finally has to be the one who kind of comes in and say, look, I'm the expert on this. And they'll go through all the background and the training and why they deal with this in real life, these scenarios that have already been talked about today, trying to recreate the emotion of the moment. And he'll say that it wasn't reasonable. And he's, testified in other cases. He's a big expert. He's studied all these different treatises and other profiles of cases, all this basis that I have that other people don't have, and try to build credibility on that. Mm-hmm. But again, then we expect in the defense, right, we'll throw on their expert and I would get up and in a conversational way in closing go, you got two experts. One says it happened in a proper way, the other says it didn't. They kind of cancel each other out. Let's look at everything else.
But I think
in a tie, the defense wins.
I'm sorry, Paul, go ahead.
Oh, no, I didn't necessarily have a question. I would just ask Marsh at this point. I know we're kind of jumping ahead and kind of all over the place. With the state wrapping up its case, we think in the next day or so, my question is, you see it sometimes when the state's done, the defense will rise and ask the judge, I forget what it's exactly called, but basically a summary judgment that the state hasn't proved its case. It would be a very high bar to jump over, but you're not at the point where you think the judge could ever say, at the end of the state case, we're not continuing. You failed to live up to even proving man one or man two, do you? You don't think we're there? And could you explain that process in the legal system that the defense often does and asks the judge for a ruling even before the defense begins its own case?
Right. Well, we have two kinds of law systems, right? We have civil cases and we have criminal cases. Civil cases are about money and contracts and everything other than criminal law, where you're either going to jail. Those are between two different parties. And in summary judgment, which you can argue at any point in the case, can be early on or even before the case goes to trial, you can argue, even if everything the one side says is true, it's still not enough for them to win. And so that's a summary judgment action that you have in a civil lawsuit. In a criminal case, it's kind of the same thing like you just said. We call it a motion for judgment of acquittal. And we just basically are making the same thing. Judge, if everything they say is true, there's no way that a jury can convict in this case. They haven't met their burden even remotely, and therefore it shouldn't happen. That's not happening here. Judge is going to let it go to the jury.
Understood. Yeah, understood. So we'll get back into Sergeant Peterson's testimony here. We're waiting for the afternoon break to wrap up. And then, of course, we anticipate probably another Earl Grey cross-examination. Marsh, just as we kind of reassess today thus far, the state taking away some points, correct?
Yeah, this is a state's day. And despite that, the defense has scored an awful lot of hits on this. And that's because this is a hard case. And question for you. The state's had a challenge since the beginning, tried to build this into a plausible argument, based on the manslaughter 1 charge. It's a lot harder than manslaughter 2. And again, I think at the end you're going to be left with a strong feeling of Ms. Potter testifying. She'll probably be the last witness for the defense, I assume. She'll be very personable and kind and everything else. 2 ways to go with that strategy on the defense side. You can put in all of the supporting witnesses to testify about her character, and she's a great person. You do all those things and go, and then here's Ms. Potter, kind of a thing. So you do it all that way, build up to her. And the other way is you put her on early, and then everybody else comes after her. They're kind of hard to cross-examine. Here's how I know Ms. Potter. She's a great person. It's kind of hard to attack that, really. So either strategy is a common one to go with, whether she's before or after that. I generally like to put her after because she's the one person that gets to sit in the courtroom the whole time and hear everybody. So she can kind of piece everything together at the end. So I'd rather have her then. Again, assuming you think she's going to be a witness, good witness. I think she will be a good witness.
All right, I want to reset the stage here a little bit. We're coming up now in 3:21 Central Time here in Minneapolis, and Judge Regina Chu has taken a 20-minute break here in the afternoon testimony. It somewhat appeared, and we're not in the courtroom here, so we have the same view that you do of the courtroom, but it kind of would appear that maybe some of the jurors were starting to drift off a little bit, and the testimony has been pretty tedious, going over department policy and the use of tasers and use of force, going through those policies line by line and showing it up. About a half an hour ago, she asked the jury to stand up, stretch their legs a little bit without referencing what was happening. And then about 10 minutes after that, she decided, let's just take a break for 20 minutes. We're coming back upon that time right now. On the stand has been the second witness for the day. His name is Sergeant Mike Peterson. He's with the Brooklyn Park Police Department, and he's been going over line by line on that use of force and the taser policies that they have with the department. I see Judge Regina Chu is now back on the bench, so let's take you back into the courtroom.
Okay, please be seated. Mr. Frank, can you continue?
Thank you, Your Honor. Sergeant Peterson, thank you. I wanted to ask you, when you are putting together a training, when you complete a training, do you always save in the department's records every record of that training, every piece of paper used for that training?
Every piece of paper, no.
Okay. And have you, but does the department then keep track of every training that has been attended?
Yes.
Now, I want to talk about these PowerPoints and these presentations that are made at the training. And so to do that, I'm going to start with Exhibit 388. Well, actually, before we start doing that, we had discussed a little bit about the holster, correct?
Yes.
And I'm going to show you what has been received into evidence as Exhibit 380. Your Honor, may I approach the witness?
Yes, you will.
And do you recognize what that is?
I do.
And we have received testimony that that is the taser taken from Ms. Potter after this incident. Is that what you recognize it as, a Taser 7 holster? I'm sorry, did I say taser? That is the holster taken from Ms. Potter after this incident.
It looks like a holster that we would have issued, yes.
And is that the same as your holster that you currently are using?
Similar.
How is it different?
This would, as it sits on a belt, rock to the rear, rather than how I have mine, it would rock to the front.
Okay. And what I'm wondering if you can do, if your taser would fit into that holster.
Okay.
And if you could demonstrate to the jury by placing your holster, your taser in that holster, and then demonstrating how it would be taken out of the holster to use.
Do you want me to stay seated or stand up?
Probably easier to stand up, I think.
Okay.
Well, first, tell us what you're doing as you're doing it, please.
Okay. So there is a safety release button here, which merely takes a piece of plastic out from the trigger area, allowing the taser to rock straight to the rear, and then it won't go any further than that. Now I can acquire a grip and I can just pull it out.
And so once you let that switch go, how much do you have to move it to get it out of the holster?
1.5 inches.
Okay. But you can't pull it straight out, you have to move it a little. Okay. All right, thank you. All right, may I approach again? All right, now, if I could, I would offer Exhibit 388.
That exhibit will be admitted into evidence.
And I would like to show you the first page of Exhibit 388. Do you recognize what this is?
I do.
And is this the first page of a Taser training PowerPoint?
It is.
And what I've done is, this is a rather lengthy PowerPoint, correct?
Yes.
And I'm going to jump from slide to slide so that we can kind of speed this along, all right? And when you talk about a PowerPoint, I assume everybody knows this is sort of a presentation that you put up on a screen for everybody to see, correct?
Yes.
And you could also print it and provide it in paper as well?
Yes.
So this one is from 2016. This was in the records of the 2016 training records, and that's consistent with the date on the first slide here, true?
Yes.
Now I'm going to go to slide 2, and this indicates what the goal is, correct?
Yes.
And that's to reasonably safely and effectively operate the Taser, correct?
Yes.
And if we go to slide 4, here again is instruction that every participant must receive, fully read, and understand the Taser warnings, correct?
Correct.
Now, I know you mentioned earlier a release. Does every student have to sign a release?
Yes.
Okay. I thought it was only the people that subjected themselves to a voluntary exposure.
That was the warnings that I was speaking about, but on these form that we use to track that training, they're also signing a release to hold Taser liable for any injuries that occurs while they're being trained in Taser.
Got it. But this here again is another slide about the warnings being provided to the participants, correct?
Correct.
And if we can go to slide 4. Sorry, I was already there. That is slide 4. Can we go to slide 8, please? And this slide talks about disclaimers. Each agency is responsible for creating its own use of force policy, correct?
Correct.
And so this is why you go over the policy, the Brooklyn Center policy.
Yes.
And at the bottom, CEWs are serious weapons and are to be treated as such, correct?
Correct.
Is that stressed to participants?
Yes.
And a Taser is not a substitute for deadly force. What does that mean?
That if you need to use deadly force, you should probably use a instrument that would meet the needs of deadly force.
As a Taser alone would not necessarily be deadly force.
Not necessarily.
Can cause death, but not intended.
Certainly can.
And then to slide 10. A person must complete the entire curriculum, correct?
Correct.
And that's been true for all the Taser trainings you've been involved in?
As far as I'm aware.
Slide 12. Directing everybody to make sure that the safety switch is off, correct?
Yes.
And slide 13. Lasers must not be pointed at the eyes, so we know, at least as far back as 2016, the Tasers you had safety switches and lasers, correct?
Yes.
Slide 14. Here again is a now familiar screen about warnings for the Taser, correct?
Yes.
And here you are to distribute, review, and understand, at least a reminder to do that, the Taser product warnings, correct?
Correct.
Slide 15. And again, making the materials or giving them to those who attend the training, correct?
Correct.
This is also a part of all the Taser trainings that you're familiar with? All right, slide 24, please. So voluntary exposure. I think you mentioned that earlier. It's when somebody agrees to be shocked with a taser, correct?
Correct.
Have you ever volunteered for that?
I have.
How many times have you volunteered for that?
Once.
Why only once?
Didn't want to feel it again?
And so that's a voluntary exposure, correct?
Correct.
And that's not required as part of the training.
No.
When it does happen, and if we could go to slide 29, voluntary exposures require 2 spotters, is that right?
Yes.
Why is that?
To reduce the risk of injury when the person falls.
And if we can go to slide 41. This is an illustration of the Taser X26P. Is that the model you were using in 2016?
Yes.
And that's why you would have this particular PowerPoint, because that's the one you were using?
Correct.
And that also as well had a flashlight and a laser, correct?
Correct.
And slide 42, please. Indicates that model had a safety switch and a CID screen, the information display at the back also.
Yes.
Slide 44. This slide indicates similar way to operate the safety switch as the current model, correct?
Correct.
In slide 49. That's that CID screen, very similar to the one that you have on you today, correct?
Similar.
And slide 61. And this screen is about a spark or function test, correct?
Correct.
So is that a requirement for people operating a taser even back in 2016 for this, when this presentation occurred?
Not a requirement.
How do you mean?
It says should be conducted.
All right. So it was a recommendation from Taser,
Correct.
and your policy would have required it in 2016?
It mirrored it, saying it should be conducted.
Slide 87. This is instruction on using minimum force necessary to accomplish objectives, correct?
Yes.
And only those actively resisting, right?
Yes.
Also, the training here to give a verbal warning before the use, correct?
Correct.
And then the next slide, 88. Again, giving subjects an opportunity to comply before force is used. That's part of the warning, as you indicated earlier.
Yes.
Slide 89. And this is the targeting guidelines, correct?
Yes.
And the targeting guidelines in 2016, the same areas of the body as we went over previously?
I'm not sure.
Okay, fair enough. Slide 91. So the smart use considerations, can you describe what those are? What aspect of the training these refer to? My question is really more about this portion of the training that they refer to as smart use considerations. Is more tactical or practical?
Yeah, it's taking the totality of the circumstances of the situation in front of them, whether it's in a reality-based training scenario or out on the street, and making appropriate decisions.
Okay. And if we can go to slide 98. So again, to reduce cardiac risks, is there a concern about the heart when a taser is deployed?
There is.
And what is that?
There have been instances where it's been reported that the taser has caused cardiac failure in people. According to the research I've seen, it's inconclusive, but just to be sure, we want to try and keep electricity away from the heart to minimize that if possible.
And so this is part of the concept of targeting, correct?
Correct.
All right. And slide 108, please. And this is a slide about the pros and cons of which side you carry your taser in the holster,
Correct.
similar to the one we looked at previously.
Yes.
So this was presented during the 2016 class as well.
I can't say for sure.
Why not?
I don't know what version of the PowerPoint this is. If this is the user course, if this is an annual research course.
So this is from your training records, so it would be one that you had.
But we
Correct.
could have hired new officers and they could have gone through the initial course. We would have done a recertification or annual research for officers. So I can't say specifically when this was presented.
But certainly this is part of the training on which side to holster.
For this PowerPoint.
Okay. A concept that was certainly known to officers in 2016, whether it's this taser presentation or not, correct?
Yes.
Okay. And that, by that I mean weapons confusion.
Yes.
In slide 114, please. So again, this is about targeting, right?
Yes.
So that was a concept that was taught as far back as 2016, correct?
Yes.
And 116. And here again, seeing the same sort of target area, back is preferred, correct?
Yes.
When practical, practicable, I guess is the word, correct?
Correct.
And 117, if the front is targeted, it should be the lower abdomen, correct?
Correct.
And there is a reference here to split the belt line. What does that mean?
It references how the body is made up of two different nerve bundles, one that controls the upper body, one that controls the lower body. The two different hemispheres, which is kind of at the belt line, is where you can engage both of those. So even if you are at a close distance, if you can get probe spread above the belt line and below the belt line, you are more likely to have neuromuscular incapacitation.
When the probes come out of the taser, do they come out at different angles or different angles from the taser itself?
Yes.
Why is that?
To give spread between the two different probes.
So the farther you are away from the subject, the more spread you'll get?
Correct.
And so you want to be a certain distance away from the subject to get the best probe spread. Is that the proper way of saying that?
Best probe spread, among other things, yes.
Slide 119, please. And that's what's explained here, correct?
Yes.
And slide 120. This is the explanation of neuromuscular incapacitation, correct?
Yes.
And slide 131. Some causes of limited effectiveness. So this was a topic of training, at least whether this one or other trainings as far back as 2016 at least, correct?
Yes.
And loose or thick clothing could be one of the circumstances that affect effectiveness?
Yes.
Okay. Slide 150, please. Again, a recognition back in 2016 that the taser may not achieve the intended results, correct?
Correct.
And slide 155, please. So back then, the recommendation was the preferred range is 7 to 15 feet, correct?
Correct.
And is that still essentially true?
a little bit farther off with the current Taser product that we carry.
And what do you mean a little farther off?
Generally, we want to be between 10 and 12 feet.
And slide 168. Now, this indicates you can go hands-on with the subject. What does that mean?
It's recommended that we try and restrain the person that is being tased during the tasing to reduce the need to administer additional rounds or cycles of the taser or other force options becoming necessary.
And can a person who goes hands-on receive some of the electrical shock from the taser?
Yes.
How does that happen?
Electricity travels the path of least resistance.
So if you put your hands in that path,
it will go into your body.
Okay. Slide 205, please. This refers to non-firing drills. You were training back in 2016. What is this referring to, non-firing drills?
This would refer to being able to put a cartridge onto the taser, take the cartridge back off, that you can manipulate the safety, perform a spark test.
So the proficiency things you were talking about earlier?
Yes.
And then 206, please. Firing drills, would those have been done as well in this training in 2016?
Yes.
And 207, please. Refers to conclusion and written examinations. Were written examinations done throughout some of these taser trainings?
In some taser trainings, they were, yes.
Okay. And that's not done anymore, is that correct?
Not currently, no.
Okay. So at this time, I would move for the admission of Exhibit 258.
Is there an objection to 258? Yes. What is 258, Mr. Frank?
It's a lesson plan from taser training.
No objection as to admissibility. Redundancy is the objection, though.
All right. The exhibit will be admitted into evidence, and you may publish it.
All right. Do you see this then, Exhibit 258 on the stand?
Yes.
And what is that?
It is a lesson plan that was developed by one of our taser instructors.
And so is that the sort of lesson plan for the actual taser training?
Yes, it's the outline of what we would want to accomplish and do that day.
And we see in the Roman numerals there, the taser presentation. Well, let me back up a little bit. Number 2 is Department Policy and Legal Review, correct?
Yes.
And so that's the sort of classroom, part of the classroom section of it?
Yes.
And then the taser presentation, is that referring to the PowerPoint?
Yes.
And then the written test, correct?
Yes.
And deployment of taser.
Yes.
So this is a fairly standard format of the taser trainings while you've been doing them with Brooklyn Center?
Over the years, yes, the standard format.
And deployment of the taser, how is that done in those types of classes?
We have a static target that is placed at an optimal distance, either standing or in a laying down position. Depending on the instructors that we have there, we may have one instructor one run line, another instructor running a different line, and then we cycle officers through as they perform the putting a cartridge on, how to operate the safety, how to do a spark test, and then how to deploy a taser.
This time here, I would move for the admission of Exhibit 263. It's a taser training outline from 2018.
Any objection to 216?
No objection, redundancy.
All right.
The objection is overruled. 216 will be admitted.
And for the record, it's 263.
Oh, 263.
Yep.
Thank you.
Put that on the screen for us, please. Do you recognize that?
Yes.
And this is essentially an outline for the Taser refresher in 2018, correct?
Correct.
And this a sort of standard format outline for the trainings during this stretch of years?
Depending on what the topic was, yes.
Okay, what do you mean depending?
Well, they also list here chemical aerosols, intermediate weapons, so they may have also gone over some of those things at this training. I was not one of the instructors there, so I can't say for certain.
Okay. Are you familiar with the instructors listed, though?
I am.
Okay. And so this would be the annual recert on the Taser, correct?
It appears so.
And then I would offer, Your Honor, Exhibit 264.
Any objection to 264?
264 will be admitted into evidence.
And does this appear to be the Taser training PowerPoint from the 2018 presentation?
It appears that way.
Okay. And let's go to the next page, please. Up in the upper right, the expectations. Again, repeating the expectations of safely handling the Taser, correct?
Yes.
Well, I'm sorry, this is it's got to certify annually, correct?
Yes.
All right. And then in the lower right corner of that page, again, we have that warning about Tasers, correct?
Yes.
And that moment to remind you to distribute the warnings, correct?
Yes.
And if we can go to the next page, little lesson on electricity here, apparently, right?
Correct.
And then an explanation, the slide about neuromuscular incapacitation, correct?
Yes.
All right. Then let's go to the next page. Slides in the bottom, again, voluntary exposure guidelines, correct?
Yes.
And again, requiring a spotter, correct?
Yes.
All right, then let's go to the next page, and then the next page, please. Go one more. And screens at the top, the version in 2018, the X26P, correct?
Yes.
Has the same safety switch, flashlight, and laser, correct?
Yes.
And the CID screen.
Yes.
And then if you could skip to page 8 in the bottom corner. The same slide here about the spark or function test, correct?
Yes.
And then if you could skip to page 14, please. Here are those same smart use considerations about the amount of force to use, correct?
Yes.
And then if you would go to page 17, please. Here we have the holster pros and cons screen again, correct?
Yep.
So another topic are taught again, as well as probe placement and targeting, correct?
Yes.
And then let's go to the next page, please. In the lower right corner, again, deployment distance considerations, correct?
Yes.
In the 0 to 7 feet one, correct?
Yes.
If we can go to page 20, please. And again, instruction on limited effectiveness, correct?
Yes.
if you can go to page 21, please. Again, contingencies may not achieve the intended results, correct?
Correct.
But also, again, the warning about people operating vehicles or machineries in the lower left. Correct?
Yes.
And then if we go to towards the very end, there is a written test there as well, correct? Yeah, right? And that would be at least gone over in class, correct?
Depending on the year, correct.
Okay. So that's how it was taught in 2018, correct?
Can I ask how what was taught?
I'm sorry. I didn't hear you.
How what was taught?
All those subjects were taught again, the Taser training in 2018.
According to that presentation, whoever received that presentation, that's what they learned, yes.
And Your Honor, I would offer Exhibit 243.
Any objection to 243? 243 will be admitted.
And if you could pull that up, please. Do you recognize what this is?
I do.
And is this a Taser PowerPoint for essentially 2020?
Yes.
Okay. And at the risk of dragging everybody through a whole nother PowerPoint, would you agree that this contains a lot of the same subject matter as the 2018 PowerPoint?
For the most part, this appears as though it's a user update, which may have cut out some of the basic information about electricity and the background function of how a Taser works.
And so, well, let me just do this. If you can go to page 9713, be the next page. Again, to provide the warnings, targeting, smart use considerations, correct?
Correct.
And 9714, please. Again, review the PowerPoint, the product warnings, pass the test, deploy cartridges, correct?
Pass a functional test, yes.
Okay. And page 9715, please. And again, here, stop in the middle. At least this is telling you stop and make sure that these have been distributed for individual students, correct?
Correct.
So if we can go to 9718, please. Again, targeting, right? Don't avoid the head, throat, breast, chest area of the heart, correct?
Don't intentionally target those areas, correct.
And 9719. Again, the back is preferred, correct?
Correct.
And below the neck?
Yes.
And can you go to page 9732 as well? So this is referred to as a smart use study aid, correct?
Correct.
And so this would be provided to students as well through the PowerPoint?
Either through the PowerPoint, electronically, or in physical form.
Now, and this was the 2020 version, correct?
That looked like it was version 22, I believe.
Okay. From 2020.
I think that was the date on the front of it.
Right.
The version number doesn't always correspond with the year.
Correct. So 2020, we all know, was the COVID year. Did that affect how you did the Taser update training that year?
Slightly, yes.
How so?
We had to go to a venue where we tried to conduct as much of the training outside as possible to limit inside time. We did not use electronic means, therefore we printed everything off on paper.
And gave that to each student?
Correct.
Now, after 2020, did the department change to a different Taser?
We did.
And it changed, I assume, to the Taser 7, correct?
Correct.
And so was there a requirement, first of all, that people who are, the officers who are carrying a Taser be certified or recertified in 2020?
They were recertified in 2020.
On the previous model?
Correct.
And then also be trained or certified on the new model, the Taser 7?
Yes.
And how is that done with them?
Taser creates a transition training, a PowerPoint test, some drills that we have to do to familiarize the officer, the end user, with how the Taser 7 differs from whatever product they were on before that.
So it's an introduction to the new device?
Correct.
And at this time, I would offer Exhibit 244.
244 will be admitted.
Did this, and do you recognize this as that PowerPoint from the transition course?
Yes.
And did it go through sort of the new parts of the Taser 7 that we talked about earlier, the lasers, the safety switch wasn't new, of course, but...
Yeah, I went over the differences between the Taser 7 and the product that we were on prior to that.
And at the end of it, it talks about drills and practical exercises. Do you recall that?
I believe so.
Yeah. Did you do that for that
Yes,
transition course?
I did.
And did you, in fact, teach that transition course?
I did.
And can you explain for the jurors how you did that, the drills and practical exercises?
So after we spent several hours in a classroom setting, the users had a Taser 7 in their hands. They were able to learn how it's different from the X26P that we were on. Once I was confident that they had a good understanding of how it worked, I went into a different area of our police department. I had set up a training scenario. Each officer came in one by one. I had a safety officer that was there running the scenarios, but I had created the scenarios. I was the subject that they were going to be working against, or I was the subject that they were going to have to use some type of force against. I had two different scenarios for each officer. When they were done with their scenario, we asked them to not discuss it with any other officers, to just try and give the other officers the best opportunity for training. And we went through the two scenarios.
And as part of those scenarios, were they required to draw their tasers and deploy them?
Yes.
And how did they deploy them without hurting somebody or getting another voluntary exposure?
So one of the features of a Taser 7 that we did not have on our previous platform is they have a training probe that is basically some Velcro that comes out, and it's connected to monofilament line that still runs back to the Taser. So no electrical current ever flows down to the subject that has those two little Velcro probes that connect onto them, but they still get the feel and the sound of what a Taser 7 would sound like if deployed.
And, okay, you can take that down. I'd like to show you Exhibit 246, please. Do you recognize what that is?
I do.
And do you see a signature down there towards the bottom?
I do.
And whose signature is that?
Mine.
And there, above your signature are some check marks. Did you place those there?
I did.
And what is the purpose of those check marks?
To show the officer was able to show their proficiency and competence in using the Taser 7.
And that was done through the classroom instruction as well as the scenarios, the drills?
Correct.
All right. And that is why you place your signature there, correct?
Yes.
And the student's signature above that is Ms. Potter, correct?
It appears so, yes.
And this was done on March 2nd of 2021?
Yes.
All right, I want to switch gears a little bit and talk to you about non-specific Taser, training not specific to Taser, just regular use of force training, the rest of the training. All right. Your Honor, I would offer Exhibit 364 at this time.
Any objection to 364? 364 will be admitted into evidence.
And do you recognize this document?
Yes.
And explain, if you will, where this document comes from.
This document is prepared by the Minnesota Post Board, who oversees and tracks training that officers must get every year or through continuing education credits over their career.
And are there certain topics that are required as part of, or required by post for officer training?
So this document is specific to in-service, meaning officers who are currently licensed and on the street for use of force learning objectives, and there are many components of this document.
I'm glad you mentioned that because we see the term in-service quite a lot. What does that mean in regards to training?
There's a couple different definitions, but it generally means that an officer has passed their field training and are certified for solo patrol and are licensed peace officer authorized to make arrests in the state of Minnesota.
So in-service training, to distinguish it from like new officer training.
Pre-service training is what we would call that.
All right. And the topics listed on Exhibit 364 are those specific topics required by post, correct?
Yes.
And this document is dated February of 2012. Is that right?
It appears so, yes.
Yeah. And so this is something Post has been putting out for quite a while.
Quite a long time.
Okay. And we see that, A is use of force, right? And so what is generally, topic A, use of force, about?
It's pretty general, talking about the statutes that are in Minnesota that define what and when we can use force as police officers, but also the public. Other statutes, 69.3.2 and 3.3 about warrants and using the minimum amount of force necessary. And then the tactics that are listed there: verbal skills, empty hand techniques, intermediate weapons, deadly force, and how to use totality of the circumstances to make appropriate decisions.
So this is a lot of, classroom stuff, right?
It is, and a lot of this stuff is covered in other aspects of this document as well.
Okay. I'd like to go on to the next page then. And topic B, another topic required by post, correct?
Yes.
And what is B?
So it's giving the officers information that they may need or have before, during, and after a critical incident or use of force incident.
So this is referred to as readiness aspects of force, correct?
Yes.
And under the performance objectives, the number one there is how extremely stressful situations affect physical and mental functioning, correct?
Yes.
So has this been a topic of use of force training as long as you have been a trainer?
Yes.
And is this a required part of training every year?
Annually.
And how does the department, or how has it tried to fulfill that requirement?
Over the years, we try and educate the instructors on it by doing research. There's no hard and fast rule about how any of these things will affect any specific officer, but they're general guidelines that have been reported from other officers who have been in stressful situations, and things to note of officers as they prepare for a stressful situation or the aftermath of.
And so is this a way to try and teach them to think and act in real life situations?
It's a way to prepare them to not know how they're going to react in that situation, to prepare as best as they can for it.
And is this done through the scenario-based training with your department?
Partly, but partly through lecture as well.
And if we scroll down to letter D, proficiency with intermediate force weapons, would this cover Taser training?
Yes.
That's considered an intermediate force weapon?
Yes.
And so is this required as part of annual training?
Yes.
And letter E, principles of firearm use, that's something taught every year?
Yes.
And that's both classroom and practical?
Mostly range time.
So if we talk about qualifying for the firearm, what does that mean to you as a police officer and a trainer?
Showing proficiency with the firearm that they're assigned, or a patrol rifle.
Can you just describe for the jurors generally how that's done?
We're on a range, static target. We have a course of fire, and the post board says what certain percentages of our rounds have to be at different ranges, and we have them shoot that range, and they have to have a certain qualification score.
And how often is that done then?
Annually.
You were talking earlier about the scenario-based training, officers having all their weapons. Is that an attempt to incorporate all of these topics into training?
Yes.
And I'm going to move for the admission of exhibits 316 and 317.
Any objection? Okay.
No objection.
316 and 317 will be admitted into evidence.
I'm going to kind of show them in reverse order with 317 first. And do you recognize what this form is?
Yes.
And what is it?
This is an affidavit of attendance for a training session that anybody in the state of Minnesota can use for a course that has been approved by the Minnesota Peace Officer Standards and Training Board.
Okay. And if we scroll down to the second page, do you see a spot here for Officer Potter's signature?
I do.
And down on 31 there, correct?
Yes.
And what date did she attend that?
It says November 15th, 2016.
And does it indicate how long?
The class that day was approved for 8 hours or 8 credits.
All right. And if we can scroll back up, I'm sorry. What is the sort of the title attached to this training?
This one looks like it is a 2016 Brooklyn Center PD in-service.
And so in-service could cover a number of topics?
Yes.
All right. And so if we can go then to Exhibit 316. And do you see this explained there as well? Well, let me ask you this. Is this the outline from the November 15th in-service?
Yes.
And so we see that in the afternoon, there was a couple of hours on use of force policies and statutes?
Yes.
Taught by you?
Yes.
Okay. And so that's kind of how in-services are done, various topics, including sometimes use of force.
Yes.
And I want to go to offer Exhibit 325.
No objection.
That exhibit will be admitted into evidence.
I want to ask you if you recognize this. Well, no, that's the wrong number. I'm sorry. I'm sorry, all right. Let's take that one down. Exhibit 271.
Any objection?
And 272, we might as well do that.
No objection.
271 and 272 will be admitted.
And let's start with 271. So this is the outline, I guess, if you will, of the November 15th, 2016 in-service, correct?
This looks like a lesson plan, correct?
And this will cover de-escalation, correct?
Yes.
As well as the use of force policies and Taser, correct?
Correct.
So this is sort of a typical layout of classes, various topics, including here, Taser.
They vary from year to year.
And 272, please. From that same training, discussing the readiness aspects of use of force in 2016, correct?
Yes.
All right, then would offer Exhibit 318 and 321.
Any objection? To 318 and 321.
No, Your Honor.
Those will be admitted.
All right, let's look at 321, please. Here again, a sign-in sheet, correct?
Yes.
And if we can scroll down, you see Officer Potter had signed in for this as well
Yes.
on 9/5 of 17.
Yes.
All right, if we can scroll back up, this is for what kind of class?
It says it's a fall 2017 use of force.
And then if we can go to Exhibit 318. And so this is the fall use of force in service. The objectives: learning objective A is the use of force. Objective B is the readiness aspects, correct?
Yes.
And objective D, the Taser. This was all taught in that class, for instance.
The classroom portions of Taser probably would not have been taught in this.
Okay. What would have been taught with reference to the Taser?
So that would have been the scenario part of it.
Okay.
Same with chemical, intermediate weapons. So in here you can see under timeline there's 5 hours spent on scenarios. So we still cover parts of other learning objectives, but we may not go through the classroom portion of it.
So in this situation, then, of this day, 5 hours was spent doing those scenarios.
Yes.
And, Your Honor, I would move for the admission of Exhibit 323.
323 will be admitted.
And do you recognize that?
Yes.
So this is a 2018 use of force, correct?
Yes.
And I think we need to scroll down to see Officer Potter's signature there, correct?
Yes.
And the 326 18.
Yes.
All right. And then I would offer, Your Honor, Exhibit 265.
Objections to 265?
Just a second. No, Your Honor.
265 will be admitted.
And is this the outline for that same class that Officer Potter had signed into we just looked at?
It appears so, yes.
And indicating that this use of force would include scenario-based training as well?
Not this one. It does not appear so, no.
Why not? I'm sorry.
This looks like it's just arrest and control or defensive tactics, as some call it. 2 hours is pretty tight to cover that category and have scenarios built into it.
Okay. And exhibit, if I could, Your Honor, offer 266.
Any discussion of 266?
No, Your Honor.
That'll be admitted.
And this for the use of force in service later that year, correct?
Yes.
And would this include scenario-based training as well?
Yes.
All right. And so this was done in 2018 as well?
Yes.
To move sort of quickly along, in exhibits 327 and 330, Your Honor.
Any objection to those exhibits?
No, Your Honor.
They'll be admitted.
And if we could put up exhibit 330. And this is a sign-in for the low light and clement weather training, correct?
Correct.
And if we scroll down, Officer Potter signed in to that on 10/26.
It appears so, yes.
And if we can go to 327. Again, an instructional block here, correct?
Yes.
But scenario-based training would have been done at some point with this?
Yes.
And, Your Honor, if I could offer exhibit 259.
Any objections to 259?
No, Your Honor.
259 will be admitted.
I'll put that up. So here again is the October 2020 in-service, is that correct?
Yes.
And that includes, A, the use of force, correct?
Yes.
And if we can scroll, well, and we don't have to, at the bottom, B, the readiness aspects of force,
Yes.
taught in the fall of 2020.
Yes.
So kind of I've tried to just get a flavor of how those years have gone, where you'll have a couple of trainings each year for use of force, the aspects that post requires.
Yes.
And would each of those include scenario-based training or not always?
As much as possible, we try and include it, but it's limited by time we're given, resources we have. But as much as possible, I try and incorporate them.
And I'm going to show you now what has previously been admitted as Exhibit 335. Do you recognize what that is?
I know the format.
Okay. A record of
Training.
Training. You'll see over in the name of training, column, do you know who enters that information?
What column?
The name of training column?
That would mostly come from any affidavit of attendance that was filled out for a approved class, or an external training that the officer attended, which was not in our control.
And so this is just a real brief description of what the actual class was.
Correct.
Your Honor, can I just have a moment, please?
Yes.
Just one final question. Sergeant Peterson, in all the years that you've been working at the Brooklyn Center Police Department, have you been aware of any other officers who have drawn their handgun when they meant to draw their taser?
I don't.
And in the scenario-based training, has that ever happened?
It's not a topic that I frequently think about. I would have to take a considerable amount of time to think about that.
Yeah, I guess I'm just asking if somebody has ever said to you, that's not what I meant to do.
I have conducted so many trainings, run so many trainings that they honestly all blur together. I couldn't pick out a specific time.
I have nothing further for the witness here.
Yes. All right, members of the jury, we're going to stop for the day, and we're going to start up again at 9 o'clock. Have a wonderful evening. Okay, officer, you may step down.
This is the live battery that we have.
All right, counsel, see you tomorrow.
Because let's not put it in.
All right, everyone, welcome back. Day 5 has finally wrapped up here in court in Hennepin County in the trial against Kim Potter for the shooting death of Daunte Wright in that traffic stop from last April 11th, where she accidentally pulled her gun instead of a taser. Her defense has always maintained that this was purely an accident. She has pled not guilty. The state is trying to prove her guilty of first and second degree manslaughter in this case. Coming up tomorrow, we anticipate that maybe there will be cross-examination of this particular witness, but we will see. It's been kind of an interesting day here in court so far. You just heard on the stand here for about the last hour. This is Sergeant Mike Peterson of the Brooklyn Center Police Department. I may have misidentified him before from being from another police department, but he is from Brooklyn Center Police Department, testifying about the use of force policies here and how Kim Potter had undergone those use of force training sessions and had performed them. Interesting question here at the end here from Matthew Frank on behalf of the state when he asked, was there ever a scenario-based training of drawing a gun instead of a taser? Has it ever come up? And Sergeant Peterson said no, he didn't believe it ever has. So here we go. We're going to wrap up the day. The court's going to be back in session again tomorrow morning at 9 o'clock. My colleague Paul Bloom and I will be here just before to kick it all off. And in the meantime, oh, by the way, that should be 9 o'clock Central Time, because we know a lot of you are joining in on this particular webcast from across the country. We'll have it on fox9.com and on our YouTube channel too. Paul will have a wrap-up of the day's proceedings in court coming up on Fox 9 News at 5 o'clock and throughout our newscast tonight. And for those of you who may be at work and in traffic on the way home, my colleague B.C. O'Neill and I will bring you the news here at 6:30 tonight and at 7 o'clock, a pretty convenient time for a lot of you over on Fox 9 Plus. On behalf of everyone here at Fox 9, my name is Tim Blotz, and we will see you tomorrow morning here for the latest court proceedings. Have a good night.